Lost my live stream, so just let it run.
I'm going to use the ladies' room once more. I'll be right back.
Well, good morning, everybody. People in here still. Just want to check your screen name, see if I properly with your party. Have to admit the challenging with Milwaukee, people putting in Milwaukee, because I had to figure out if you're which Milwaukee. But I think I got people settled pretty well. And we're already live streaming, so if people were trying to watch that, they already can. And just setting up a few more names. Hopefully we can get started in a bit.
So, Your Honor, I just wanted to. It sounded like in the preliminaries there was some reverb. I don't know if that's us.
Okay.
Or to you.
Well, I don't hear it on your end.
Okay.
I don't know what that means, but nothing on my
maybe it's not
setup.
an issue then.
Yeah, nothing on my setup's changed. So so I'm going to put in I can. So I'll have to say for WEPCO, if we can use the whichever screen you have that's got a microphone, that's going to be the primary microphone. we'll just need to have those witnesses take that seat so that for the live stream, we can then see the witness. I think it's probably better for this is just the way that YouTube works. It only displays the speaker at a time. So the microphone's going to pick you up. If you're not the person talking, the microphone's going to display that person's face anyway. So whoever's laptop with the live mic, should be the witness if there's a witness present. So you could just switch microphones or switch seats either way.
Yeah, we'll probably just switch seats.
Mhm.
I think it'll be a little bit more difficult to switch the mic.
Yeah, I don't play around with that. I understand
Right.
completely.
But yeah, understood. We'll do our best if you don't mind reminding us if we forget.
Oh, don't worry. I'll do my best to remind you.
Thank you, Your Honor.
All right. Just everyone's here.
Morning, Your Honor. This is Corey Singletary with Cub. I just checked with attorney Coburn Ferris. She had indicated she's in the waiting room. I just wanted to know if there was a problem. If there is, we can have her try to reconnect.
No, I don't. I'm still checking people in.
Okay.
So yeah, just have her just sit tight for a second. Once I let them in, it's harder to do this. There's a few people I don't recognize in the waiting room. Henry Pitch. I'm not recognizing that was is that a witness? Pitsch. And then someone just logged in as Alex. I don't know, that probably, oh, maybe it's Alex Lindquist. Or it's Andrew Lindquist. It's not Alex Lindquist. I don't know what it is.
Tetlock, Your Honor?
Yeah, I'm not, we'll let him in and see.
That could be Alex Tetzloff from IUOE, Your Honor.
Okay, yeah. Right. For now, what is that? It's like Tetris. All right, we have everyone in, not everyone in, yeah, everyone from the waiting room should be joining us. Just wanted to verify a couple names I couldn't recognize. Alex, are you there?
Yes, I am.
Okay, not seeing you. Can I just get your identity? I don't see you on the screen, so.
Trying.
Is it Alex Tetzloff?
Yes, sir.
Okay.
Yes, Your Honor.
You're there. Okay. I think there was one more person I didn't recognize. Henry pitched, Pitschch. Just let me know if you're affiliated with a party. Maybe your commission staff nowadays. It's okay.
I've had so far with this complaint.
Yeah, I hear you. Can you just let me know who you
I
are?
apologize for the issues that you've had, but yeah. No.
Hello, can anyone hear me?
Yes, there you are, Henry.
You can hear me?
Yeah, who is this?
My name is Henry Pitch. I'm with Senator Robert Worch's office.
Well, that's what and that's
Okay,
kind of what
I
I was.
see.
I didn't say-
So I mean, asking of that people generally speaking take you observe the hearing on YouTube. People who are not parties to the case.
Yeah.
Do you have that
Okay,
link?
so this is live. This is streamed on YouTube.
Yes, it's streamed on YouTube. I can, if you see the screen share, I can give you the link right.
Okay, yeah, that would be fantastic.
Yeah, so if you can't click it from here, but I can, or if you can do the QR code, can you see that?
Okay, awesome. Yep, I'll join there. Thank you.
All right, great, thanks. I think that's, oh, Roger. Who's Roger?
Your Honor, Roger Colton with Walnut Way. I
Oh,
apologize for not putting a last name on my ID.
Okay, yeah, well, just next time is a charm, so I appreciate it if you could. Okay. There, we got everybody. Excellent, thanks very much. Let's get started. All right. Well, welcome everyone. Where's our court reporter? There you are. All good. All right. Welcome everyone. This is docket 5UR111, joint application of Wisconsin Electric Power Company and Wisconsin Gas LLC for authority to adjust electric, natural gas, and steam rates. This is Michael Newmark, the administrative law judge for the PSC. This is the party hearing session, and we're connected through Zoom with parties and commission staff in attendance. We are live streaming this Zoom hearing, and recording of the live stream will be available on our YouTube channel, the PSC Hearings YouTube channel. It'll be the unofficial recording of the hearing. Official recording will be in the transcript that we finalize and will be posted on the commission's website. We're also today we're taking comments and evidence really, and allowing for cross-examination of witnesses from commission staff and the parties. We're also taking public comments in this case. We'll be doing so on two dates, Tuesday, October 1st at 2 p.m. and 6 p.m. at the Cesar Chavez Community Center Gym in Racine, Wisconsin, and also on Thursday, October 3rd at 1 p.m. and 6 p.m. at the Drury Plaza Hotel, Great Lakes Ballroom in Milwaukee. In addition to those public sessions, we are accepting written comments from the public. Comments are due no later than October 7th. They can be filed through the commission's website or mailed to us. So comments we receive by that deadline will be considered, and I'll be reviewing them and we'll receive them into the record. So public can observe this session through YouTube. The hearings will also be, you can also connect to the hearings through our YouTube channel in order to, you can also connect to the hearings through Zoom in order to participate, or you can observe those hearings on our YouTube channel as well. So just wanted to point out that parties are not to participate in the public comment process except for as detailed in the facilitating matters order, and the public is the regulation for public participation is detailed in our notice of hearing. So that's our notice. Let's move on then to appearances. bring up our list. So let's start off with Citizens Utility Board.
Good morning, Your Honor. Kara Coburn Ferris with the Wisconsin Citizens Utility Board. And I have with me Cub witnesses Tom Content, Dr. Steve Keim, and Corey Singletary.
Okay, City of Milwaukee.
Good morning, Your Honor. This is Assistant City Attorney Tom Miller. And I have with me city witness Eric Schambarger, and Marina Dmitrievich will be joining. She is currently in a common council meeting.
Okay, thanks. IBEW Local 2150. No, we don't have James Meyer here. I thought I saw. Oh, that was the Steelworkers Union. Okay. How about IUOE Local 420?
Good morning, Your Honor. This is Alex Tetzloff.
All right, thanks. I don't know if you can get your, I might not have enough room on my screen. If you can get your camera on when we call you, that will be, oh, there you are. I see you. My screen's just not working right. Okay, so we have Alex, Microsoft.
Good morning, Delaney Brewer on behalf of Microsoft, and I'm joined by Robert Stevens, our witness.
Great, thanks. Milwaukee Metropolitan Sewerage District.
Good morning, Your Honor. Emily Vandre, appearing on behalf of Milwaukee Metropolitan Sewerage District, and I have with me our witnesses Kevin Schaefer, James Bride, and Jamie Toskis.
Okay. Public Service Commission.
Good morning, Your Honor. Evan Whites on behalf of the Public Service Commission of Wisconsin. I won't name all of the commission staff witnesses at this time, but they're also here.
All right, thanks. Going down the list, Renew Wisconsin.
Corey Walsvik on behalf of Renew Wisconsin, and I also have Andrew Kell and Ben Belke here. Thank you.
Roundies.
Good morning, Your Honor. Kurt Boehm appearing for Roundies.
Sierra Club.
Good morning, Your Honor. This is Megan Moxpress on behalf of Sierra Club.
Okay. United Steelworkers, Local 2006.
Morning, Your Honor. Joseph Klubertons on behalf of the Steelworkers, Local 2006.
Great, thanks. Vote Solar.
Morning, David Bender on behalf of Volt Solar, and Will Kenworthy will be joining a bit later in the hearing.
Okay, Walmart.
Good morning, Your Honor. Stephen Lee appearing on behalf of Walmart, and with me today is Eric Austin.
Okay, Walnut Way.
Your Honor, Krista Westerberg and Eduardo Castro appearing on behalf of Walnut Way, and witnesses Roger Colton and Antonio Butts are also here.
Great. And Weeg.
Good morning, Your Honor. Steve Heinzen on behalf of the Wisconsin Industrial Energy Group.
Wisconsin Electric Power Company.
Good morning, Your Honor. Attorney Patrick Proctor Brown on behalf of applicants Wisconsin Electric Power Company and Wisconsin Gas LLC. Also present with me are attorneys Jackson, Wilson, Zank, and O'Connell, and Attorney Phillips.
We have everybody there. Okay.
Oh, and I'm sorry, Attorney Goldschmidt is also here.
Oh, okay. We don't have an appearance from Attorney Goldschmidt in writing, so we'll have to add that in. Okay, yeah, I don't know what happened with the alphabetizing here. I thought there was something wrong. Am I missing? I don't think of a different case. Okay, so we got everybody. All right. So any corrections, or we have Goldschmidt? We'll need to. Oh, there he is. Huh, I hadn't seen that before. Okay, we got him. So we have everyone we need on the list. That looks good. Okay, great. So let's get, so I know that, so if someone can contact witness Meyer, there may have been some confusion on his part about his need to participate here. If we can get him in before the end of the day, I suppose we can verify his testimony and let that testimony in on the record. But just so you know, we do have a part of the facilitating matters order, and in the email that I sent out yesterday reminded everyone that failure to appear will cause me to not receive your testimony. So you need to either be here or be available for questions. And certainly if you're the sole witness, sole person representing a party, to be here and verify your testimony is important. People might not have crossed for this witness according to the emails yesterday that were sent by parties and staff, but that's not a waiver of questions. I might have a question, or a commissioner may appear with a question. So in order to make sure we have everyone here when we need them, until you're excused, you need to appear. And well, you don't have to be there the whole time, but until I excuse you and we have your documents verified, we won't be able to accept that testimony. So, but I'll allow it if you can show up before we end today. I can allow it in. Okay, so that was our notice, our service list. So I know we have a few people who have some time constraints. We do have a number of preliminary issues to deal with. Well, off the record, why don't we just deal with people who have no cross at this time and who are available to either verify their testimony. Well, people who are here for cross, in case there is any, then we can see if we can excuse them before we begin our preliminary activities here. So we did get the list of people here, so we can go off the record. We have a list of people who don't have, that may not be questioned. I think in terms of applicant witnesses, we do have the sur rebuttal, so we need to keep them in here for that. Some other preliminary matters, let's just keep them available. But we did have some time constraints for some of the witnesses. Just display what I have here. So who was? So I believe, for example, that Tetzloff was only available early in the morning. Is that correct?
That's correct, Your Honor.
Okay. Okay, we have MMSD is AM or PM. Roundies AM or PM. Kenworthy's not here yet. Okay. So let's just go down the list first and see if there's any objections to receiving testimony by affidavit. Is Keim going to be adding testimony?
He will stay and verify at the hearing. I also wanted to mention, Judge Newmark, that witness Singletary he unfortunately has to leave at 5 p.m. And so he's available until then, but given what happened on Friday with the pub serve hearing, I'm guessing we could go beyond that time.
Right. Okay. Well, we'll see how late this goes. Yeah. So were there questions for Stevens? I think we did. We might have a question or two, actually. I might have a question.
Your Honor, on behalf of Microsoft, we did request that Stevens be heard before 2 today, if possible.
Well, I think the only one that needed to go early was Tetzloff that I knew of. And then we had Andrew.
Commission staff witness Lindquist would like to appear between 11:30 and 12:30 if possible. That's the window he's available.
All right. Well, let's verify the Tetzloff testimony, and then at least we can get him off the list. I don't think he needs to be. Okay. So witness Tetzloff, are you there? I see you there.
I am, Your Honor.
All right, let's just swear you in and let's verify your testimony. So raise your right hand.
Sure. Back on.
Yeah, back on. Yep. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right. So I see you filed. So just state your name and your position, please.
Alexander Tetzloff, business manager, local 420, operate engineers.
All right. I see you filed direct testimony and surrebuttal testimony. Is that correct?
That's correct, Your Honor.
And you refiled those already, I think, to correct the comments that I had provided.
That is correct, Your Honor.
Okay. So are those documents complete and correct to the best of your knowledge?
Yes, Your Honor.
Okay. So I just wanted to note, you don't need to refile this now. You could wait till after the hearing. It's probably better off in case we have other changes that come up. And this way you're not sort of trying to get this in before the hearing when it's crunch time. So you do have 3 working days to file after the hearing, these corrections. So it's just better to get these things when we're expecting them to come in. And we understand that when I have a comment, it's just, you can just make those corrections based on those comments after the hearing. So I appreciate you doing it, but you don't need to rush before the hearing. It's better off just to wait.
I understand.
All right.
Yep.
And it looked like you filed those correctly, so I appreciate that. All right. Does anyone have any questions? No? All right. Thanks very much. You're excused.
Thank you, sir.
How about the United States Steelworkers? Did we have any? Do we have that witness here? Ah, yes. Kumarantz. There's no cross for that witness, right? Okay, I'm going to swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right. So state your name and your position, please.
Joseph J. Klubertans, President, United Steelworkers Local 2006.
All right, great. So did you file direct testimony and surrebuttal?
Yes.
Are those documents complete and correct to the best of your knowledge?
Yes.
Okay, so I did have some corrections for you. So if you could refile these documents according to the notes that I provided. Do you have any questions about those?
No, I don't.
Okay. All right, thanks. All right, so any questions for this witness? No. All right, so that's 3 working days after the hearing. That's when it's due.
Thank you.
Thanks a lot. All right, you're excused. Take care.
Thanks.
All right. All right, so let's get into some of the comments. So let me ask just for the other witnesses here, other parties, is our offered evidence list, it's a mess. So I don't know if it makes sense to even ask at this point if there's problems with the list. We'll just have to pay attention as we question the witnesses, make sure we have the correct witnesses, correct filings one at a time. I think in this case may be more useful because things come up anyway at the end. So in terms of the comments, I think we're just going to go over my other comments first and see if we cover questions people might have. First of all, First of all, just I just noticed how some of the documents were filed. The IRF document descriptions, we already addressed that with the unions, but there's I guess we had an exhibit that was filed as testimony. And then I think in terms of roundies, we had another instance where you really should be waiting to after the hearing to refile to correct your testimony. So offering confidential documents are already filed on IRF. That was an issue I saw. We need to make sure we get the public version and the confidential version filed as exhibits. This is in another docket. So that may be tricky if you don't have access to the confidential version, but if you have access to it, then you'll need to file that pair of documents. Any questions about that? So I did see that people were citing varied on the witness, but they're either, if a confidential document was being discussed by a witness, they're either citing the confidential document specifically or the public document specifically by using the C or the P. I guess it may not be that important to designate C or P, just to use just the straight citation. I don't know if there's a reason why, if someone was only relying on the public version, maybe it makes sense to cite only to the public version. Did anyone have a rationale for what they were doing there? If you want to just explain that, I just would like to know. No rationale. Okay, so then I would say you don't need to use C or P, just use the straight citation, kind of includes both, I guess. I don't know. Okay, so timing of refilings, we discussed that a little bit. Just instead of trying to catch up with my comments, that does not need to be put into an errata. And it does not, you don't need to file those corrections before the hearing. Thought I made that clear on the emails I was sending, but I don't, it's just, that would be very burdensome. I hope people don't think that's what I'm expecting, because I don't think it's fair to have you guys try to catch up with that while we're trying to do other work. So, so you have 3 working days to correct any problems that have been addressed either through my comments or through the errata, something that comes up in the hearing. That's why it's done after the hearing, so you can just do it once. If for my corrections, you don't need to file an errata for that. I've already noticed everyone through my comments. So this one, you can see there, you're putting in the comments that I was noticing. I think they are. Maybe these are additional ones. I didn't double check that, to be honest with you, but and maybe that's the problem. But so just so you know, if you don't need to file an errata for the comments that I've
thank you, Your Honor.
Yeah.
On that errata, my understanding is it was partially to make some corrections that we had identified based on your comments, but the primary purpose of it, and the reason we filed it, was to respond to your comments related to the commissioner quotations.
Well, no, actually,
we misunderstood. But
that's a different one. So this is the first one you filed. That's why I picked this one up. First one you filed just had these. I think they're just the comment corrections. So you don't need to do that. That's over. It's just too burdensome. I wouldn't expect that. So
okay, understood.
Yeah,
Thank you.
yeah. So if it's just for that, yeah, don't file that. And and like you didn't file revised testimony. So other parties did, but you don't need to go over that.
Yeah,
Again.
understood.
Yeah. Okay.
Thanks.
All right. So this one, just want to make sure we're on the record for this. So yeah, we do have the commissioner quotations issue here. And so what I intended to do was just simply reiterate my ruling in the pub service docket on Friday regarding commissioner quotations. And then by implementing that would be to have the rebuttal for Singletary stricken And then I did note that there's a commissioner quote in the Magna rebuttal in this case. I was also planning on doing the same to that. So just in general, I don't have that in front of me here, but just to reiterate my ruling on Friday, I think that commissioner quotations are troublesome and cause problems in order to rely on as substantial evidence. And I think they lack probative value because of the failure, the inability to verify them, and for due process problems, especially because the speaker is not subject to cross-examination and has not been vetted in terms of credentials vis-a-vis the statement being made. So that's the basic ruling. I think I covered the grounds there, but essentially I'm reiterating my ruling in the pub service case. And then in the same vein, asking for the same result, which is we'll strike the rebuttal from Singletary. But we also have a new issue, which is a commissioner statement by witness Magna involving rebuttal. We also see that in the course of the filings, the applicants have asked in errata to add an exhibit, and that the exhibit is a. Yeah, am I getting that right? Yeah.
I'm sorry, I didn't hear the end of what you said, Judge, and that the exhibit is.
The exhibit is Magna 1, which is purported to be a transcript of the open meeting discussion for the day that this passage is being was rendered. So I can hear some comments on that, but I mean, this has to overcome my overall ruling, but also there's some issues with timing and the process here that we can get into necessary. So let's hear from the applicants first, and then I'll take comments from others. So let me, first of all, I'm going to ask, before we get into that, let's just have Cub respond if they wish to respond to the first part of that regarding Singletary's testimony.
Thank you, Your Honor. We understand your ruling, and we still believe that the statement that we quoted gives more information to what is provided in the order, and similar to how Wisconsin Supreme Court cases have quoted open meeting comments. We believe that this is useful information to include, and we provided context and in good faith, did that with candor. And in addition, we'd be happy to provide the full transcript of the open meeting. That said, we understand your ruling.
Okay. Anyone else want to comment on the Singletary testimony?
Yeah, I just would reiterate my comment from Friday that our position is that Cub is offering the quotations to prove the matter asserted, which is related to the payroll discrepancies. And that is a distinction between what I think we'll discuss next, which is what Mr. Magna is offering the quotation for in his testimony. Okay. So that's all I would say on your ruling, and we understand the context of it.
Okay, anybody else? No? All right. Yeah, and I just want to respond to Attorney Coburn Ferris. I don't doubt the candor of Cub in this situation. I guess I'm just, I think more to the point, which I haven't expressed yet on this record, is I feel like there is more of a rationale for quoting a commissioner if there is a specific point of an order that is disputed or ambiguous and needs to be clarified. Essentially, I guess, well, we'll leave it at that. So I don't see that being the case in the order with respect to staffing issue that was raised in this in the context of the Singletary testimony. But okay, so that's in addition to the other reasons. But yeah, that's in terms of the specific context. So so let's move on to the Megna testimony. Any response or initial comment from the applicants?
Your Honor, could I ask one quick question before we move on to the
sure.
Magna testimony?
Mm-hmm.
Just a point of clarification on, I understand Your Honor's ruling as it relates to the Cub quotation.
Mm-hmm.
Commission staff witness Malley did respond to that in Sir rebuttal. I know in the pub service case, we struck a couple lines from that Sir rebuttal testimony to align with your decision. I just wanted to ask if that was the expectation here as well.
Yeah, I think it was, correct me if I'm wrong here, I think it was the Probst testimony in Wisconsin Public Service, and it would be the Malley testimony in this case.
It's page 3 of Sir rebuttal Malley.
Okay, yeah. Yeah, and I think the same result should occur. So there was a mention of the passage that witness Singletary had made, the quotation the witness had made. So if we can take the same section out of the Malley testimony that we did for the Probst testimony. Yeah.
So I think starting on line 16 through 19, the witness, that sentence.
Yes, that's right.
Okay, thank you.
Okay. Okay, so let's hear from the applicants about the Megna passage quotation.
Thank you, Your Honor. I think as I noted in response to your order directed to Cub, I believe this is a different circumstance than the more lengthy quotations that Cub had in their testimony. It's not for the truth of the matter asserted, it's for the effect on the listener and to describe the purpose of Mr. Megna's testimony. So I think earlier in his testimony, he discusses the application that was filed for a deferral request. And then in this part of the testimony, it's explaining why he's putting forward this additional information. That is a distinction from the WPSC case where Mr. Megna didn't offer direct testimony because we hadn't had the specific direction from the commissioner. It's a very limited quote. It's in a footnote. It's essentially saying, bring this up in the rate case. It was the current chair who was making that statement. The purpose of the errata, and I don't think it was late under the rules, was to comply with the considerations that you had in your ruling on Friday, right? Which is that it can't be verified. So we submitted a verified transcript. It's out of the context of the open meeting. So we submitted the entire transcript. It's not for the truth of the matter asserted. So there's no cross-examination or authenticity problems with it, right? It's for the effect on the listener, the utility. And I think that all of those were addressed in the errata and our additional filing. That said, if the standard is probative evidence and that's all, then it might fail that prong, and we can understand that perspective from Your Honor. But again, we thought it had helpful context to why Mr. Megna was submitting the testimony in direct, because we'd essentially been directed to do so by the chair in the open meeting. Those comments were ultimately not picked up, and the order was actually not issued, I don't believe, until after our direct testimony was in, right? So at the time the direct testimony was filed, it couldn't have been replaced by the final decision because it took a fair amount of time for that final decision to come out. And the purpose was to say, this is why we're submitting the direct testimony. The chair of the commission has told us to do so in an open meeting. So that's what I would say in response to Your Honor's quotations. I can discuss the timeliness of the errata if that's necessary. I think we did comply with the timing of the rule. It couldn't have come in at the time of direct, right? Because we weren't aware of the transcript requirement, and again, not submitted for the truth of the matter asserted.
Mm-hmm. Yeah, I could address the timing. Well, let me hear other comments first. Anyone else wish to comment on the applicant's position? No, okay. So the timing is it's pretty technical, but it's important. So on errata, I wouldn't be expecting to see a new exhibit being offered. So that would be supplemental testimony with a motion to leave to supplement the record. So in terms of process, I think that's important to say. If you're going to be offering an exhibit and changing testimony in that manner, we're not looking at corrections. We need to file that as a motion for leave to offer additional evidence, and that triggers a process which we can hear objections and and if this was done in terms of timeliness, I suppose it could have. This was on rebuttal. I don't know exactly when that order was issued in the case, but there was probably time to do that earlier. But either way, the idea is to file a motion for leave rather than filing that in errata. That's just that portion's not appropriate. That's not the substantive basis of keeping it out at this point, but just in terms of the use of errata, I think that was inappropriate. So just for the future.
Okay, thank you, Your Honor. I think that is helpful clarification for the future. I don't think that's clear to us from the facilitating matters order. I think our understanding is if it's a substantive piece of testimony, we would file a motion for leave, but understood on the going forward process.
Errata isn't errata. I think we all can agree with that. We expect from that, but errata is to correct, not to add. So, but I think I did note in the comments here for this witness that I think substantively what's better suited in this case is a citation to the current order in order to show that what information is needed, why the commission denied the application in that docket, and what information the utility should be filing. I think that was clear in the order, and the order wasn't available before. I understand that, but just in terms of getting the proper information into the record where we don't have to wonder, as we've been saying, the commission speaks through its orders. Now that we have an order that definitively says what it says, that's simply citing to that, I think will solve our problem with getting the background, the rationale for filing this into the record without bringing up the controversy of quoting a commissioner and the process by which we do that. So I think.
Understood, Your Honor, and not questioning the decision there. The note on the offered evidence list strikes some of the testimony. I think the kind of easier way to handle Your Honor's ruling is just to replace the footnote with a citation to the order. But
let me see.
It's Magna rebuttal, Your Honor. It's number 2. Strike is, I think, what's addressing your order, Your Honor, and it strikes some testimony and then also the footnote. I think the most direct way to handle your decision, Your Honor, would just be to replace the footnote with the final decision. But if there's another reason why we would strike that piece of testimony, I'm happy to respond to it.
Okay. Yeah, I think that's okay. Anyone have a comment on that? Leaving the testimony in and changing the citation to the order. Put that on the screen. So leaving the sentence starting with earlier. And then striking the footnote and adding a citation to the order. I think that does the purpose we're looking for.
Your Honor.
Yes. No comments? Okay, yeah, let's make that change then. And so I did want to just discuss very briefly what was being filed as Magna 1 in order. So we are developing a new practice here, unfortunately, I think. And I'm still going to be very careful about allowing commissioner quotations in the record. I haven't done it yet. So the Magna, so we have what was purported to be a transcript of the open meeting.
And I think, Your Honor, we'll just withdraw that.
I understand. Yes.
Okay.
And I won't receive it. But I did want to just review, like I said, briefly to say,
Oh, understood. Thank you, Your Honor.
What direction I can give on this. This is not an acceptable transcript. First of all, it's not verified. It's not certified. So I can just show you the bottom. We usually get that page on the bottom with the court reporter's certification. And also on every page, there's a indication that this best efforts transcript of the proceedings. I don't know what a best efforts transcript is, and if it's not verified, I'm not going to accept it. So that's just something you guys, everyone needs to be aware of. There's also many inaccuracies, just words that don't make sense. So I don't know how much we could rely on this. And as you can see, if you're, of course, this is the cure, is to put an entire transcript of the open meeting in the record. Now, obviously, you see the problems with doing that as well, which is which passage are you going to pull out, and you have competing passages. Now you're going to have to interpret various commissioner statements throughout the meeting, different commissioner statements, different commissioners making different kinds of statements, and interpret those rather than rely on the order. I know the situation, the order wasn't issued. But the problem is when you quote a commissioner, you run into all this quagmire. So that's why I'm very reluctant to accept that kind of testimony. Okay. Okay, so we handled that one. So we also have pending motions. There's a motion for leave to file the Magna surrebuttal. I think that it was a late filing. Was that the basis of that?
It was an inadvertent misfiling, Your Honor. So we did ultimately file it late.
Okay.
But it was intended to go in on timely and didn't.
Right. Okay. So were there any objections to the Magna surrebuttal? No. Okay. So we also have the Zagonk Exhibit 9, which was also, do you want to characterize that for us, Attorney Proctor Brown? This was
Yes.
on rebuttal and now filed, when was it, yesterday?
That's right, Your Honor. It's referenced in Mr. Zagance's rebuttal due to a miscommunication internally here. It wasn't filed along with it. The first time we were notified that it wasn't filed is Sunday at about 2 p.m. when we were able to review Mr. Tierney's surrebuttal. So worked as diligently as we could to get it in yesterday, filed the motion yesterday as well. It's a one-page schedule that is explained in about 2 pages of testimony in Mr. Zagance's rebuttal. So I don't think there's any prejudice to the parties as Mr. Tierney actually responded to the testimony itself. But if there's a curative instruction or an additional piece of testimony that staff, who's the only party that testified about that piece of Mr. Zagance's testimony, wanted to put in, happy to discuss that too.
All right. Yeah. So I just wanted to check on the. Okay. All right. And okay, so does anyone have a comment on that?
Your Honor, Evan White's on behalf of commission staff. I guess initially I didn't really have an issue with this. I understand that sometimes things get missed and you don't see it until later. However, I think from staff's perspective, we have a greater concern now seeing the SIRSA rebuttal from Mr. Zagantz. And the reason I bring that up is Mr. Tierney did respond to this and did say that it's impossible to review the validity of the figures without the exhibit containing the analysis being referenced. And then when I saw the SIR rebuttal where witness Zagantz is saying that he references this particular exhibit and then states that his conclusion is one that Mr. Tierney does not dispute. Well, staff hasn't had an opportunity to really review or vet this particular exhibit. I understand it's only one page, but it's a number of financial figures and kind of extrapolation and analysis. And I guess I'm just somewhat concerned if it was just a missed filing that someone forgot to upload it. They thought it was uploaded. It wasn't filed until very late in the day yesterday. I think around 4:18 p.m., I think is what was referenced in the applicant's motion. And then now with kind of attributing that staff does not contest the conclusions from that exhibit in SIR rebuttal, that causes me some concern and that staff hasn't had the appropriate amount of time to fully kind of vet and respond to this exhibit that should have been included in the rebuttal round of testimony.
Comments for anyone else? Okay, so I did have a question for the applicants. First of all, we've been saying filing, but this is actually a good opportunity to note for people that in case there's issues with documents not getting onto IRF on time, the main cure, which should of course probably didn't get done here, I just want to confirm, but what's really important that happens on time is that it gets served on time so that parties have, and services by email. So you need to email these things, or at least email them as fast as you can. If something is late on IRF, I can live with that. It's just the service to parties is most important. So IRF sometimes has problems. People can't log in. I don't know the story with IRF sometimes, but if there's a way to, the best way to cure these things is to make sure you're emailing things on time. And if you miss something, get that email out as soon as you can. So I just wanted to confirm with the applicants that this was neither, didn't get filed and it wasn't served on time as well, right?
Yeah, that's right, Your Honor. The internal miscommunication was which part of the spreadsheet needed to be PDF'd, and rather than clarifying the kind of miscommunication, it just didn't go out, and it's just silence. And so it was certainly prepared. Clearing up the miscommunication yesterday took longer than it should have, which is to Attorney Weitz's point. Why it didn't go in immediately on Saturday. The people involved in the miscommunication were not available on Sunday, or we certainly would have attempted to do that sooner.
So is there an explanation for why Zagantz and SIR rebuttal is stating that commission staff doesn't contest it? Is that the language?
I'm not sure if that's the precise language. I'll take Attorney Weitz's representation on that, and we can pull it up and we can make curative instructions on the SIR if that's appropriate. Mr. Zagantz is also certainly here to testify in person today. I think the point of the SIR rebuttal is that Mr. Tierney doesn't contest that there are going to be potential adverse financial consequences for a downgrade in credit rating, and that's the point of the exhibit. That's the point of the rebuttal. I don't know if staff wants to have the opportunity to put supplemental testimony in and analyzing the exhibit, but it was something that Mr. Tierney asked for in direct. We intended to put in rebuttal, and so we're not opposed to any analysis that Mr. Tierney would like to put into the record at all. Again, just an inadvertent mistake on our
right. Nor could you, but yeah.
Something in a revenue requirement, it goes to an alternative analysis that is not being sponsored by commission staff. So it is kind of analysis of a side issue in the docket.
Okay. So how do we propose that we correct this? Is this something maybe staff could help us with, or?
I guess, Your Honor, at this point, what I might suggest is, I know one thing that was helpful that we did last week at the public service hearing on Friday was to, with the amount of sur rebuttal filed, took a brief break so that all the parties could kind of review that. I think that would maybe give staff an opportunity to see how much time or additional analysis would be needed on this particular exhibit, or and then maybe we could revisit this issue to determine what makes the most sense as far as a cure.
Okay. So we'll set that aside for now.
Thank you, Your Honor. And just for the record, I think that's a good idea on Attorney White's part.
Yeah, I'm just reviewing the sur rebuttal. It doesn't say that witness attorney doesn't dispute the exhibit necessarily. So I think that may be the point that the applicant's making, but which would be a very difficult statement to make. So okay, let's move on then. Okay, we handled witness appearances. Okay, so we also have the content exhibit 5, which is also filed, I think, as an additional. Not really sure, actually. I don't really remember what the context of that was. So if you could just enlighten us, Attorney Corbin Ferris.
Sure, that exhibit is accompanying some short testimony that Mr. Content will be offering on the stand today in response to company's sur rebuttal.
Okay, so it hasn't been offered yet, but it's been provided for use today. Okay,
yes,
so that's so
consistent
far.
with
So
my
far,
interpretation of the facilitating matters order.
Yes. Okay. So far, so good. All right. We'll leave it at that then.
Your Honor, before you move away from correcting exhibits and testimony,
Yes.
I have a matter to raise as well with regard to 2 filings of exhibits I made last week during the pub service hearing, and the upshot is that they are 2 exhibits from Lane Collin, 5 and 6. The documents were marked 5 and 6. They were served to everybody as 5 and 6, but when I put the name of the document into IRF, I said Pollock 5 and 6.
Yes. Okay. And I see that. I think I attempted to correct my list here in anticipation of that, but because there was some confusion about the filing, let me just ask if there's any comments people want to make about that. No. Okay. Yeah. So we'll just count that as filed on time. I think it was filed as Pollock, but that labeling did no prejudice. As I understand.
Thank you very much. Out of caution, I did file it with the proper name today. So they have. So that's the IRF numbers we'll be using for.
Yes, I have those listed.
All right. Thank you so much.
Yep. Okay. Great. All right. So we do have witness Meyer just joined us. So I think we're just going to take him to verify his testimony.
Judge, this is Krista Westerberg with Walnut Way. I apologize. And maybe this is still on your list to get to, but there was another pending motion, which was to amend the brief schedule.
Oh, yes, you're right.
I'm sorry, I'm sorry, Ms. Westerberg, which was?
To amend the briefing schedule.
Yes.
Thank you.
I apologize. That got lost in the shuffle here. Let me bring that back. Yeah, so we do have the other motion is to amend the briefing schedule. I'm going to bring that up. So the situation is to, because of the timing of the public hearing sessions, and we usually hold the written comment period out past the public hearing. So the written comment deadline, as I said before, is I don't know if I remember that exactly. It's after the last public hearing session, which puts getting those documents into the record far beyond the deadline for filing briefs. And Walnut Way is requesting a change in the briefing schedule to allow for the citation of public comments in the briefs. So a couple of things I wanted to say. Well, yeah, so we already heard their motion. Let me ask if parties have any opinions on that. Parties and staff. So my understanding is that staff may not be able to accommodate the full briefing schedule to be delayed to this extent.
Your Honor, that was the only thing I was going to bring up is I know, as everyone probably remembers, when setting the schedule in this case, there was kind of a lot of constraints to make sure that everything happens on time and gets done by the end of the year. So I know there was a lot of back and forth coming up with the schedule that we did have. And I just don't know that there's enough room in the schedule. I think that would put kind of a heavy ask on staff if we were to delay the entire briefing schedule by that amount of time.
Okay, so I had an idea that I had to accommodate this as well as staff's concerns. And it's based on, I did review some of the briefs that Walnut Way had cited in this request, briefs that Walnut Way had filed in previous cases that used public comments and cited to them for the commission's benefit in the brief. So what I propose is that we continue with the initial and reply briefs on the merits as scheduled, but then allow a brief, this schedule that's being proposed by Walnut Way to be either an addendum to the I think it's probably a good way to actually phrase it, an addendum to the brief in order to either insert citations to public comments or add a brief statement with respect to the public comments according to this schedule. And then the bulk of the briefing will be done, but in order to bring to the commission's attention whatever comments the parties wish to discuss, there'd be this separate timing for that in order to accommodate getting the comments in the record. Now, there may be some, depending on how, there may be some delay even more so because the public comment exhibit may not be available that quickly either, given the timing of the case. But the bulk of the information would be on IRF. So I think there'd be enough comments in order for the parties to be able to react and include in their briefs. Also, I mean, right now comments are being received. So there are already comments that could be incorporated in the briefs. But if you want to have the full plate of comments available to brief and to include in your briefs, I can accommodate it in that way. So there'd be a limited brief to respond to comments or to raise information that the public has offered in the case. We're using in that briefing schedule, but the rest of the briefs would be as normally filed on the current timeline. So I don't know exactly how if that would be an addendum, it would be just sort of a, be a separate brief, or it would just be saying insert these lines into my existing brief. I don't know exactly how that would look. If people have a preference or any ideas about that, I'd be willing to hear that. So
Your Honor, I would let the other parties go and then do a reply if that is all right, and since we're the ones filing the request.
Sure, I'll hear from anybody as an idea. No? Oh, go ahead.
Okay, thank you.
I think the applicant.
Well, Your Honor, yeah, we do have a couple of comments, I suppose, if no one else wanted to speak first. We obviously didn't file an opposition on IRF, so it didn't have any fundamental issue with the the motion, except for the concern that staff just raised, right? Like our fundamental concern in scheduling was to get a decision by the end of the year. And our secondary concern was to make sure that there was enough time to have a clean record for the commission. We had an awful lot of back and forth on that. And everyone complied with this very quick briefing schedule or testimonial schedule, which has, I think, clearly resulted in some problems. And to then push it out to accommodate public comments, we don't think is necessarily appropriate. Your compromise, Your Honor, makes sense to us so long as the page limits are the page limits, right? We're happy to have an addenda to a brief to summarize public comments so long as it doesn't extend the page limits for a single party that wishes to put in public comments, which are not substantive evidence and will come before the commission in their entirety when the record is compiled and the public comment exhibit is sent to the commission. So that's our comments, and I'm happy to respond to anything from Walnut Way or the other parties.
Okay, thanks. Yeah, and I did want to just mention that the timing of the public hearing sessions is unfortunate, but it's more difficult than you can than you might realize to get the proper location with that meets all of our criteria, and to have people, you know, get back to me and get a reservation actually finalized. Also, we ended up adding a location in Milwaukee within the city limits, which ended up extending both the time to secure a location and the timing of the hearing itself. So so we might not see those dates going out this far out into the future in most cases, but yeah, unfortunately in the current schedule, that's what happened here. But having said that, we don't necessarily, I don't really want or desire parties to be dictating, or parties' concerns to be really the main thrust of how we schedule a public hearing session. We need to do that as we can, as time permits and resources permit. So but this is an accommodation I think we can make just to be able to satisfy all interested parties and their concerns. And I think there's no strong objections. We'll go ahead with that. I guess so do we have maybe Walnut Way has more of a detail in terms of what we would expect to see from this kind of brief? That would be useful.
Right, Your Honor, and I understand that there are a number of competing considerations with scheduling the hearing, and you know that all of this is not always done at the same time, and that's why we're seeking this adjustment. You know, I would note, in what we said in our request for the order to amend, is that this schedule that we proposed really isn't any later than the hearing or the schedule 2 years ago. And I was not aware of staff's concern, you know, about this particular motion beyond the discussions we had when we were doing initial scheduling. So we thought this was not a major change to prior practice or an adjustment to what's been done before in terms of timing. So our preference is still that, you know, and I think the cleaner option is just to have the initial briefs be done on this proposed schedule as we've got it. But if that is not the ALJ's ruling, we will, I don't have any particular ideas here on the spot about what the alternative or additional brief would look like. Or if it would just be an amendment to the briefs that we do, but then it's a little bit hard to handle the page limit, because then you take something out to fit in a new comment, you know, it's a little bit messy. That's my only concern.
Yeah, I'd say just have a comment with respect to public comment, a brief with respect to public comments, and then keep that to the normal page limits. I don't know if you're really going to need 30 pages, but yeah, I think that's the simplest way to handle that. So it would be a separate brief, but just to focus solely on the public comments. Like I said, there may be issues with the fact that I may not have received all the comments through the effect of the public comment exhibit going out and being received into the record. So we do run the risk that there may be a comment that you're citing that I end up not receiving. But I think we'll just have to take that chance. And hopefully we won't face that situation. Plus it's something we can cure. But in the meantime, the rest of the case can run and the commission staff can get its work done. I don't think this will be impacting their the work that they need to do to prepare the record before the commission open meeting. So let's do it that way. So we'll do, just to be clear then, so we'll have the brief with respect to public comments, the initial version due October 10th at 1:30 p.m. and then the opportunity for a reply brief due October 18th at 1:30 p.m.
Your Honor, I guess I just would reiterate my comment that I do think that these should be held to the same page limits. That I don't think it's appropriate to have give Walnut Way the ability to have 60 pages of initial briefing and to add another 30-page brief on public comments. But if that's your ruling, Your Honor, then
maybe I misunderstood you. So you wanted to have 30 initial, including both briefs.
Correct, Your Honor. Yeah.
Okay. No, I don't think we can. I don't want to necessarily do that. We can limit the initial brief to 15 pages and the reply brief to 5 pages.
The initial public comment brief and the initial reply public comment brief. Okay.
Yeah.
Just one other thing I wanted to mention. I didn't want it to go unaddressed. Attorney Proctor Brown mentioned that public comments are not substantive evidence. I don't agree with that. I mean, they are sworn. So I do think they are substantive evidence that can be considered just like anything else we're doing today.
Yeah. Well, thanks for raising that. I think the Attorney Proctor Brown's not ruling on that, so he's giving us his opinion. So, but I appreciate the response.
Your Honor, if I could just ask one point of clarification from staff's perspective, just as I'm trying to think about how this factors into all the steps that need to happen, and whether it be the decision matrix and then the parties' comments on the decision matrix and all those steps before the open meeting and things of that nature. So is the expectation that the briefs that would be filed according to this later schedule would be limited only to public comments and not raising new issues? I think that distinction would help in staff's preparation of things like the decision matrix and that kind of stuff.
Yeah, so I would label it initial brief with respect to public comments. It's only to address the public comments. And then the reply is only replying to the initial brief.
Thank you.
Okay. Is that clear to everyone?
And thank you, Your Honor. The amended page limits and your clarification on the substance of the briefs, I think would address our concerns on our side. So appreciate those clarifications.
Yeah, I think that's fair. Okay. So, right. So we do have witness Meyer is waiting, and I think we can take him quickly. Okay, there we go. So I see you there, James Meyer. Just unmute your device and we can proceed. No, I think I can do it. Oh, there you go. Great. You just tip that camera down a little bit so we can see. There you go. Perfect. Yeah. All right. So let me swear you in. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
All right. State your name and position, please. Please.
James W. Meyer. I'm the business manager with IBEW Local 2150.
All right. And I see you filed direct and surrebuttal. Is that correct? Yes?
Yes.
Okay. And are all the is the information you provided complete and correct to the best of your knowledge?
Yes.
Okay. I just see a few corrections that I added to the document. Any questions about that?
Nope. I will get those corrected ASAP.
All right. Great. Thanks. Any questions for the witness? No? All right. Thanks. You're excused.
Thanks.
All right. So just let's go off the record. Let's take, we have some AM witnesses. Let's just get that lined up before two. So we have the MMSD has 2 AM witnesses. Bieber. Can't remember what you said about him.
Your Honor, this is Kurt Bain with Roundy's. If it's okay, it would be great if we could do Bieber this morning. He's boarding a flight and he'll be back, on in the afternoon, but it would be great if you could just kind of get this off of his plate.
Okay, I think that's fair.
Thank you.
All right, so let's take a few of the yeah, we have some simple witnesses we can take. Let's take witness Bieber first.
Your Honor, this is Stephen Lee for Walmart. Before we do that, can we excuse Mr. Austin for Walmart? I believe no parties indicated questions for him, and we intend to verify via affidavit.
All right, sure. Any questions for Austin? No. Okay. Yeah, so we can excuse Austin and look for verification by affidavit.
Your Honor.
Let's do that first. Let's do the affidavit people first. So anyone else we can take by affidavit? We'll just go down the row. So Cub was no. Anyone from City Milwaukee we can take by affidavit?
Thank you, Your Honor. I don't believe there's any cross-examination intended for either city witness.
Okay.
We do have Eric Schamberger here right now. Marina Dmitrievich is an alderwoman and she is still in the Common Council meeting. But I would actually prefer to do both by verification if possible. I mean, by affidavit if possible.
Okay, well, I think we can manage that now. So were there any questions for these witnesses, Dmitrievich and Schamberger? No questions? Okay, so we can excuse them.
You're going to say that back on the record, or do you want me to?
I'm not on the record? Oh, no. When did I go off the record? Yeah, okay, so let's get on the record. So we're asking for witnesses who can be excused. And their testimony can be filed by affidavit. So we have City Milwaukee witnesses, Dmitrievich and Schamberger, and there are no questions. So we can excuse them. Did I excuse Austin as well? Put that on the record, make sure Walmart witness Austin is excused. Anyone else we can excuse?
Your Honor, can you excuse Vote Solar's Kenworthy by affidavit, so I don't have to have him log in from overseas?
Okay. So he's available to testify?
He's at a family function overseas and he was going to leave in order to testify if there's any questions for him, but if there's not, I'd like to be able to let him stay at that event.
Okay, but he would be available if necessary.
He is available if necessary.
Okay, all right. So any questions for Kenworthy? Okay, all right, yeah, we can excuse Kenworthy. We'll accept that testimony by affidavit.
Your Honor, while we're on this topic, there are 3 witnesses from applicants that have no rebuttal and, to my knowledge, no cross.
Okay.
Gerlikowski, O'Brien, and Pecorelli.
Okay, so Gerlikowski, just want to make sure we understand there's the update exhibit that was requested by, was it Ritzma? So that's already been a note in the offered evidence list. We're okay with that? No issues? Okay. And who are our other witnesses?
You have them now on the screen, Your Honor, O'Brien and Pecorelli.
Okay. So O'Brien, I don't know if I've shown this one, but there's the O'Brien 4. I think it's a, is it doing this? It's a exhibit that I created. It's just the commission's decision in 05 GI 108 phase 1. So that was going to be an additional exhibit. Any questions about that?
And none from applicants, Your Honor. I
Okay.
think it's in the notes.
Yeah, I just want to make sure we're all on board.
Yep.
So let's see. So then any questions for Gerlikowski?
Your Honor, I just wanted to remind you of the exhibit that you're requesting of Gerlikowski for the West Riverside E4 issue.
Oh, okay. So let's go off the record for that. So I actually relabeled that in the gonk. Was that incorrect?
Well, he was a witness who testified about that.
So which one? Which witness?
Zagans is the one who brought it up in rebuttal, and then I asked for a calculation in my rebuttal.
Right. So is it appropriate for Zagonk to file that, or should it be Gerlikowski?
Your Honor, from applicant's perspective, Mr. Gerlikowski is the subject matter expert or the more familiar with the fuel issues. So I think we would probably, if there's analysis to do or some proffering of analysis, we would probably have it be Mr. Gerlikowski. There wasn't enough on the fuel to have him submit an extra piece of testimony in rebuttal. It's the only reason he didn't.
Okay, so that's.
But I actually don't quite understand what's being asked. If we could.
Okay, well, let's. It's interesting. Okay, so all right. Let's go off the record. We're off the record, right?
Yes.
And maybe the better course of action is to put the two subject matter experts in direct contact, Mr. Ritzema and Mr. Gerlikowski. We have no objection to that on our end, but that would probably eliminate the game of telephone, which I think probably happened when we were reviewing Mr. Ritzema's rebuttal testimony.
Yeah, I guess I'm just concerned about if we could have Gerlikowski take the stand and explain and get some clarification.
Yeah, he's definitely available.
Okay, that might be the better course. If that's the person who needs to understand what's to be filed, and I'd rather have that understanding done on the record or at the hearing rather than wait for a subsequent conversation. So, okay, so let's keep Gerlikowski on the list. And
okay, thank you, Your Honor.
Yeah, I'm glad we got to that actually. Okay, so we'll mark. So let's get on the record. So we're going to mark.
I'm sorry, Your Honor. Before we move there, two witnesses for WEG, if we could excuse them, that would be great as well. Mr. Bauer and Mr. Pollack.
Okay, yeah, we're not there yet. So
okay.
Sorry, this is confusing, but this case is just, it's kind of run amok. But so I'm just glad we're getting done what we need to get done. So on the record, so in terms of Gerlikowski, we will call that witness, and we're also marking Gerlikowski 4, which I can describe as the West Riverside CPCN EFOR model run as requested in surrebuttal PSC Ritzema 3. And we can discuss whether we're gonna, how we deal with that or what it is later when we get the witnesses on the stand. So, so for O'Brien.
Thank you, Honor. And just for your scheduling purposes, we'll probably have him go later in the day. And I can let you know when he's prepared to testify about that.
Okay, great. Thanks.
Thanks.
So we have O'Brien. Any questions for O'Brien? Okay, we can excuse him, that witness, and we'll move on to, what was the other one?
Piccarelli, Your Honor.
Piccarelli, yes, thanks. Any questions for Piccarelli? No? All right, that witness is excused. So let's keep going down. Did we cover? We didn't cover sewerage district. Are there any witnesses we can excuse? Any questions for these witnesses. So we'll start with Bride.
Be happy to verify by affidavit, or he's here now.
Okay, well, we could do the affidavit if it's, oh, it's up to you if you want to call him.
Affidavit's just fine with us.
Okay, that's good. All right, so we'll excuse Bride. How about Schaefer? No questions. We'll excuse Schaefer. And I'm gonna pronounce this wrong, but Touches.
Yes.
Any questions? No? Okay, they're all excused.
Thank you, Your Honor.
Move down to Renew. Belkey. Any questions? Okay, excuse that witness. Kel. Questions for Kel? None. Okay, Kel's excused. Roundies. Any questions for Bieber? None. Okay. Bieber's excused. Kenworthy, did we get to Kenworthy yet? Yes, we did that. Walnut Way, there's still questions for, is that right? I think it's the applicant. Did the applicant still have questions for Butts?
Oh, yes, Your Honor. We do have questions for Mr. Butts and Mr. Colton.
Okay.
Sorry about that.
You're good. All right, for Weig, Bauer, any questions for Bauer? So we have questions for Colin?
Yes, Your Honor. Some very limited questioning.
Pollock? No questions? Okay, so there, Pollock is excused, Bauer's excused.
Yeah, thank you, Your Honor.
Run the gamut.
Your Honor, just a quick point from commission staff. Witness Lindquist is available if we could have him verify we're in the window where.
Right. Okay, let's take Lindquist quickly, and then we'll probably need short break. Where is Andrew? There you are. Okay, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do swear.
Okay, go ahead.
Thank you. Mr. Lindquist, in this proceeding, did you file or cause to be filed direct and serve rebuttal testimony?
Yes, I did.
And did you also file or cause to be filed one exhibit?
Yes, I did.
Are the statements and representations in your testimony and exhibit true and correct to the best of your knowledge?
Yes, they are.
Do you have any additions or modifications to make to your testimony or exhibit at this time?
No, I do not.
Thank you. That's all I have. The witness is available for cross.
Okay, any questions? No? All right, thanks. You're excused.
Thank you, Your Honor.
So before we take a quick break here, did I miss any of the applicant witnesses that we had no questions for? I don't know if I got everybody. Brian Piccarelli, that was it, right? Okay.
I think that's it, Your Honor. The rest of the witnesses have served rebuttal that was filed.
Right.
I guess I'm being told this is a relatively simple piece of questioning for Mr. Gerlikowski, and I think he's on. If you see him on, he would be prepared to testify before the break, is my understanding. But that might be a game of telephone in and of itself.
Okay, well, let's go off the record. How are you doing, Debbie?
I'm fine.
Okay, I still want we're cramping.
Oh, no.
All right.
That's just due to somebody's speed, but I won't mention any names.
Oh, okay. We won't mention that. Okay. All right, we'll take Gerlikowski. If I see him there. I'm not sure. I'm in the waiting room. If you could turn on your screen, witness Gerlikowski. If I'm seeing everyone. So you think he's connected?
That's what I was told, Your Honor. He might be in the waiting room. Not 100% sure. I'll be honest with you.
No one's in the waiting room that I can see.
Oh, I guess I'm being told there's some sort of Zoom problem. But so we can take him after a short break if that makes sense to everybody else, or
Sure, I think we
over
could.
you.
Well, is there anyone else we can take quickly? Say, is there any other AM people that we haven't excused? People from morning only or had a morning preference? No? All right. Okay.
Mr. Nelson, I think, had some cross from Roundy's. I think he's available to go, if that makes sense to your honor, and to Roundy's.
Yes, we're ready for
Okay.
Mr.
Okay, so Nelson.
Okay, we'll bring him. He's here in the
Okay.
room, so we'll bring him over.
Okay, great.
Thank you.
Okay, see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Perfect. Go ahead. Okay, you guys ready for on the attorney side? Just need to introduce your witness, please.
Thank you, Your Honor. Mr. Nelson, did you submit written, direct rebuttal, surrebuttal, and surrebuttal testimony in this case?
Yes, I did.
Did you also sponsor and submit 18 exhibits?
Yes, I did.
Is everything in your testimony and exhibits truthful and accurate to the best of your knowledge?
Yes.
If I asked you the same questions in your written testimony, would your answers be the same?
Yes, they would.
This witness is available for cross.
Okay, before we ask that, Debbie, you know who the attorney is? You got the name?
Yes.
Okay.
Ms. Zank.
Yes. Okay. So
That's
we
correct.
have did you mention the rebuttal? I might not have been paying attention that closely.
Yes,
Okay.
rebuttal was included.
All right. So I just wanted to mention the Nelson 18, which is an exhibit that I put together. So I don't, and let me just show you that. So it's formatted to be the final decision in docket 5 UR 103 with appendix B omitted because I think it's the entire tariff. So so it's just a copy of that decision printed from IRF, and I believe it's the not on the public side, so that's why it was not available. It wouldn't be available for the utility to file. So I wasn't able to share this before because the file is so large that it can't be emailed. So I just wanted to give everyone a chance to look at that, and I'll probably be filing this because like I said, I can't get it out the door unless I just file it. But it's the true copy of the order minus appendix B. So I just wanted to make sure everyone got a chance to understand that at the hearing. Are any questions about that? Okay. Okay, so with that, are there any questions for the witness?
Yes, Your Honor. This is Kurt Bain with Roundy's.
Okay, go.
Good morning, Mr. Nelson.
Good morning.
I'm just trying to find you on my my screen here.
So
can you like
spotlight him? Yeah.
Oh yeah, that would be great. Thank you.
I should be doing that more. Go ahead. Yeah, that should help. So do you see better that way? Just let me, I'm just curious.
Yeah, that's great. I wasn't sure which square was Mr. Nelson. So
Right.
It's all cleared up now.
Okay.
Good morning, Mr. Nelson.
Good morning.
I just have a couple questions about the CG3 rate design proposals in this case. The CG3, so Wisconsin Electric has 3 large general secondary CG3 rates. Is that correct?
Yes, that is correct.
And the one that's referred to simply as CG3 is the general secondary service demand time of use rate. Is that correct?
Yeah, that's correct. It's a firm service, general
Sorry,
secondary offering.
it's a what, excuse me, a what service?
Firm.
Firm service.
And for this rate, you state on page 12 of your rebuttal testimony, beginning on line 12, you state that Wisconsin Electric is generally in favor of rate design proposals that move rate designs in the direction of the cost of service. To the extent that demand-related costs can be recovered through demand-based rates, they should be, to that end, modifications to the overall rate structure of a particular class or subclass should be done incrementally and gradually. Do you recall that statement?
I do, yes, and I see it on the screen.
Now, turning to your direct testimony on page 56, starting on line 16, the question is, did Wisconsin Electric make any adjustments to the rate design for the CG3 offerings? And your response was, no, Wisconsin Electric maintained the relationship between the customer demand and energy charges that were established by the commission's final order and docket 5 UR 110. Is that correct?
Yeah, that's correct. I may further clarify that statement that is the initial final decision. So I believe the limited reopener for 2024 was also in docket 5 UR 110. So that statement is in regards to the 2023 test year final order.
Thank you. So would you agree that the current rate design for Schedule CG3 does not recover all demand charges or all demand costs through demand charges, that it recovers less through demand charges than there are in demand cost? Is that correct?
Object to the form.
Who objected? I'm sorry, I can't see.
Attorney Zeng.
Thank you.
That might have been a little sloppy. Let me rephrase. Would you agree that the current rate design for rate CG3 recovers less revenue through demand charges than there are assigned to the demand cost for that rate?
According to Wisconsin Electric's preferred cost of service study, I do indicate in my direct testimony that that is the case. On pages 57 and page 57, line number 10. So roughly 78% of the class's demand-related distribution costs are recovered, so not 100%.
And as you indicated a moment ago, and also on page 56 of your direct testimony, Wisconsin Electric is not proposing any movement toward recovering more of these demand costs through demand charges in this case than are in current rates. Is that correct?
With the clarification earlier about the limited reopener, there is a minor movement towards cost of service in this case by utilizing the rate design from the 2023 test year. That is because, and it's my understanding that effective January 1 of 2024, any change in rate was applied to the energy charges. So reverting back to the 2023 test year does, while minor, move rates back towards recovering more in the demand rate than not.
Thank you. Now, Mr. Bieber, witness for Roundy's, he has some recommendations for the CG3 rate design that you discuss on page 12 of your rebuttal testimony. And one is to maintain the current on-peak and off-peak energy rates, and two is to increase the on-peak and customer demand rates by an equal percentage amount necessary to recover the proposed rate increase. My question is, you state later on that page, beginning on page 10, you say that Mr. Bieber's recommendation increase the proportion of demand-related cost recovery on customer bills, moving the demand-based rates closer to the cost of service study suggested target than Wisconsin Electric's rate design. Is that correct?
Yes, that's correct.
And in your review of Mr. Bieber's testimony, you would agree that that Mr. Bieber's proposal doesn't move that rate 100% to cost of service. In other words, 100% of, per Mr. Bieber's proposal, 100% of demand-related costs will not be recovered through demand charges, correct?
Yes, I would agree with that in reference to the applicant's initial class cost of service study and revenue requirement, just with that clarification.
So Mr. Bieber is proposing to move closer to cost of service, but it's just an incremental change. Is that correct?
Yes, that's correct.
Thank you, Mr. Nelson. Those are the only questions I had.
Okay, do we have other cross?
Your Honor, this is David Bender for Volt Solar. I have a couple of questions on that last, the Sir rebuttal round that just came in.
All right, so let's grab that. Okay, go ahead.
Good morning, Mr. Nelson. David Bender for Volt Solar. I had a couple of questions for you on page 3 of your Sir rebuttal. So on lines starting at the top of the page, you're responding to PSC witness Nye suggestion that the commission is able to or may want to consider increasing the cap on the CGSCU tariff. Do you see that?
I do, yes.
Okay. And you're starting at line 8, you say you disagree with that. And the first reason you give is because QFs, qualifying facilities with generation up to 5,000 kW or 5 megawatts are able to participate under the CGS DSFP tariff. Do you see that?
I do, yes.
Okay. That CGS DSFP tariff is one of the requirements of that tariff is that the generation interconnect directly with the utility system, essentially separate from the customer load. Is that correct?
Yeah, so to participate under that tariff, the generator must be directly connected with the company's distribution system. There is one minor exception to that, and it does allow for the operation of auxiliary load that's required to operate the generator.
Yeah, but the auxiliary load is separate from like the customer's on-site load co-located with that generation, correct?
Yes, it would be much different.
Okay. So for QFs that are larger than 1 megawatt, and so do not qualify for the CGS CU tariff, but are less than 5 megawatts, do those QFs have any ability under the existing tariffs to self-consume their own generation behind the utility meter and also sell any excess to the utility at an avoided cost rate?
Objection, form.
Overruled.
I believe the CGSDS FP tariff is the only applicable tariff for QFs greater than 1 megawatt, but less than 5 megawatts. To provide with the ability to sell energy back to the company at avoided cost rates.
Okay, so that's the one we just talked about, right? That requires connection directly to the utility and not interconnected with customer load.
Correct.
Okay, so my question was, are there any that allow both self-consumption of the generation behind the meter and sale of excess at avoided cost? And you pointed me back to FP. Is that, am I correct in understanding that to mean that there are no such tariffs?
Yeah, I believe I stated that was the only tariff that allowed, well, let me clarify. So the CGSCU tariff is the only tariff up to 1 megawatt that allows offsetting of on-site load with the sellback of any excess load. The DSFP does not allow for that on-site load offsetting. So it would only be one of those conditions. There's also the non-purchase tariff, but that would also only be one condition, which would be offsetting on-site load. But there would be no purchase by the company for any excess energy delivered to the company.
Okay, so I think you explained your reasons, but I don't know that you answered the question directly. So the question is, for those QFs larger than 1 megawatt, is there any tariff that allows them to both self-consume behind the meter and sell excess to the utility?
No, there is not.
Thank you. That's all the questions I had for this witness.
Thank you.
Okay. All right. Well, before I ask for other questions, just wanted to mention, so there was a number of commission orders that were cited in your testimony, Witness Nelson, and I don't think I have instructed that in my comments to add those citations. And I think I did a few of them, but I was very specific on the locations. So if there are other places where you cite commission orders, we'll need to get the TSC reference number attached to it. And I think especially the ones to the varying orders in the UR 110 case, it may be critical to know which order you're referencing, because it seemed to be, the change your answer depending on the case, whether it was the original or the reopener. So I just want to make sure we follow up with that. Okay.
Okay.
So anyone else have questions? All right. Any redirect?
No redirect, Your Honor.
All right. So we do have the Sursa rebuttal. Let me just make sure. So I didn't actually move these things in yet, because we're going to go through each witness and make sure we had the right documents. So, so we did review all the documents. Yeah, I think they're all accounted for. So I can receive the Nelson exhibits and testimony, and we can otherwise we'll continue to do that when we get to our witnesses. Okay, great. So thanks very much. You're excused.
Thank you.
Let's see. So we did have Gerlikowski join us. Do we have time to take him? Oh, he's waiting in the waiting room again. Did I not admit him? Oh, and Alex too. Oh, so Alex says, can he, how long can Alex wait? Andrew, I'm sorry. Is it Kirschling? Oh, Alex, yeah. What's Alex timing again?
Your Honor, we already took Mr. Lindquist.
Okay. Really?
Unless I'm imagining things.
I don't know anymore, to be honest with you. So, okay, I'll take your word for it. No, you're right. He just joined us again. I don't know why. Okay, just got confused there. All right, so let's take Gerlikowski.
Thank you, Your Honor. If we're on the record, applicants would call Mr. Gerlikowski to the stand virtually.
Oh, there he is. Great. So raise your right hand. Can you hear me okay? There you go. Do you swear or affirm?
Yeah, I can.
The truth and nothing but the truth?
I do.
Okay, looks like he's pretty delayed here. We're going to try our best to work with that, and we may need to have him call in just to have the connection two-way. So let's try to do with the introductions and see how that goes. So go ahead, Attorney Proctor Brown.
Thank you, Your Honor. Mr. Gerlikowski, would you state your name for the record, please?
I don't think that's going to work. Okay, looks like your connection's pretty slow, so it probably would be best if you called in. And
Brandon Gerlikowski.
So let me get the number for him.
You're off the record, correct?
Yeah, thanks. So Brandon, if you can see the phone number there, you want to just call in and we'll be able to communicate much better using the phone connection.
Okay.
That sounds like he's
Enter your meeting ID followed by #
All right, so I'm going to mute your Zoom, but you can keep your video on, and I'll admit. Oh, you probably can't. Yeah, and I'll admit you by phone. So yeah, *6 to unmute.
Can you hear me?
Yes. Yeah, much better. So you may have speakers on your computer.
All right, is that better?
Yep, that sounds good. Great.
Yeah, I agree, Your Honor. That does sound a lot better.
All right, excellent. So where were we? We were swearing in and getting names and introductions. So why don't we go ahead with continuing with that?
We're back on the record.
Yes.
Yep. Thank you, Your Honor. Mr. Gerlikowski, would you please state your name for the record?
Yes, Brandon Gerlikowski.
And did you pair and cause to be filed public and confidential versions of direct testimony?
I did.
And if I asked you the questions contained in your direct testimony today, would your answers be the same?
They would.
And did you prepare and cause to be filed public and confidential versions of 2 exhibits?
I did.
And are those 2 exhibits true and correct to the best of your knowledge?
Yes.
And earlier in the proceeding, we discussed 2 placeholder exhibits, Exhibit WEPCO WG Gerlikowski 3 and Exhibit WEPCO WG Gerlikowski 4. I want to discuss really briefly Exhibit 3. What do you understand Exhibit WEPCO WG Gerlikowski 3 to be?
Could you please pull it up on the screen?
So the note that ALJ Newmark has on the screen indicates that Exhibit 3 will be a placeholder for summary and updated DRRs. And I believe that references back to your testimony and Mr. Ritzima's testimony. Does that refresh your recollection on what Exhibit 3 would be in the context of the fuel plan?
Yes.
And do you intend to file that exhibit as a supplemental exhibit after this hearing?
Yes, I do.
And then Exhibit WEPCO WG Gerlikowski 4, the note relates to a verbal request or a request from Mr. Ritzema related to the West Riverside CPCN E4. Would you describe for the record what that exhibit will be?
Yes, we will update the fuel run associated with the West Riverside EFOR.
And that exhibit will be filed after the close of this hearing, correct?
Correct.
Your Honor, I think that covers the notes. I would take your direction on if you want me to ask any other foundational questions related to those 2 delayed exhibits. Subject to that, Mr. Gerlikowski is available for any cross.
Okay, great, thanks. No, I think it's because it's in the context of the testimony filings. There's enough understanding with what we're expecting. Because I just wanted to make sure we understand that the EFOR that's being used in Gerlikowski 4 will be the value provided in the West Riverside CPCN final decision.
That's my understanding. Mr. Gerlikowski, did you understand that Exhibit 4 would include the West Riverside E4 that was included in the Commission's final decision in the CPCN docket?
Yes.
Thank you.
Okay, great, thanks. All right, so is the witness available for questions?
Yes, he is, Your Honor.
Okay, and just so we know, I can accept the documents that we're displaying here, and they're on the offered evidence list, plus with the corrections we're expecting and the post-hearing exhibits, we'll expect to get those. I guess maybe just one other question related to that is, what would the timing be for filing Gerlikowski 3 and 4?
From my point, it would be literally a day or 2.
Okay, and I guess Gerlikowski 3, do you need to wait for something first in order for the update to be created, or that's something you have, you have the information you have already as you sit here?
Yes, we should have all that information.
Oh, okay. All right, great. So, okay, so any questions? So interveners or staff, questions? Nothing? Okay. All right, okay, any redirect?
No, Your Honor.
Okay, great. All right, thanks very much. You're excused.
All right, thank you.
Thank you, Your Honor.
Bye.
Yeah.
Thank you, Mr. Gerlikowski.
Okay.
So we're at noon, Your Honor. I'm not sure when you wanted to take the break, but we can proceed with other witnesses that have sur rebuttal, or really we'll take your direction on who wants to go next.
Okay. Do we have any quicker witnesses here we're expecting, or?
Are you off the record?
Sure.
So my understanding, Your Honor, is Mr. Kurducky, Mr. Lambert, Pekka and Megna have no cross, so it would just be a matter of if any of the parties object to their sur rebuttal.
Okay.
If there are no objections to their sur rebuttal, then we would submit those witnesses' testimony by affidavit. I know in the WPSC case, there was some question about how much time the other parties needed to review that sur rebuttal, so.
Right. Okay.
Your Honor, commission staff would have some cross for witness Pekka. I guess as it relates to the other witnesses with sur rebuttal, I would ask maybe we could have over the break to review that, although I think witness Lambert might be a quick witness. I don't think commission staff has any questions for Lambert.
Okay, well, why don't we do our break now? That'll give time for review. We're off the record, but is there any significant differences? Is it different? Does this sur rebuttal differ in substance between the pub service case and this case? Anything we should know about?
I don't believe so, Your Honor. Mr. Megna's testimony is maybe a little bit different because of the differences in the forestry testimony, but
okay.
And Pekka is new.
Pekka is new because it relates to storm hardening.
Okay, yeah. Okay, so how much time do we think we need to break and review the sur?
I guess could we come back at 1 maybe? Does that work for everyone?
That's fine with me. Everyone okay with that? All right.
Fine with the applicants.
Okay, let's do that. We'll take a break till 1 and we'll return for the rest of applicant witnesses.
Thank you, Your Honor.
All right.
Thank you.
Mhm. All right. Just about time to get started. Everyone enjoyed that. All right, looks like we have most people back here that I can see. Can't see everybody. I just was wondering, I think I see a note for Stevens to go before 2 p.m. If that's still the case, maybe we could just take Stevens quickly.
That would be great, Your Honor.
Okay, and
Your Honor, one other quick thing before we get started. I don't know if you wanted to revisit the issue of Exhibit Zagant's 9 before we start taking testimony again. I do think I have some suggestions based on kind of staff's position.
okay, I'm not sure if we were going to do that when we took the witness or not. Maybe
Either's fine. I just wanted to let you know in case you wanted to address that separately.
Okay, yeah, thanks. Well, let's work on getting some witnesses. We have Bieber, okay, handled here, and then we'll probably just do that in line with when we take the witness.
So, Your Honor, from applicant's perspective, we're agnostic to whether you want to take other witnesses out of order. I would say resolving the issue related to the sir, and if anybody wants to question the witnesses that provided sir would simplify stuff for us too, but
okay,
it doesn't need to be before you take other witnesses.
Let's poll the parties about that first. That's fine. We still have we have time before 2. So yeah, that's good. Let's check if we have any questions for witnesses who filed sir. First of all, let me ask if the just generally speaking, any objections to the sir?
Judge, this is Krista Westerberg for Walnut Way.
Okay.
I just have a general objection to the practice of submitting sir rebuttal on the morning of the hearing. I think in past proceedings I've been involved in, the sir rebuttal has at least been submitted by the 1:30 deadline prior to the hearing date, if I'm remembering correctly. And I think that's a better practice because then we are not having to spend the time during the hearing reviewing sir rebuttal testimony. I also think it's inconsistent with the facilitating matters order. I understand there is some benefit to having the written sir rebuttal so that we don't take time in the hearing saying basically the same thing. But I would appreciate, I just want to lodge the objection that at the least it should be submitted the day before to make the day of the hearing more efficient. And I think it's just, it's a practice that if it continues could affect hearings going forward. Thank you.
Oh, okay, thank you. I appreciate that. Anyone want to respond to that?
I have a brief response. I don't want to respond as much as I did in the WPSC hearing, but I think this is like my 10th or 12th rate case, and I've never heard of having the sir deadline be 1:30 the day before. We've literally handed it out to the other parties as the witness takes the stand prior when we were in person in Madison. And again, the entire intent is to help the other parties to understand the testimony that those witnesses would put on the stand when called to testify. And we think it is beneficial to the other parties. There's no prejudice to it. It's just a simplifying and time-saving practice. So that's my brief response. I know we talked about this in more length in the WPSC hearing.
Yeah, okay, and so looks like we're off the record, just so you know. So we did note, so let's get on the record. So I can have you repeat your objection, Attorney Westerberg, if you'd like, or I could just, why don't you just give us that again.
Your Honor, so Walnut Way had objected to the sir rebuttal coming in the morning of the hearing for a couple of reasons. It's counsel's recollection in past cases, the sir rebuttal, if it has come in the day before the hearing at the 1:30 deadline, which makes things more efficient because then we don't have to spend time during the hearing for people to review the sir rebuttal. It also appears to us to be inconsistent with the language of the facilitating matters order, which requires evidence to come in at the set deadlines. provided in the order and in the scheduling order as well. I think those are most of my objections, but the basic concern is that it's inefficient and it's to some extent unfair.
Okay. Do you want to repeat your response, Attorney?
Yes, Your Honor, if you don't mind.
Yeah, go ahead.
I'll be brief because we discussed it at length in the WPSC proceeding, but I think that's an inaccurate characterization of past proceedings. We kind of polled the room, and I think some of us go back 40 years maybe in utility practice and are unaware of a requirement to give the SIR the day before. I've literally personally handed it out as the witness takes the stand. Witnesses are permitted to have direct testimony when they're called to testify. From our perspective, it's time saving and eliminates any potential prejudice or surprise to the other parties by providing it in written form.
Anyone else want to comment?
Your Honor, if I may be heard, Megan Walkscross on behalf of Sierra Club.
Yes, I don't know if I'm getting a little interference there, but go ahead.
Can you hear me a little bit better now? I'm not sure.
And maybe it's actually a little too loud. Could be yeah, that's okay.
Okay.
Okay, go ahead.
I would just reiterate the concerns that were raised in the hearing last week. And I would also note that there were some strenuous objections to Sierra Club introducing any new information on redirect in the course of, in response to cross-examination. And so the timing of the SIR rebuttal and the ability to prepare for direct testimony in response to that SIR rebuttal does matter quite a bit in terms of who gets the last word, basically, in introducing new information, given the utility's position on what is and is not a fair scope on redirect in the course of examination of witnesses.
Okay. Anyone else?
Yeah, this is Kara Coburn Ferris from CUB. I would just note that, regardless of the utility's characterization of past practices, the merit of giving other parties testimony, when they don't have time to review it, does not seem strong, and it seems to be counter to the facilitating matters order that clearly require that the utility or all parties provide any document not previously on offer to the commission and parties by 1:30 the day before. And if the utilities were able to provide their SIR at that time, I don't think we would be so concerned, but there's a real due process concern with getting that, particularly for parties that don't have multiple counsel and don't have legal assistance and paralegals and such to help them manage other aspects of hearings.
Your Honor, I have a brief response to both of those comments, if you don't mind.
Sure, go ahead.
Our understanding of these hearings is that you're allowed to provide additional direct testimony on the stand. So in lieu of providing this additional direct testimony on the stand, we have provided written SIR rebuttal testimony at the beginning of the hearing. That is different from redirect. Redirect is supposed to be within the scope of the cross. Additional direct is supposed to be within the scope of the SIR rebuttal testimony that's pre-filed. All of our SIR is within the scope of the SIR rebuttal testimony that was pre-filed. We tend to get quite a bit, as you would expect as the utilities. And to simplify our on-the-stand additional direct for the parties, we prepare and file and serve pre-filed written SIR. That is a time saver for the parties. It eliminates prejudice for the parties. There's absolutely no due process concern because those witnesses could get on the stand and be read those questions and provide those responses on the stand. So anytime that you get to review that testimony is a boon. And if there's going to be significant objections to that, we will just come and read the testimony on the stand in future proceedings. So You're getting more than is required under the facilitating matters orders as it stands. And if there's going to continue to be significant objection to it, we will go to a process where those witnesses are called and testify live, which will extend these hearings.
Okay, well, what I could say is we don't have any specific objections to the SIR that's been offered here. So that's one thing. I'm sensitive to everyone's comments here. This is not a perfect process. It's certainly do not have a magic wand solution for this problem. But I think the situation that we are in here is that I think seeing the SIR rebuttal in writing does have its benefits and of course has its drawbacks to some extent. I think what really matters to me, we're looking at whether this process is fair or not, is the degree of information provided in the SIR. So I've always mentioned the touchstone is that if it's in place of someone speaking testimony on the stand, it should generally appear that way. So if it's a simple, the questions should be, in my mind, the quicker the answers can be, the more succinct it can be, the better. And once someone starts putting something in writing, it can get very detailed and very complicated. Someone's on the stand and speaking from their memory, speaking, as they sit in the hearing room, that testimony tends to have a different tone and a different, it's just done in a different manner. So to have someone provide, it's a matter of degree, it's a matter of volume and in terms of address and in terms of how the SIR is presented. So, it's going to be a balance, and the timing is not ideal, and the standard is very squishy. But I think we've done a pretty good job balancing by allowing parties this time here today to review. But yeah, the alternatives is certainly there's a right to present this testimony live at the hearing. That's what's contemplated in the FMO. So I think you have to weigh the benefits and the negatives in terms of saying, well, if I was just to hear this on the stand, how would I be able to respond to it? I think there is still a value of written SIR. I just, we get to the point where how many rounds of testimony am I going to put in the schedule? It just, we could just be having infinite amounts of rounds up until the last second of the hearing, I suppose. So I don't want to start another round of testimony being scheduled. I would say that, especially in this case, I was kind of surprised to see this come in at the time it did, so close to the hearing, because I believe there's not that much difference between what was submitted earlier in the pub service case and this case. So perhaps the testimony could have been filed earlier, but again, the alternative is to listen to the testimony being spoken on the stand, which is something I've ordered applicants or utilities, possibly these applicants, to do in other cases, saying, no, I don't want you to pass this out and have people digest it, and we're going to read it, question and answer on the record. I don't think it was any different in terms of the benefit or the time it took. Any due process problems seem to be exactly the same, because you're now still trying to prepare a response and digest the testimony as it's being spoken. So yeah, I think we're doing the best we can in the situation. And the only thing I think that I'll mention is that probably what would benefit the record in many ways, in terms of the filings, in terms of getting people organized, people prepared, getting, like I mentioned, the filings, I mean, accurately filing these documents, would be having more time in the schedule. And I think parties seem to be frustrated by it as well. I think all parties are tending to feel that the chafe of this enhanced pace. So I would, I think that would benefit all of us to have more time in these cases, which may mean a later decision date. But that's the only real solution I can see to the rush that we face and the real pressures that we're getting when these cases stack up. And these two cases, a pub service case and the case today, are highly detailed. There's lots of documentation, lots of preparation, but this is not the only case. So we've all been together for other cases recently, and we will continue to be. So yeah, to have more time is always would be a very beneficial change to the process, but that's not quite in my hands. So otherwise we don't really have a solution, but to do what we can and to try to adjust as necessary when we're faced with something that may need to be corrected, something that comes in late, something that's not filed appropriately. But I can hear individual objections when that occurs, but I think generally speaking, the process of certiorari rebuttal, getting that in writing, is something we've been working with and has worked in the past. If people do have ways to modify that, I think the 1:30 deadline may have some benefit, but I think again, I've seen this work before, and if it's something that parties can agree, that they won't need time during the hearing if they can get these filings in the day before. That's something I would consider. Maybe we can discuss that at a pre-hearing conference in terms of being able to eliminate some of the hearing time for review of the certiorari. But in this case, I think we're okay. We haven't had any specific objections to these filings. So having said that, I think we can ask whether there are questions for witnesses who filed certiorari. Any cross? So let's start with Bulkley.
Your Honor, sorry to interrupt. This is Krista Westerberg again. I didn't, I would have had some specific objections to some of the certiorari rebuttal for Zagonic and Mr. Stasek. Basically because even though they are couched in terms of responses to the certiorari rebuttal from Mr. Colton in particular, they don't make any new points that haven't been made in prior testimony. They're repetitive, they're duplicative. And I think that is an illustration of why the practice of certiorari rebuttal is a little bit problematic, because it encourages more and more. It's like when you add a third lane on a highway, people will fill it. So I feel like that is what we are seeing with those witnesses, and we can wait till we get to those witnesses, or I can give you the pages and lines now.
Sure, let's wait till those witnesses. That's fine. Yeah, duplication certainly something we need to be concerned about. So it's Stasek and Zagonic.
Yes.
Zagonic? Yeah.
I believe it's pronounced Sagance, Your Honor, but
Zagance. Okay, thanks. Appreciate that. I will continue to get it wrong, unfortunately, whether I like it or not, but Zagance. Okay.
understood. I just thought I would mention that when I heard it.
I do appreciate that. So Bulkley, am I saying that right? Any questions? No? All right. So we can accept that testimony with affidavit, and I just want to be sure we have all 45 exhibits, direct rebuttal, surrebuttal, and certiorari rebuttal. Okay. So I've not reviewed the certiorari rebuttal for formatting issues. If I'm assuming these are substantially the same as in pub service, so there's any notes that I gave in the pub service case, please carry those over.
Will do, Your Honor. Thank you.
Great. Korducky, any questions for Korducky? No? Okay, so we have direct rebuttal, certiorari, 16 exhibits. Okay, so we can accept that testimony with an affidavit. Lambert, any questions? Okay, we have rebuttal, surrebuttal, and surrebuttal. I can accept that testimony with an affidavit. Okay, so Megna, there might be some statements from Megna. Nelson.
Nelson testified, Your Honor.
Oh.
I think we're to Becca, who I believe staff had some questions for.
I'm sorry, what was that name, Mr. Park?
Pekka, P-E-C-H-A.
Thank you.
And it's
That's correct. Staff does have a few questions for witness Pekka.
Okay. All right. So now to switch gears, let's try. So what we'll have then is the rest of our witnesses are excused. Ones we just reviewed, Bulkley, Korducky, Lambert. And we will take the remaining witnesses in just a minute. Let's hear from.
So, Your Honor, before we move on from that, we could address Mr. Megna. Our understanding was there weren't any questions for him and that we addressed the inaccuracies in the off-the-record session about the offered evidence list. But if people do have questions, certainly he would be available. Otherwise, we would ask that he be excused and submit by affidavit.
Okay, I didn't notice. Did he cover that background information in Sir? One of the questions I was asking.
Oh, Your Honor, if you want us to, that's up to you. I guess we could offer him again as you did for your questioning, as we did in the WPSC case. Otherwise, I think we understand where you were going with that and could submit some, I suppose, supplemental rebuttal testimony, but it's up to you.
We'll just have him make the statement on the stand. Yeah, that's
okay. Thank you, Your Honor. Yeah.
So let's just
so he's
down.
Available too.
Okay, great. Let's skip to Microsoft because we have a 2 p.m. request before 2 p.m. Let's get them up here. I see Attorney Brewer. Do we have Witness Stevens here?
Yes, I'm here. Can you hear me okay?
I can hear you, but I don't see you. Ah, there we go. Okay, great. There you are. All right, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead.
All right, good afternoon, Mr. Stevens. Can you please state your full name?
Robert R. Stevens.
And where are you employed and in what capacity?
I work for Brubaker and Associates, Inc. as a senior principal.
And have you prepared and caused to be filed in this proceeding direct testimony consisting of 6 pages and 2 exhibits and surrebuttal consisting of 2 pages?
Yes.
Do you have any corrections to your testimony today?
No.
And if I ask the questions set forth in your testimony today, would your answers be the same as in your written testimony?
Yes.
The witness is available for cross.
Okay, did you mention 2 exhibits? I don't.
Yes, direct
Okay.
and 2
All right.
exhibits.
Okay. All right. So any questions for this witness? Nobody? I did have a quick question for you, Witness Stevens. I was just curious because you did make some forward-looking statements that involve plans that Microsoft has. And I just wondered do you speak for the company?
I don't speak for the company in terms of their sustainability plans per se. Rather, I've provided a document that explains those.
Okay. And okay, so all of your testimony regarding the sustainability plans are based on the documents that you filed.
The documents that I filed and whatever conversations I had with Microsoft and their counsel.
Okay, but when you're saying Microsoft has certain plans, they're not commitments you're making for the company with respect to this proceeding and with respect to Wisconsin.
That's correct.
Okay. Do you know of any plans? So there were some statements made about enhancing sustainability, generally speaking, in those documents and in testimony. bring out an example, but I don't know if we if you really need it. Okay, so for example, the sustainability goals mentioned on page 2 of your rebuttal. I was just curious, are there any specific plans that you know of Microsoft has that relates to Wisconsin?
Excuse me. The plans that I'm aware of that relates to Wisconsin is to try to have the rate, the special tariff that is mentioned in my direct testimony approved. Such tariff which, if approved, would allow Microsoft to enter into agreements for certain kinds of facilities with WEPCO that would assist Microsoft in seeking to attain its reliability goals. I'm sorry, it's carbon-free and sustainability goals.
Okay. Okay, that's the extent of your knowledge.
Yes.
Okay, all right. That's all I had. Anyone have questions about that? Those are the questions I had.
This is Krista Westerberg for Walnut Way. I do just have one brief follow-up question.
Sure.
Mr. Stevens, as you just heard, I represent Walnut Way, and I think you had read and responded to in your rebuttal the testimony of Mr. Antonio Butts, correct?
Yes.
Okay. And you might recall Mr. Butts had suggested some sort of community collaboration or community benefit agreement between Microsoft and the utility and community groups as a suggestion for his testimony. Are you able to say whether, given the limitations you just described as to whether you speak for Microsoft, are you able to say whether Microsoft would object to entering into a collaborative like that or an agreement like that?
I'm not aware of any objection, but it would be more appropriate for Microsoft counsel to address that in brief.
Thank you. That's all.
Okay, yeah, not sure if that's a legal briefing issue, but we'll read the brief and see. Okay, that's all. Any redirect?
No, Your Honor.
Okay, great, thanks. All right, thanks very much. You're excused.
Thank you. I appreciate it, Your Honor.
All right, take care. Okay, so let's move back to WEPCO. Yeah, WEPCO. Who do we want to take next?
Your Honor, applicants would call Steve Pecca next and just have to reset a little bit over here.
Sure.
Thanks.
Ready, Your Honor?
Yes, just changing names here. Okay, so let's begin. I'll swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, great. Go ahead.
Mr. Pecca, did you submit written direct rebuttal, rebuttal, and rebuttal testimony in this case?
Yes, I did.
Did you also sponsor and submit 3 exhibits?
Yes, I did.
Is everything in your testimony and exhibits true and accurate to the best of your knowledge?
Yes, it is.
And if I asked you the same questions in your written testimony, would your answers be the same?
Yes, they would.
This witness is available for cross.
It looks like I'm missing an exhibit from the list. So where do I get the?
Yes, Your
exhibit?
Honor, the 3rd exhibit comes from Mr. Pecca's rebuttal testimony. There's sponsored in it, I should say.
Oh yeah, there we go. Oh, I see what happened. There we go. All right, great. Okay, so yes, let's seeing all the documents there. I can accept those on the record. Any cross for witness Pecca?
Good afternoon, Mr. Pecca. Evan Whites on behalf of commission staff. I just have a couple of quick questions for you. First, I wanted to start with some questions about your rebuttal, page 3, if you have that in front of you.
Yes, I do.
Okay. Starting at line 17, I guess you're responding to some issues raised by Commission Staff Witness Kraft. And you're talking about the spending on the storm hardening projects in 2024, correct?
That is correct.
And I just wanted to walk through this to make sure I understood it correctly. So for the first 8 months of this year, the average spend was 3.2 million per month, right?
Yes, that is correct.
And then you stated that to get back to budget, the company would need to spend $4.6 million per month for the remaining 4 months, right?
That is correct.
And that would only be doing the math on those numbers. That would just get back to the roughly $44 million 2024 budget, right?
Yes, that's correct.
That would not bring the company back to the underspend from 2023.
That would not include any additional spend beyond 44 million to complete the work that is on track this year.
And I guess that brings me to the next area I wanted to explore. I'm just trying to understand because it seems to me some confusion about the number of projects and from what year and when those projects are being undertaken. I think that's quite a bit of your testimony was talking about some of the delays to the 2023 projects and that some of those are now being completed this year. Is that fair to say?
Yes, it is.
So I was just wondering if you knew or could provide to kind of cut through some of this back and forth and give some clarity to the topic, the exact number of projects that the company is intending to complete this year in 2024.
Yes, I can do that. And that is included in page 2. Although not the details, we have a total of 15 undergrounding projects scheduled to be completed this year and 46 total sectionalizing and automation projects that are scheduled to be completed this year. So we had 3 additional undergrounding projects added to the 2023 projects that were originally scheduled to be completed. Those are complete at this time. We have 9 total undergrounding projects completed, 6 that are remaining. And then of the sectionalizing automation projects, we had 46 total projects, 19 originally planned. We pivoted, as I discussed, in relation to some of the supply chain shortages. We added 27 additional projects, sectionalizing automation projects. Of the 19 original projects, 12 are complete, 4 are currently in construction, 3 are wrapping up design, expected to be complete by the end of 2024. And of the 27 additional projects, 21 of those are now complete and 6 are in construction and expected to be complete by the end of the year. So those totals should reconcile out to the total that was in my prior testimony.
So I guess I'm still trying to unpack that a little bit. So if we're just looking at a high level, is combining both the undergrounding and sectionalizing projects, is that, you said 15 and 46, so is that a total of
61? Yeah, 61
projects for the year? Okay.
Yes.
I'm sorry, Mr. Weitz, I didn't hear the entire question. So
Is
that
that a
is that a total of the,
of 61 projects for the year?
and your answer, sir?
Yes, that's correct.
Thank you.
So of those 61 projects for 2024, how many of those are 2023 projects?
Those are of the 2020, 15 of those are undergrounding projects, are 2023 projects, and 46 of those sectionalizing and automation projects are 2023 projects. These were projects that were pivoted to in 2023 due to the supply chain shortages with pad mount transformers.
So of the 61 projects for this year, all of those were carried over from 2023.
Yeah, some of those were completed earlier this year. Those were included in our post-construction report that we did file this summer that summarizes all the projects that were completed by March 31st of those initial 2023 projects. So we do have an overlap of work as you indicate between 2023 and 2024.
So if I'm understanding correctly, then there's no new projects for 2024. These were all projects that were delayed from 2023.
Some of these projects were added to 2023 to be completed in 2024 due to the supply chain shortages. So the total 61 projects are the total number of projects we have planned in 2024. Some of those were 2023 and additional projects were added to be completed as part of the 2024 plan. So there is a mix of those projects.
I guess maybe I'm still not quite understanding this point. In 2023, there were supply chain issues that caused the company to pivot to I guess some different projects because of, I think it was pad mount transformers or something like that. There were some supply delays. So some additional sectionalizing projects were added in 2023, right?
Correct. We added 27 additional sectionalizing and automation projects to the original 19.
So that gets you up to the 46 total projects.
Correct.
But those were added in 2023.
They're correct. They were added in 23 for, again, the construction schedule is a multi-year schedule. It'll begin in 1 year, conclude in the following year or subsequent year. Those schedules are different for undergrounding projects, which may be up to 2 year overall schedule from scope through design, permitting, easement, construction, and closeout. Distribution automation, sectionalized automation projects generally are a little bit shorter than that, 12 to 18 months.
Okay. So there were no new projects then identified in 2024. It was just getting caught up on those previously identified projects.
Yes, that would be accurate.
Okay. Are there any 2023 projects that would still be remaining to be completed in 2025?
No, my expectation is that all of these projects that were identified in 2023, including the additional projects, would be complete by the end of this year.
Okay. Are there any projects that were originally slated for 2024 then that would be carried over into 2025?
Yes, there are undergrounding projects in particular that were delayed that will be completed in 2025.
Do you know approximately how many?
I do not have that readily at hand. I would estimate of the just take a quick.
Let's go off the record for a second.
So in 20.
And we'll get on the record. Go ahead.
Okay. So the project list, we have 31 undergrounding projects scheduled in 2025 and 56 sectionalizing automation projects scheduled in 2025. That is in the Exhibit 2R. 87 total projects. I would estimate about half of those, looking at the project list, were carryovers from 2024 into 2025 due to the timing, as I explained in the project schedule.
And for some of those projects, you said they take either 18 months or 2 years from start to finish. So would any of those 2024 projects carry over into 2026 as well?
My expectation is that they would not carry over to 2026 based on the current supply chain stabilization that we've seen in the last half year.
All right, thank you. I don't have anything further.
All right. Any other cross? Redirect?
No, Your Honor.
All right. Thanks very much. You're
I'm
excused.
sorry, who said that?
Oh,
Who said no?
Attorney
Lauren
Zank.
Zank, attorney for applicant.
Who said that? Oh,
Lauren
mistake.
Zank.
Okay. You know what? I'm looking for a lit up box. That's why I couldn't
Yep.
find you. I apologize.
Nope, sorry for the confusion.
So off the record, I can hopefully maybe, oh, you're excused. I think I said that, did I? But-
Now you did.
Now I did. Okay, there you go. I did want to mention it may be helpful if you go in Zoom, there's a view setting. And I have a updated software update a couple of weeks ago, maybe. So if you're using the program, not the website, I think if you're using the program, you'll be able to see it. You can switch to multi-speaker, which puts whoever's speaking a few words up on the top of your screen, and then puts everyone else sort of in smaller boxes below those people. So I don't know if you have that setting, but if you have if you're using the downloaded version, you should be able to click multi-speaker. It is pretty handy there to bring people up who are speaking. So just a tip for you guys.
Thank you, Your Honor.
So let's get back on the record. We had Pekka, and who's next?
My apologies. I had difficulty unmuting myself. We're calling Dave Megna.
All right, let me just adjust the names here. I'm drawing a blank on your name.
Oh, Dave Megna, Megna.
And your name?
Oh, Kate Phillips. I'm sorry.
I don't know.
No
I was thinking
problem.
Redwind, maybe. Redwind.
That's probably a good thing, Judge. You don't call my name today.
No, it's very embarrassing, actually.
Okay.
All right, so here we go. I think we have everything set up, and I'll swear you in. Let's go ahead. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
All right. Mr. Megna, please state your name for the record.
David Megna.
For purposes of this proceeding, did you file or prepare to file direct rebuttal, surrebuttal, and surrebuttal testimony?
Yes, I did.
Subject to the corrections, if I were asked you the questions contained within your testimony, would your answers be the same today?
Yes, they would.
Your Honor, we also had the one exhibit, but I believe we struck that exhibit. So Mr. Megna does not have any exhibits. But,
Okay. That looks like we have the set of documents in front of us on the authored evidence list. So, okay, so that's all the documents we have. We can accept those for the record pending the corrections we need. Is the witness available?
yes, Your Honor, the witness is available for cross-examination.
Okay, any questions? Parties and staff? No, okay, I did want to just complete the record here based on last week's hearing for Wisconsin Pub Service. I did ask you a few questions, witness Megna, and you responded with some background on the forestry management program, just to benefit the record. I guess it may be quicker if I ask you if you recall those statements, and if you could summarize them for us, or I can ask you a few questions. Either way.
Yes, I do recall those questions.
Okay. So can you give us a summary of the background information about the forestry management program?
Absolutely. So one of the questions was, when do we trim our trees that are embarking on our distribution lines? And typically, as trees become a hazard, as they get close proximity to our distribution lines, that could be anywhere between touching or within 10 feet, we typically trim those trees. In some cases, we are removing trees depending on if it's a healthy tree, it can withstand any kind of wind or severe storms. But if they're weak trees that are diseased or dead, we will either top them or to remove the hazard from our electric distribution lines, or we will take them completely down to the ground. In the case of topping them for a customer, we will typically get them below our distribution line so that they can be safely removed by a private tree contractor, because our distribution crews or our forestry crews are really the only ones that can work within 10 feet of an electric line due to OSHA regulations. So we'll top the tree, make it safe, and then private contractors can remove the line or remove the trees safely for a customer.
Okay. That's all you have prepared? So I just had one other question. I think we had mentioned in the pub service case related to the estimates for forestry management in the test years. And I just had asked you whether the figures provided delineated between topping trees and removing failing trees. Can you provide the answer to that?
Yeah, on the We Energy side and Wisconsin Electric side, there the cost is significantly higher than Wisconsin Public Service Corporation. And the work that we've done for customers to safety zone trees is somewhere in the area of about $5.3 million. Overall, that includes some removals, but mostly just topping so they can be safely removed by a private tree contractor.
Okay. So, but that figure is inclusive of both types of management, topping and removing.
That's correct.
Okay. All right. Okay. Great. Just want to make sure that we had this offered for the record in both cases. So I appreciate taking the time to do that. Any cross-examination based on what we just heard? No. How about redirect?
No, Your Honor. No redirect.
Great. Thanks. All right. Thank you very much. You're excused.
Thank you.
Okay. Who's next?
Good afternoon, Your Honor. Applicants would call Mr. Joe Zagans who will stand next. I know there were some preliminary things that Attorney White's thought you might want to address off the record. Happy to do it on or off the record. It's up to your preference, Your Honor.
Yes. Hang on. Please spell your name right, and then I'll. There's a C in there, isn't there? Okay. All right, let's swear him in. So raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Thank you, Your Honor. Mr. Zagans, would you state your name for the record, please?
Joseph Zagans.
And Mr. Zagans, did you prepare direct rebuttal, surrebuttal, and surrebuttal testimony in this proceeding?
Yes.
And subject to some corrections that we discussed on and off the record today, if I asked you the questions contained in your direct rebuttal, surrebuttal, and surrebuttal under oath, would your answers be the same as they were in your pre-filed testimony?
Yes.
And Mr. Zagans, did you prepare and cause to be filed 9 exhibits?
Yes.
And are those exhibits true and correct to the best of your knowledge?
Yes.
And Your Honor, I'm forgetting right now what Zagans 10 is. I'm just going to try and refer to the note quick.
Oh, yeah, that was changed to Gerlikowski 4.
Oh, okay.
Yeah. So that's
Thank
no
you.
longer there. Yeah.
So my understanding is, Your Honor, that Attorney White's had maybe a proposal to make with respect to Mr. Zagance's sur rebuttal. I think it would be appropriate to discuss that prior to me tendering Mr. Zagance for cross.
Yeah, sure. So let's take the issues with staff first, and I think Walnut Way also had an objection to Sir, so we'll take those in turn. So
Your
yeah,
Honor, I think Attorney Proctor Brown's point was the argument as it relates to Exhibit 9.
right. So go ahead, Attorney Whites. Did you have something?
I would just kind of supplement what I said earlier. I still have some of the same concerns about the belated nature of the filing and staff's ability to analyze it and respond to it. I do think that there is, in the interest of completing the record, some arguments in favor of its inclusion because it sort of fleshes out in greater detail the figure, the $600 million estimate that was in Mr. Zagance's I believe, rebuttal testimony. However, what I would propose is that analysis really only quantifies the cost of one side of a decision point that the commission might be faced with or might be deliberating on. And on the other side of the decision point, if the commission would make kind of the flip side of that coin in terms of their decision, there could be costs on that side as well. So in the interest of preparing a complete record and not kind of snowballing into a back and forth beyond this, what I would propose is that staff be allowed to submit an exhibit by the Friday testimony deadline, just essentially in a similar type format, quantifying the cost to maintaining the existing credit rating rather than Mr. Zagance's exhibit, which quantifies from the applicant's point of view the cost of a credit downgrade. That way the commission would have similar quantification on both sides of that decision point, and I don't think we need to go into any additional detail. I think the other issue that I brought up as far as whether or not witness Tierney agrees with Mr. Zagance's conclusions, I think that could be addressed today. But I just don't know that today staff could present that numerical quantification to essentially present that other side of the position.
Okay. So I think essentially you're proposing another additional Tierney exhibit. And let's see what we have here. So that would be Tierney 7.
Correct.
Okay, so we'll just mark it for now. We can have the witness explain. We'll have Tierney explain that when it's witness's turn. But as far as the concept there, are there any objections to that?
From applicant's perspective, Your Honor, I think that makes sense. It's our basic understanding that Mr. Tierney has already presented the costs in his and Attorney White's framework, the benefits, I guess, of the credit changes that he proposes. So my understanding would be that he would just be summarizing those pre-existing schedules in a new exhibit, which we have no objection to. I mean, if we're introducing a new concept of the benefits, I think then it would need to have some sort of testimony accompanying it. And I don't want to go down to that snowball. What ultimately I think happened here is Mr. Tierney presented some benefits to customers in his direct testimony, asked for additional information from us. Mr. Zagance had some testimony about that, and then just failed to put in the submission that has the detailed analysis. And so I think it makes sense to have this exhibit, and we wouldn't have an objection to it if that's the framework that Attorney White's is proposing.
Okay, well, yeah, go ahead.
I was going to say that's my understanding as well, that it wouldn't be a new analysis, but I guess the issue is that the way that it's presented in Exhibit Zagance 9 isn't an apples and apples comparison to the way that it's presented in some of the other staff exhibits and schedules. So kind of doing the analysis to present it in an analogous format so that the two could be compared essentially side by side would be the purpose of that exhibit.
And just I think from applicant's perspective, I think that makes some sense. Again, it's our understanding this is kind of an alternative to the staff's position in the case in any event. So makes sense to have a summary exhibit like that.
All right. So I guess one way to cure any concerns about what might be in the exhibit is when it's filed, we can treat it as if it's a request for leave for additional evidence. I don't think you need to file the motion for that or the request because we're all here debating this. But essentially what that says is that if someone has an objection, there's 3 working days to file an objection if we're kind of triggering that process. So we'll just do that here so that we have that process in place. We don't have to make it up if it's needed. It's already in place. So just in case something comes in, if it's unexpected in some way, that'll be how we can handle that easily. But failure to file any sort of response is in agreement to it. So just if you want to accept it, then just stay silent.
I think that makes sense, Your Honor, too. And just to put the dates around it for my own, just so we're on the same page, I think the exhibit will be filed on Friday, and that would give us till next Wednesday or anybody to object to that. So that.
Yes, 3 working days. So so I'm triggering the process that's in the FMO for leave for additional evidence. Yeah.
Thank you, Your Honor. Appreciate that a lot.
So I did wonder if maybe we're missing something. Make sure we're not missing something, which is the statement of the does not dispute statement on the Sur rebuttal Zagank 2. Is that something staff is comfortable with, or is that does that go too far in terms of reading into what witness tyranny understands here?
Your Honor, at that point, I think we can clarify when witness tyranny testifies. So that I thought we could handle today. It was just the actual substantive exhibit with some analysis and things that can't be done on the fly on the stand. So.
Okay, well, I'll leave that up to you. That's fine. All right, so now let's move on to Walnut Way's objection.
Your Honor, Krista Westerberg again for the record. And I should say also that we were not in the WPSC hearing. I know you know that, Your Honor, but just for the record, we were not there. So some of this we're walking into a little bit with the Sur rebuttal. But the main objection is that the points raised on pages 8, the entirety of page 8 and page 9, the entirety of page 9 are duplicative of information in Mr. Zagank's rebuttal at page 40 to 43 and Sur rebuttal at pages 14 to 15. And it just dovetails with our point that the ability to file Sur rebuttal isn't really adding a lot, or Sur rebuttal isn't adding a lot substantively to the record. They reiterate the same points and criticisms that they have of Mr. Colton's testimony regarding the LIFT program and their views of the proper accounting treatment for the LIFT program.
I'm sorry, the proper what treatment?
The proper accounting treatment for the LIFT program. Yep. So again, nothing really new of substance. It's more a matter, as I see it, it's just wanting to have the last word. So those would be our objections.
Okay, any response?
For me to respond? Yeah. So if that's true of our testimony, it's true of Mr. Colton's Sur rebuttal testimony. And in most legal practices that I'm aware of, the party that has the burden of proof does get the last word, and that would be us. So some of this stuff it's just obviously new, right? So any reference to his Sur rebuttal testimony couldn't possibly have been in Mr. Zaganc's Sur rebuttal testimony. The concept of netting was raised for the first time in Mr. Colton's Sur rebuttal testimony, so that's page 9. And And the idea that the summary of his rebuttal testimony also has to be new. And in his rebuttal testimony, he attempted to refer to his what he said as his participation in rate case proceedings back to the 80s, which I don't think he'd referred to in the past. And so we're rebutting the idea of this kind of appeal to authority of his long history in rate case proceedings, potentially not even in Wisconsin, in these pages of his testimony. It's 2.5 pages in Mr. Colton's rebuttal testimony. It's 1.5 pages in Mr. Zaganza's rebuttal testimony. I think that's entirely consistent with the sifting and winnowing that goes on in those rounds of testimony in these proceedings.
Okay. Anyone else?
I got a little bit fast there.
Okay, just take a deep breath here. Okay. Okay. Anyone else comments on this? No. Okay. So I mean, I guess I didn't hear if the objection was to then strike these pages. Was that the proposal?
We didn't articulate that, Your Honor, but I think that would have to be the result of the objection. So yes.
Okay. So, I mean, we faced this many times. I think the facilitating matters order already does instruct that we need not do a few things, which is to provide statements of prior testimony in the next filing, that they can be just referenced by citation, and there's also sort of the understanding that a party doesn't, or a witness doesn't retract or reverse a position unless the witness does so, affirmatively. So those are mechanisms to attempt to reduce the volume of testimony as we go through the rounds of testimony. So I would encourage everyone to apply those rules, but I've seen that parties do, and witnesses of all parties and staff do kind of present that summary of the other opponent or other parties' witnesses' testimony, and then goes through the analysis. A succinct version of that with a citation goes a long way. I've found in some proceedings where the question is worded, where you're saying you have a comment on a certain page of someone's testimony and just give a very brief topic, and then the answers provided, it actually helps the reader, because I think it refreshes their memory what's been said in the past, but it doesn't take a lot of time and effort to get through that narrative. And then if the reader needs some help, they can go to the citation. So in terms of duplication and repeating testimony, those are the current rules. I've not really, some point I was going through testimony and trying to police that, but I'm not going to do that anymore. I don't have the time for that. So in terms of that, that's what's been happening. It's not ideal. In terms of what we're seeing as terms of responses, what would be very useful is for the parties, and I'm going to do this going forward, but I think it's another situation where referring to a witness's prior statement, I'm not sure if I can pick out problems here, but it would be helpful if we get a citation to that witness's statement. So if Zagonk is responding to a rebuttal from Colton, is it Colton? If you have a citation, that goes a long way of saying, well, it's sir rebuttal, it's sir rebuttal, it's responding to what was said before. That really does kind of deflate an argument that it's not responsive. So I just scanning through this, I didn't see this. Okay, did see there's a citation. Okay. I didn't see citations everywhere, but maybe that's inclusive of the one that we just saw on the top. So,
Your Honor, for this particular piece of testimony, the intent of that summary is really just to pick out that there's 2 points that they're responding to, and then there's a final wrap-up question responding to those points.
Yeah, I'm not criticizing this in particular. I'm just saying these are the rules in place that help to try to deflate what the problems being raised are. So I do see some citations to surrebuttal. So that to me makes me feel comfortable that this is responsive. And it may be responsive with some duplication. To that extent, the FMO says, you can just respond by citing that you've covered it in prior testimony. And that if we want to make things shorter and more efficient, that would be helpful. If that's the extent that you have, that the response is being made, if it's just citing to prior testimony, you just need to provide that citation. But outside of that, the last word issue, of course, is possibly not exactly accurate because we will be taking witness Colton after the applicants. So if there is a response to this surrebuttal, that's testimony being given prior to witness Colton's appearance, and witness Colton can respond to it. So I think in this situation, I don't see the need to strike this. Again, if we're relating this back to issues with surrebuttal, written surrebuttal, we've already covered that. It's not the best, it's not ideal, but it works. And there's issues either filing this in writing or seeing it in writing or having it done on the stand. There's problems either way. But in terms of the last word, I mean, we're all going to be here at the hearing. We have witness Colton coming up afterwards, and certainly we'll all still be here after that testimony, but hopefully we can put this to bed with that round. So I don't see a problem with this particular filing. So we're going to leave that in. But I do appreciate going through the process to vet that. Okay, so we have Zagant. We did staff's issue and the motion, and we can ask if there's any cross. Does anyone have questions?
Staff briefly has a couple of questions for Mr. Zagant.
Okay, go ahead.
Good afternoon, Mr. Zagant. Evan Whites on behalf of Commission staff. I just have a couple of brief questions for you in relation to your surrebuttal on page 11, if you have that in front of you.
I do.
So at the bottom of page 11, you talk about the force majeure costs associated with some of the outstanding projects, right?
I'm getting there. 1 second, please.
Sure. Let me know when you're there.
I'm there now. Thank you.
You said surrebuttal, right?
Correct, surrebuttal.
I'm there now.
Okay. So that's what that paragraph is talking about, right? Is the force majeure costs?
Yes.
Okay. And in there, you note that when the company is faced with force majeure notices from developers, that there's a couple of choices. And I was just wondering if, without getting into the specifics of any, attorney-client privilege or anything like that, you could just walk us through how the company, the options available to respond to those force majeure notices.
Yeah, I'm going to refer back to my rebuttal testimony to page 36. So Wisconsin Electric and co-owners aggressively negotiate with the providers the change order topics themselves, that are actually determined to be force majeure events. And ultimately, the costs that are arrived on represent good faith, aren't they?
Your Honor, it's 36.
I'm sorry.
Sorry, I interrupted you.
That's okay. Ultimately result in good faith, arm's length transactions and resolutions to the unexpected problems. Absent that, then there'd have to be some type of legal remedy beyond accepting that force majeure item.
So I just want to unpack that a little bit. When you say aggressively negotiate, I guess what do you mean by that? Are you talking about the contract on the front end, or are you talking when you're provided these notices of force majeure cost trying to negotiate some sort of resolution of the amount, or what does that entail?
I'm not in the room when that happens, but it's my understanding it is the latter.
Okay. Are there any clauses in the original contract that would cover, I guess, the allocation of risk between the developer and the company as it relates to these type of situations?
I don't have the familiarity with the specific contracts to answer that question.
When you say that there's aggressive negotiation, I guess I still don't quite know what that means. Does that mean that the company is negotiating for a lower cost, or what is that?
Yes, it would mean either an expeditious resolution and least cost alternative.
Those are two different things. So I guess which is the ultimate goal?
I don't know if one supersedes the other.
Okay. In your sir rebuttal testimony, you mentioned that litigation could be a potential alternative, but as you write, potentially delay commercial operation of these needed generation resources.
Mm-hmm.
To your knowledge, is that the only downside to that particular approach?
I don't know other downsides. I'm not saying that there isn't. I don't know.
Do you know if there's a quantifiable cost as it relates to delay?
Specifically, I don't know. Generally, I would say that usually there is a cost associated with delay, any project delay.
And what does that stem from?
What would the cost from a delay stem from?
Right.
I mean, it would be, examples that I don't know apply here. Would it be, I guess, simply you're renting equipment and the equipment has to stand by for an extra day. But that's a very small, specific example. That's just an example.
Does the company look at the force majeure costs and the reasoning behind them and determine how that relates to, I guess, getting back to the contracts or whether they're reasonable?
Yes.
Do you know if there's a set criteria for how that's evaluated?
I'm not familiar with the set criteria.
Thank you. I don't have anything further.
Okay. Any other cross?
Walnut Way has a little bit of cross, Your Honor.
Okay, go ahead.
Thank you. Good afternoon, Mr. Zaganek. As you've heard, I'm Krista Westerberg here on behalf of Walnut Way. I'd like to direct you to your direct testimony, pages 9 and 10 of the public version is what I'm looking at.
Yep, I'm getting there. I'm on page 9 right now,
Okay.
although I have the confidential version in front of me, not the public.
Careful.
I'll look for the highlights.
Yeah.
Hopefully they're there.
I just had a question for you about line 16 on page 9.
Okay.
Where you talk about the significant increase in bad debt, which is projected to more than double for WEPCO Electric since the 2023 test year. And you summarize the $33.7 million figure as part of the 2025 revenue deficiency. Do you see that?
I do.
I just want to know, does the term projected refer to, or is it intended to include the lift credits?
So
When you
I'm
use,
I'm gonna refer to my exhibit 3 just to refresh my memory on what the expense is in the test year.
Make a lot of sense to the viewer, but that's okay.
So I'm, all right. Thank you for the time. Could you please ask the question again? I'm sorry.
You can read it back.
Question, I just want to know, does the term projected refer to, or is it intended to include the lift credits?
So I'm not sure what's precisely meant by the lift credits.
is it intended to include bad debt attributable to the lift program?
Yes.
Okay, and then on page 10, I have the same question. On page 10, line 11, when you're referring to the underlying bad debt projection for test year 2026, that's also intended to include lift credits.
Yes, it's an all-in number. It's the projected bad debt, including the impact of lift.
Okay. I want to switch gears a little bit to the cost for outside legal expenses that the applicants are seeking for the 2025 and 2026 test years. You had provided some testimony on that issue in response to Mr. Butts, correct?
I believe it's rebuttal testimony.
Right, and I want to ask you, have you actually looked at a portion of the testimony from Mr. Butts?
Have I?
Page 5 of his direct.
I don't have a copy of that in front of me.
I think that Judge Newmark can pull that up, otherwise I can read it to you.
I'd probably prefer it to be pulled up if that's acceptable.
Yeah, just give me a minute. Go off the record for a second. So it's direct 4 or 5.
Direct pages 4 and 5. Yes, please. And are you able to see that, Mr.
Are you back on?
Yeah, let's get back on.
Sorry. Go ahead.
Mr. Zagak, are you able to see the bottom of Mr. Butts' direct testimony, page 4, and a portion of the top of page 5, where he summarized?
Yeah, I see rows 15 through 19 on page 4 and rows 1 through 3 on page 5.
And would you agree that those lines summarize the amounts that, and then on following on a little bit on page 5, summarize the amounts that the applicants are seeking for legal fees for outside expenses in test years 2025 and 2026?
Objection, Your Honor. This is self-summarizing some DR responses. I'm not sure that this is appropriate in cross to confirm the accuracy of DR responses that are in front of him, but.
Trying to understand, make sure that the witness understands the amounts.
Okay, I'll allow it. Do you need me to show you something else though, or do you have something in front of you?
I can rephrase the question too. This might make it a little easier.
Rephrase, you said?
Yes.
Okay, I just want to make sure the witness is seeing the testimony because I don't know if I can display it all on one screen. So have you seen what we're talking about here? Page 4 and 5?
I think so. We could just scroll up a little bit so I could see the beginning of the answer.
Sure, yeah.
Thank you.
Okay, yeah. So did you want to rephrase your question, Attorney Westerberg?
Yes. If we can scroll down onto more on page 5.
Okay.
Thank you. Lines 8 and 9, the testimony states that WEC anticipates spending approximately 1.5 million in legal fees for each year of the upcoming test years. Do you have any basis to disagree with those amounts?
I have to defer to the data. If that's what the data request says, I believe the data request to be correct.
Are you able to say, sitting here today, what portion of that amount would be attributable to attorney's fees, outside legal expenses for rate case proceedings?
I am not.
But you would agree that otherwise the outside legal expenses can include expenses for any legal issue that the applicants might have, like be it employment and labor or intellectual property or other regulatory issues.
Would you repeat the question, please?
Let's read it back.
Thank you.
Question, but would you agree that otherwise the outside legal expenses can include specifications for any legal issue the applicants might, might have, any legal issue that the applicants might have, like unemployment, or is it unemployment? Employment, because it looks funny here. Labor, property, or other regulatory issues?
I'll just object to the extent that implies we have issues related to those things. I think any business has legal needs, but I don't believe that we have legal issues that require that kind of a characterization.
Okay. Yeah, and maybe just rephrasing the question may be helpful, because I guess I'm having a hard time parsing out the different pieces. I think I know what you're trying to ask, but I think the answer would be better if the question was just phrased a little bit differently.
Sure, I can re-ask it.
Yeah.
Mr. Zagak, would you agree that the outside legal expenses that the applicants are seeking in this case include not just regulatory issues at the Public Service Commission, but also other legal needs such as employment or intellectual property or other regulatory issues?
Yes, I don't know specific issues, but it is the legal expenses that applicants anticipate incurring.
I don't have anything else, Your Honor. Thank you.
All right. Any other cross? How about redirect?
No redirect, Your Honor. Thank you.
All right. Okay, thanks very much. I don't know if I said we can accept all those documents, so I'll just say it now. And you're excused. Thanks very much.
Thank you, Your Honor.
Oh, I did want to mention, hang on. Almost forgot. Knew there was something else. So I just wanted to be sure, is this the witness that filed the force majeure letters that we saw in the pub service case? Is that coming through this witness in this case?
Yes, Your Honor. It's 3 sets this time, right, for the 3 different projects. I think I understood your note on the public and confidential, but yeah, if there's something else that we should discuss.
No, just want to make sure we got that covered. Okay, so just file the full version, confidential and public. That's exactly it. Okay, great. Thanks.
Yes, Your Honor. Thank you.
All right. Thanks. You're excused. So who do we have left for the applicants?
Your Honor, we'll call Mr. Stasek.
You know, it's a promotion or a demotion.
That's right.
Mr. Stasek has pretty strong opinions on that question.
Yeah, let's not do that while he's under oath anyway. All right. All right, and I'll just change our attorney name here.
I can go by picture.
This is a full service system here. Okay, let's see. I think we're good. Let's swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
All right.
Please state and spell your name for the record.
It's Richard Stasek, Stasik.
Mr. Stasek, did you prepare and cause to be filed direct rebuttal, surrebuttal, and surrebuttal, and one exhibit in this case?
Yes, I did.
If I ask you the questions contained in your testimony today, would your answers be the same?
Yes, they would.
And is your exhibit true and accurate to the best of your knowledge?
It is.
I believe the Walnut Way had an issue with Mr. Stasik's search for rebuttal, but other than that, Mr. Stasik's available for cross.
Okay, well, let's hear that first, so I can accept all the documents except sir for now, and we'll hear any objections to that now.
Thank you, Your Honor. I was just going to make the same objection to Mr. Stasik's sir rebuttal as I did for the Zanok sir rebuttal, that the points made on pages 8, line 14 through page 10, line, we'll say 13, are repetitive and duplicative substantively of the points that Mr. Stasik made in his rebuttal testimony, pages 20 to 23. I won't re-argue this, but it's just for the record, I wanted to impose that objection.
Okay, great, thanks. And I'll make the ruling the same. We'll accept these as they're filed with all the caveats that I've provided with respect to the prior Zagok testimony. So yeah, we'll receive those documents. This sir rebuttal, the Stasik sir rebuttal on that basis. So is the witness available for cross?
Yes.
All right, who has questions? Anyone?
Your Honor, Steve Heinzen for WEG has some questions.
All right, go ahead.
Good afternoon, Mr. Stasik. How are you today?
Good. How are you, Mr. Heinzen?
Sure, Steve Heinzen. Okay. I'm gonna, I guess, direct your attention to your sir rebuttal at page 6.
Is there a specific line?
I know it's the last Q&A though. And I guess the question is pretty straightforward. If you could let me know if 100% of Microsoft's 2025 sales are included in your general primary other sales.
So as I believe it says on page 19, they are included in there based on Mr. Nelson's exhibits in the case.
I guess I'm looking for the word 100, or I'm looking for evidence that it's 100%, all of them.
Okay, then I guess I will answer the question yes.
Okay, thank you. WEPCO is working on a new tariff for Microsoft right now. Is that right?
Correct.
And is you working on this because CP1, for whatever reason, is not a reasonable fit for the service that Microsoft will receive?
Objection form.
You know, I don't know if I just go off the record. I just don't know if I heard the tariff number correctly.
Oh, CP1.
Okay, so all right. So it was okay. Let's get back on and just rephrase.
Sure. Are you working on a tariff with Microsoft because there is not another tariff that WEPCO has that is a good fit for Microsoft?
Objection form and foundation.
Are you involved in negotiating tariffs, Mr. Stasik?
As I believe your last question asked, I said yes.
All right. And are you involved in negotiating the tariff with Microsoft?
My answer to that is still yes.
Okay, then if I could have the last question read back. Mr. Stasik certainly has, I've laid the foundation for his knowledge of this topic.
Okay, so off the record, so we're talking about the question that, can you just give us a reference point? Because there was.
Sure, it was the question that was asking whether WEPCO was working on a tariff with Microsoft because WEPCO did not have another tariff under which Microsoft would easily or take service.
Okay, so just read back.
Is that your question?
Let's read back to what's in the record, because that's off the record.
I'm not sure which.
Yeah, because there were two questions. So
I can just start reading it. If it's the right thing or the wrong thing, just
Sure.
tell me. WEPCO is working on new tariffs for Microsoft right now. Is that right? Answer
Yes.
correct. Question, are you working on this because CP1, for whatever reason, is not a reasonable fit for the service that Microsoft will receive? And objection form. He didn't answer that. You asked him to rephrase, and Mr. Heinzen asked, are you working on a tariff with Microsoft because there is not another tariff of that WEPCO has that is a good fit for Microsoft? Objection form and foundation. Question, are you involved in negotiating tariffs, Mr. Stasek? Answer, as I believe your last question asks, I said yes. Question, are you involved in negotiating the tariffs with Microsoft? Answer, my answer to that is still yes. So, did I need to go back further?
I don't believe so, no.
Okay.
No, I think you read it
Which
right.
question you want him to answer?
I want him to answer the question that asks, is WEPCO working on a new tariff with Microsoft? Because CP1, for whatever reason, is not a good fit for the service that they will take.
That they will take?
Yes.
Thank you.
Objection form.
Form overruled.
I guess what would be helpful to understand is, well, number one, I guess I'd like to have the question read back because it's gone back and forth a few times. If we could start there, and then I'm going to probably seek clarification because I'm not sure I quite understand what you're asking for, Attorney Heinzen.
Why isn't Microsoft simply taking service under CP1 and leave it there?
So I believe actually witness Stevens talked about this quite a bit in his testimony, and my understanding is based on Microsoft's many objectives when coming into the service territory is CP1 will not meet their needs because they specifically have corporate responsibility goals to serve their load hour by hour over time, hour by hour with specific renewable generation.
Okay, and would you do you expect that the pricing for CP1 and the pricing for the tariff you're negotiating with Microsoft will differ for the same load profile?
Objection calls for speculation.
Well, Your Honor, this is the work that Mr. Stasek does. He is negotiating this. He has to have some idea of whether or not there's going to be a difference in the pricing.
Yeah, overruled. You can ask a different objection, but that one's overruled.
I think it's reasonable to assume that they will be different. For one to speculate they would be exactly the same, I think would be a bit, I'll call it naive. But we are very much in the negotiation phase now, and there are many pieces to be worked out. So to know how exactly it will compare to CP1 is right now something I cannot answer.
Okay. So you have not yet reached agreement on the terms of that tariff?
Not definitively, no.
Okay. Will you, do you believe that you will have by January 1 of 2025?
We are certainly very hopeful, and we have a plan laid out where that should likely be the result of that. So as of right now, as we sit here today, I do believe that, yes.
Okay, and that would include having the commission approve the tariff?
At the point with which a tariff structure is agreed upon, we have every intention and agreement with Microsoft to work with them to apply for the commission's authorization to review and then implement the tariff.
Okay, and you would do all that, and your expectation is to do all that, including getting the commission's approval on a date before January 1, 2025?
Objection calls for speculation.
Is that your goal?
As of right now, we continue to work as quickly as we can, understanding that there could be constraints with resources and time commitments at the commission. We are still hopeful to get it negotiated, applied for, and approved by the commission as expeditiously as possible.
Okay. Final question is, how did you calculate revenues for the general primary other if you do not yet have the terms of the tariff?
So I believe that was pretty clearly laid out in other witnesses' testimony throughout this case, primarily Mr. Joseph Zagantz. We essentially structured the assumptions that we used to go into the rate that we assumed, we used the assumptions that the rate would be very similar to the EITM zone rate when we calculated those revenues. And that has been articulated, I believe, in Mr. Zagantz's direct.
Okay, I don't have any further questions. Thank you.
All right, any other cross?
Yes, Your Honor, if Sierra Club may make a brief cross.
Yes, go ahead.
You testified that one of the reasons for the Microsoft specific rate is to enable Microsoft to meet certain sustainability goals. Is that correct?
That is an objective Microsoft has stated, correct?
Is it your intention that under the tariff, Microsoft will be able to direct which resources WEPCO procures to meet the Microsoft load?
I'm sorry, I just want to process that one. Could you read that back to me, please?
Yeah.
We'll have the court reporter read it back.
Sure.
Your intention that is it your intention that under the tariff, Microsoft will be able to direct resources WEPCO procures to meet their Microsoft load?
I think the way I would answer that is not directly, no. That is not the way that we're currently discussing the process with Microsoft, that they would specifically identify and direct us to procure certain resources.
Is it your intention that under the tariff, WEPCO will provide certain guarantees as to the type of resources that it will use to meet Microsoft's load?
We are working to develop a tariff that will offer Microsoft the ability to have firm service for all of its projected load while at the same time meeting its sustainability goals.
Respectfully, I'm not sure that answered my question, which is, will the tariff include certain guarantees from WEPCO as to what type of resources it will use to meet Microsoft's load?
Objection calls for speculation.
He can answer that.
I believe.
Your Honor, respectfully, the tariff is under negotiation. She asked about a definitive term of the tariff. The prior question was, is it WEPCO's intention to do such and so? The second question was, will the tariff contain such and such a term? There's a significant difference between those two questions.
Okay.
The second calls for speculation.
And Your Honor, I can restate it as intention, which I believe my original question was before the witness gave an answer that wasn't really responsive.
Okay, yeah, go ahead and rephrase.
Is it your intention that under the tariff, WEPCO will provide guarantees to Microsoft as to the nature of generation resources it will procure to meet Microsoft's load?
I would not use the word guarantee, certainly at this point in the process. As I've stated, I believe to some of the cross from Attorney Heinzen, we're still in the process of negotiating the tariff and don't have all of the terms determined or agreed upon.
Is it your understanding that those generation resources are those that have already been announced as part of the generation reshaping plan, or will those be additional resources that have not yet been announced?
The short answer to that is we have plans already announced and files on or applications on file with the commission to build resources that will meet all of our anticipated firm demand in the southeastern Wisconsin area, particularly driven by load growth in what we refer to as the I-94 corridor. We also expect that pending the outcome of negotiations with Microsoft, there could very well be additional projects that need to be identified, procured, and then sought commission approval to acquire to serve Microsoft as well as other customers in our service territory.
Okay, thank you. That's all I have.
All right. Other cross? Okay, redirect.
Just one question. Is Microsoft a member of WEG?
It is my understanding from discussions with Microsoft that they have joined WEPCO, yes.
Nothing further.
All right, good question. All right, so thanks very much. You're excused.
Thank you.
Okay, so we have any other applicant witnesses?
I think that's it for the applicants.
Okay.
Oh. Oh.
Yeah, that's true. We're good. All right.
Mr. Dukas may want to testify. No. He's waving me off.
Okay. Okay, so we did have someone with a time constraint. Let's at least get that person. I think it was. Let's go off the record for a second. So was it Singletary that had until 4 o'clock?
Yes, until 5 o'clock, Your Honor.
Okay.
Commission staff witness Mitchell Horry asked to be called sometime prior to 4.
Okay. Let's do Horry now, just so we don't forget. And then let's see, we started up at 1 o'clock, was it?
Yes.
Yeah. Okay. You got the clock. You're watching the clock. All right, so let's take Horry.
Commission staff would call Mitchell Horry.
There you go. All right. We'll swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Do.
All right, go ahead.
Good afternoon, Mr. Horry. In this proceeding, did you file or cause to be filed direct testimony?
Yes, I did.
Are the statements and representations in your direct testimony true and accurate to the best of your knowledge?
Yes, they are.
And do you have any additions or corrections to make to your testimony at this time?
No, I do not.
Thank you. The witness is available for cross.
All right, any questions? No? All right, thanks. You're excused. All right. We can press on. Okay, so next up is Cub. You can call your first witness.
Cub calls Tom Content.
All right, there we go. In just a second, I wanted to just take the name off of the WEPCO. Not sure who's going to be there. Okay. All right, let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Please state your name and position at Cub.
Sure. Tom Content, and I'm Executive Director at CUB.
Did you prepare and cause to be filed direct testimony with errata, rebuttal, surrebuttal testimony, and 5 exhibits?
Yes.
And is that testimony and the information in those exhibits true and correct to the best of your knowledge?
Yes.
And do you have brief sir rebuttal testimony in response to Mr. Stasik's sir rebuttal?
Yes, I do.
Okay, well, before we get started, I just wanted to ask, we did have that Content 5 is a late exhibit. And I was wondering if there are any objections to receiving that.
Well, I guess the applicant would like to know what the basis for taking it into evidence at this point is. It sounded like it was going to be in response to Mr. Stasik's surrebuttal testimony. We do not see any grounds for introducing it at this point in response to Mr. Stasik's rebuttal, but certainly interested in Cub's perspective on that.
Yeah, if so, I did want to raise an issue about it, and I can just to be transparent about it. I think the exhibit is content 5. Cub is offering a transcript of the WEC Energy Group Q4 2023 earnings call transcript, and the call apparently was occurring on February 1st, 2024. So I guess I can, well, just tell you my concern, I suppose, is that, again, we're looking at transcripts of calls, and I think that if you read through the document, some of the words are not accurately, they're just not, I don't think they make much, there's some nonsensical non sequiturs here, and I don't know to what extent we can rely on this as being a transcript of this meeting. So I guess we'd like to know the purpose of this for having it be offered, and then perhaps there's a different way of using this document that maybe would avert some of the problems with receiving it into the record. So can we just get a little bit of background on that, Attorney Corbin Ferris?
Yes, in his rebuttal, Mr. Stasek described the connection that Mr. Content makes between WEC's strong financial performance and high authorized ROEs as tenuous. And Mr. Content personally observed through listening this February 24 fourth quarter 2023 fourth quarter earnings call between WEC executives and their shareholders. And this exhibit corroborates his understanding of that call. Which responds to Mr. Stasik's rebuttal questioning the tenuous connection. And beyond that, I would let Mr. Content provide his testimony, his rebuttal testimony, to provide more context for that Exhibit 5.
Okay. Yeah, I guess so I mean, what I propose is that I think the document, I guess I just have some issues with the document. It's giving me some trouble. So I'm not sure. I mean, can we verify? I think, to the extent that it's used to refresh his recollection if he attended the call, that might be useful, a proper use of the document, but I'm not sure if I can accept the document as being introduced for the matter asserted, because it says it's a transcript, but again, it's not verified, similar to the commissioners meeting. It's not verified. It seems to have some inaccurate words. I'm not sure if we can rely on it as evidence in that sense. So I guess I'll have you, so without accepting that document as an exhibit for the record, I think it might be, maybe there's a way you can use it in your questioning, but let's have your questioning occur, and then we'll see if there's any objections to what the answers may be. So why don't we go ahead with your any supplemental direct or rebuttal, however you want to phrase it. So you can go ahead with your questions with that in mind.
Mr. Content, did you listen in on the February 2024 WEC earnings call discussing fourth quarter 2023 earnings?
Yes, I did.
And what did you hear on that call with respect to the company's 5-year plan in Wisconsin?
Objection. How this is not responsive to rebuttal testimony.
Okay, well, if you could tie it to the Sir rebuttal testimony, you probably want to reference that and see
Yes.
how it relates. Yeah.
So if we could refer to pages 7 and 8 of company witness Mr. Stasik's Sir rebuttal.
Okay. I have 7 here. Okay, so go ahead.
Okay, would you, all right, I'll go ahead and read that. The question was, with respect to Mr. Content's comments on WEC Energy Group's corporate earnings, does Mr. Stasek agree with Mr. Content's assertions in his rebuttal? No. First, earnings from 8 utilities in 4 states, Wisconsin, Illinois, Minnesota, and Michigan, as well as from multiple unregulated businesses, all contribute to WEC's holdings. So the connection Mr. Content is attempting to make is tenuous at best. So Mr. Content.
Yes.
The earnings, what connection, what information was provided in the earnings call that bolsters your assertion that WEC's strong financial performance is tied to high authorized ROEs in Wisconsin, and in particular for the applicants?
Sure. Well, the communications between WEC executives and its shareholders and the investors indicate that the company is touting its earnings per share growth that has occurred over the past 20 years and is forecast to continue again this year. And the conference call itself touts growth within Wisconsin, specifically the fact that it is increasing its 5-year plan with additional investment in Wisconsin by $300 million.
Your Honor, this is in no way responsive to Mr. Stasik's rebuttal. This is, if anything, responsive to the cross of Mr. Content from last Friday on the specific issue of how much additional investment was going to be made in Wisconsin as opposed to Michigan in response to disinvestment in Illinois because of certain regulatory orders in Illinois. This is a backdoor attempt to respond to cross of Mr. Content in a completely different case from last Friday. This is totally improper.
Okay, any response?
Mr. Stasik's rebuttal directly questioned Mr. Content's testimony, and in Sir rebuttal, we are responding to that.
Why are we talking about $300 million of investment? Mr. Stasik talks nowhere in his rebuttal about $300 million of investment in Wisconsin.
Yeah,
I mean, this is the most thinly veiled attempt to respond to last week's cross-examination that you can imagine.
Okay. All right. Yeah, I'm seeing it in the perspective from the perspective of the applicants. Attorney Corbin Ferris, any response? Final words on this?
I mean, my response is that we would like to respond to Mr. Stasik's rebuttal, and with respect to financial performance, and this is discussed in the earnings call, and whether or not it's phrased with language or the specific parameters that applicants' counsel prefers we use does not seem to invalidate the question. We think this is important evidence.
Okay. So how is it tied? I guess just explain to me how the earnings call is tied to this tenuous connection.
The earnings call discusses the prospects looking forward and what the company's expectations are in Wisconsin as part of its broad corporate strategy.
And I guess I would ask Your Honor, how does that have anything to do with supporting lowering the applicant's authorized return on equity, which is the question that Mr. Stasek is answering here? Has nothing to do with it.
Mr. Stasek tries to argue that contributions to WEX Holdings are spread out across 4 states and 4 jurisdictions. And what Mr. Content is responding with is the extent to which that is concentrated in Wisconsin.
That's undeniable. The company operates in 4 states and has unregulated operations and FERC operations. That's undeniable, but that has nothing to do with this. This is a thinly veiled attempt to respond to last week's cross-examination.
Yeah, I'm going to tend to agree with the applicants. So I don't think I'm going to rule in favor of that objection.
Your Honor, we'd further ask that the question and answer be stricken on that basis.
Yeah, we don't like strike the actual transcript, but the ruling is clear.
All right. So, Mr. Content, do you have anything additional to add to your testimony at this time?
I'm sorry, I couldn't hear you.
You couldn't hear me?
I couldn't hear Mr. Content. I could see his.
I had another aspect of the earnings call that I was going to bring up that is, I believe, is responsive.
Okay, well, do we have a question? Just any other evidence? I don't know if we can.
What other evidence from the earnings call do you believe is responsive to Mr. Stasek's rebuttal that you would like to present as Sir rebuttal?
Right. Just the fact that in the 5-year in the plan, in the forward-looking plan for the overall company, that the Wisconsin portion, the regulated electric business in Wisconsin, is going to be a bigger contributor to the the enterprise, as they say it, and to the overall earnings profile for the company in the years ahead. And that's discussed that was discussed on the call that I heard, and the transcript of which we've provided.
And that was the Q4 2023 earnings call that you listened to.
Correct.
Thank you. Anything further?
Not at this time.
The witness is available for cross-examination.
Okay, questions for the witness?
Yes, Your Honor.
Your screen's off, just so you know.
I'm sorry?
Your camera's off, Attorney Wilson.
I can see him.
Oh, you're on the right. He wants you on this one.
Oh, did you switch? Well, what happened here? Okay.
Yeah, Your Honor, we were trying to get on the one that spotlights.
Oh, okay. Yeah, I need to.
Yeah, I try to get on the pinned one. Sorry.
Okay. Oh, there you go. Yeah, Oh, let me unpin the other one. I think someone must have switched. All right.
Hello, Mr. Content. Joe Wilson on behalf of the applicants. How are you?
Good afternoon. I'm doing well.
One of the things the commission will have to do in this case is set an authorized return on equity for the utility, right?
Correct.
Could you please direct your attention to page 4 of your direct testimony at lines 17 and 18? Are you there?
I was waiting for it to be called up, but.
Oh, that's a Singletary, Your Honor.
Oh, look at that. Right.
Line 17 and 18, you talk about billions of investments upon which utilities will earn their regulated returns. Do you see that?
Correct.
Utilities are not guaranteed to earn their regulated returns, though, are they?
No, from the perspective of investors, they're not guaranteed to earn their returns. The company may operate in a way such that it over or under returns based on the approved ROE in a given year. So it is if this commission, in this case, were to set an ROE at 10% or 9.65% or 9.3%, that would be the amount that's reflected and incorporated into the revenue requirement upon which rates will be set. And that's reflected in the testimony and direct and supplemental of staff witness Jennifer Maley. From the perspective of the customers, it's a fixed amount that will be collected. So as witness Maley referenced in her testimony, a change in the revenue requirement or change in the ROE of 10 basis points would adjust the ROE or adjust the revenue requirement by $8.5 million in 2025 and $9.4 million in 2026. But the bottom line is, yes, from the perspective of investors, the rates are the earning is not guaranteed, but from the perspective of the customers that CUB represents, the decision in this case to set the approved ROE is what factors into how much they'll be paying in 2025 and 2026.
Almost like you were ready for that question. So in response to my question, utilities are not guaranteed to earn their returns, are they?
No, they're not guaranteed to earn their returns. I think you covered that.
And they don't always earn their authorized returns, do they?
Objection, asked and answered. He just
Nope,
answered
that question was not asked and answered.
Overruled.
I did actually answer that in that I said that.
Well, you answered it in your narrative response to
I
my
said that they
straightforward question.
Okay, it's overruled. You need to answer this question.
Okay, could you read it back? I apologize.
Yeah, let's have it read back.
The last question was, and they don't always earn their authorized returns, do they?
That's correct.
Please direct your attention to page 9, lines 3 through 13 of your direct testimony. There you discussed earlier. Page 9.
Page 9.
And there you discuss the early retirement of the Oak Creek power plant, right?
Generally, that's a specific example. Yes, that's part of
that.
Does
Does CUB take the position that the Oak Creek power plant should be kept in service to avoid the stranded cost issue that you raised in your testimony?
We don't take that position.
So CUB does not take issue with the plant's retirement at the end of 2025, correct?
Our issue is on the stranded costs relative to the once the plant shuts down, and Mr. Singletary has more detailed analysis and is our subject matter expert on that.
You turn to your rebuttal testimony, please. And specifically pages 4 to 5. And there, you talk about CUB's funding and you compare specifically CUB's funding to the legal expenses that the applicants are seeking in the test years, right?
Yes.
And you say that CUB's funding is capped at $900,000 from the legislature at on page 4, line 23 through page 5, line 2, right?
Right.
And then at page 5, line 10, you say that CUB's funding is capped at a level well below the median for consumer advocates who advocate for residential customers in nearby Midwest states. Do I read that correctly?
That's correct.
And just want to make sure I understand the mechanism. Cub is eligible for up to $900,000 in reimbursement for Wisconsin utilities as a result of intervention and mission proceedings. Is that right?
That's essentially correct.
But funding through the PSCW is not the only source of revenue for Cub's operations, is it?
No.
And Cub isn't limited in terms of raising funds from its members, is it?
No, we are able to raise funds for members.
How much did Cub raise from its members in 23?
Subject to check. I'd have to. I could look that up. I don't have it at my fingertips.
You have a general idea?
In the neighborhood of $100 to $120,000.
Okay, what about in 2022?
I think I'm going to object to relevance. This is not Cub's fundraising efforts are outside of the scope of this proceeding. Mr. Content does not testify to Cub's fundraising efforts, and this is also information that is not top of mind.
Yeah, well, I mean, I'm certainly not objectionable to ask these questions. But I don't think the witness needs to be digging for those answers just because he's got a computer in front of him. So to the extent he remembers and can give us a general figure from his memory, that's fine. But we don't need to get into what documents or specific documentation he may have in his office. I don't think that's.
Yeah, that's fair. That's fair. It's not a memory test. I just wondering.
Generally the same ballpark for 2022.
Has it been in that level for several years?
Yes.
Sorry, was that a yes?
Yes. It's
How many
the range. There is a range.
How many residential members does Cub have?
Cub has about 3,000 members, of whom about 1,400 are paying donors.
And are those all residential members?
Largely.
Okay.
Largely.
You mean residential ratepayers? Is that what you're saying?
Residential utility customers, yes.
Yeah.
How many small business members does Cub have?
Object to relevance, Your Honor. I feel like we're really going far afield. This is Krista Westerberg now on behalf of Walnut Way. We're really far afield of the issues in this case. And I don't see how it's connected. It's very far afield of Mr. Content's rebuttal testimony as well. And
How's it relevant, Attorney Wilson?
Well, we're getting into the relative resources of the applicants and Cub, and we're trying to understand the relative needs for resources, and I'm going to go there next. So that's where I'm going with these questions.
Okay, go ahead.
We have a few dozen small business members.
I'm sorry, a few dozen?
Yeah.
Is Cub forbidden from seeking grant revenue in the same way as any other nonprofit?
No.
Has Cub pursued grant revenue, say in 2023?
No, we have not.
It hasn't made any attempt to pursue grant revenue in 2023?
No, it's something that our board is exploring, and within the it's something our board has explored, but we did not submit grant applications. Our primary source of funding is through the Act 24 funding that was created in 2021, And we've been working to implement that funding model in recent years.
In your time as executive director of CUB, Mr. Content, has CUB ever pursued grant revenue?
Yes.
Yes. When was that?
In the 2017 to 2018 timeframe.
And was CUB successful in securing grant revenue in that timeframe?
Yes.
How much?
Subject to not having memorized everything from that time period, in the neighborhood of $50,000.
Was that a one-time deal?
Yes, it was.
Your rebuttal testimony at page 5 notes what you perceive to be a disparity in the legal funding available to CUB and the applicants, right?
Yes, and I was echoing the constraints of Walnut Way as well.
Would you agree there's also a disparity in the breadth and complexity of the legal issues that the applicants face when compared to CUB?
We deal with a lot of the same legal issues in the cases that are raised in these cases through our counsel.
Has CUB, I'm sorry, I cut you off.
But we're not a corporation of the scale of WEC Energy of the applicant.
All right. Has CUB been a defendant in any class action lawsuits in the last 5 years?
No.
Has CUB been a party to any environmental cleanup, regulatory, or federal court actions in the last 5 years?
No.
Has CUB been a party to any premises liability lawsuits in the last 5 years?
Objection, Your Honor.
I'm sorry, premises lawsuits. I didn't hear the end of the question.
Premises liability lawsuits in the last 5 years?
Objection.
There's an objection. Yeah, go ahead.
Relevance.
Well, I'm
CUB in no way testified that it has been involved in class action lawsuits or environmental defense.
Yeah.
Mr. Content describes the mission of CUB in his direct. And
yeah, I'm sorry. May I respond?
Go ahead.
I understand Mr. Content didn't claim to involved in these sorts of legal proceedings. My point, obviously, and I only have a couple more examples, is that, of course, the applicants have a larger legal budget than CUB does, which is what Mr. Content seems to be complaining about. And there's a very good reason, an understandable reason, why a large corporation like WEC has a much larger legal budget than CUB does. And it's because they face a broad array of complex legal issues that CUB simply doesn't. And I've only got a couple more examples for the record.
Proceed with your question.
Thank you. Does CUB have a defined benefits plan?
By that you mean a retirement plan for employees? No.
Okay. Is CUB a publicly traded company?
No.
Okay. Thank you. Switching gears. In this case, there are several capital projects that are being placed into rate base. Is that your understanding?
Yes.
Generally speaking, has CUB taken a position in the underlying proceedings, CA and CPCN proceedings, for those capital projects, either for or against them?
Yes.
Okay, and has Cub opposed any of those projects?
I think as our lead regulatory witness, Mr. Singletary is well versed on these issues, on these questions. But I know that it there have been cases where we've raised questions about the analytical and foundational analytical analysis in the generation reshaping plan that led to the approval of that was in projects for which the utility had sought and ultimately received approval.
Okay. As you sit here today, can you name any generation reshaping projects that Cub has opposed?
Weston,
or would you defer all questions to Mr. Singletary?
Weston Rice is an example, but Mr. Singletary would have more complete information for you.
Okay. Any other examples as you sit here?
I defer to, you can ask Mr. Singletary that question.
Okay, thank you. Nothing further.
All right. Other cross? Anybody else? No? Redirect?
Yes, I just have a couple quick questions for Mr. Content. Mr. Content, does Cub participate in other rate cases besides WEC utility rate cases?
Yes, we participate in rate cases involving investor-owned utilities and municipal utilities. Not all of the municipal utilities, however.
And does Cub also participate in IOU construction proceedings?
Yes, we do.
And is Cub also deeply involved in policy dockets, such as those dealing with affordability issues and energy burden?
That's correct.
No further questions.
All right. Okay, thanks very much. So we can accept the Cub documents that we have offered direct with the errata, rebuttal, surrebuttal, and content exhibits 1 through 4. All right, thanks very much. You're excused. And let's see.
Can I take 5 minutes?
Off the record? Yeah, okay. That sounds good. So let's do 3:30. Get back for the 3:30.
I appreciate that extra couple minutes. I have a rib out in my back and it's really starting to hurt.
Oh, thanks. Sorry about that.
Oh no, I don't know why it keeps happening, but
Well, it's 3:30, so let's get back with our witnesses. I think we took still have 2 Cub witnesses. So who's our next one?
Help calls Corey Singletary.
Okay. Swear you in, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Please state your name and position for the record.
Corey Singletary, Director of Regulatory Affairs for the Citizens Utility Board of Wisconsin.
Did you prepare and cause to be filed direct, rebuttal, surrebuttal testimony with errata to that surrebuttal along with 13 exhibits?
I did.
And is that testimony and the information contained in those exhibits true and correct to the best of your knowledge?
It is.
And will you be filing 2 additional exhibits per Judge Newmark's instructions on the offered evidence list?
I will. Those would be exhibits 14 and 15.
And do you have anything to add to your testimony at this time?
I do not.
The witness is available for cross.
Okay, just want to take a break here, a breath here to make sure I have that errata. I don't know. I saw that from before. Okay, well, I'm just going to make a note of it. You wouldn't have to have the PSC number for that, would you?
I do, Your Honor. It is 517594.
Great, thanks. We can go off the record just for a second here. Okay. Okay, so I do see
back on?
Yeah, let's get back on the record. Thanks. Yeah, so we have Singletary, direct rebuttal, surrebuttal with errata, and 13 filed exhibits, 2 more to come. So I just wondered, I can accept those documents. Just any objections to those? And I just mentioned that because I mean the errata looks like a pretty substantial change there. So just everyone's on board with Columbia switching to Oak Creek. So everyone's aware of that. Okay. All right. So those documents are in. We'll look forward to getting the revisions and 14 and 15 filed. Any cross-examination?
Yeah, the applicants have a cross.
Okay, go ahead.
Good afternoon, Mr. Singletary. Joe Wilson on behalf of the applicants.
Good afternoon.
Mr. Singletary, in your rebuttal at page 2, you have said that you support staff's audit adjustments except where otherwise noted, correct?
Yes.
And if staff abandons disallowances that originally proposed, will you likewise be walking away from your support for those disallowances?
It would depend on staff's reasoning for changing its initial position from the audit.
Okay. I'm sorry, Your Honor. I'm gonna have you jumping around a little here.
I can do it. I hope. Keep up.
All right. I'd like to turn to your surrebuttal testimony, Mr. Singletary, at page 11 and 12. And this has to do with integrated resource plans, which I'll refer to as IRPs, okay?
Sure.
All right. And I'm going to paraphrase your testimony, and you correct me if I get it wrong, okay? But I think you're generally saying that there's nothing preventing the commission from requiring utilities to prepare IRPs under current law. Is that your position?
That is my understanding, yes.
Are you familiar with Wisconsin 2023 Assembly Bill 682, which was introduced in the Wisconsin Assembly in November of 2023?
Not off the top of my head, no.
Okay. Well, there was a bill introduced last November that would have adopted IRPs in Wisconsin and eliminated the strategic energy assessment. Does that ring a bell?
I seem to recall hearing something along those lines, but I couldn't speak to specifics, obviously.
Okay. Generally speaking, are you aware whether that was enacted into law or not?
I don't believe so.
Okay. Do you know whether CUB took a lobbying position with respect to that legislation?
I do not recall. I am not CUB's lobbyist. You would have to ask Mr. Content. I honestly don't remember.
Okay. We may want to recall Mr. Content on that, but let's assume, subject to check, that CUB supported a bill last year that would have reinstated IRPs and eliminated strategic energy assessment in Wisconsin. Okay.
Okay.
In your surrebuttal at page 11, line 6 through 9, you're a little bit critical of the advanced plan as it previously existed, right? So it was highly detailed and arguably too prescriptive, right?
I did not say too prescriptive. I said it was, from my perspective, for what is typically put in statute rather than, say, code. It was very specific in terms of its requirements. Too prescriptive is a value judgment, but I would say that it is more prescriptive than is typically set forth in statute for Wisconsin regulation.
Okay, so in your evaluation, the IRP that existed under Wisconsin law up until 1998 was prescriptive relative to IRP statutes in other states. Is that what you're saying?
No, and perhaps this was a little unclear in my testimony. My intent in pointing out that it was highly prescriptive was merely to sort of emphasize that the advanced plan was a very specific set of requirements and a very specific way of going about resource planning and having that proceed before the commission.
Okay. All right. So if we're assuming, subject to check, that CUB was supportive of last year's IRP bill, how do you square that support with your position that the commission already has authority to require utilities to do IRPs?
Well, the position that the commission already has the authority to do them if it believes necessary. That is my position based off of a general understanding that the commission has broad regulatory authority. I don't think that's mutually exclusive with, again, subject to that having been the organization's position. I don't think that's mutually exclusive with a desire to have such resource planning be required under the law. I think it's pretty clear that both in my testimony in terms of my perspective, and I think previous testimony and comments by CUB, that we would prefer a more basically a resource planning process that came before the commission in a more structured and I guess rigorous manner, without getting into specifics about exactly how that would be, but we think that it should be more required rather than simply optional.
So to put it another way, why do you need an IRP statute if the commission already has the authority to order utilities to do IRPs?
I think I kind of already answered that, but it's essentially, from our perspective, it would be preferable if the statute required the utilities to do IRPs and bring them before the commission, which is not to say, like we've already been talking, that the commission couldn't, on its own motion, require them of utilities. But I think we could agree that those are two different pathways.
I'm not sure we could agree to that, but okay. Switching gears, but still in your rebuttal testimony, pages 2 to 3, you discussed the Iowa Utility Board's approval of a settlement by Alliance Iowa subsidiary, which is IPL, and one specific term of the settlement relating to that utility's acceptance of depreciation only recovery for the retired Lansing power plant, right?
Yes.
And to be clear, that was one specific term of the settlement that you were focused on for purposes of your testimony, right?
Yes, it is one settlement term amongst many, but that was the one for the purposes of this issue that I had mentioned, yes.
What were the other terms of that settlement?
I can mention a few.
Okay.
An earning sharing mechanism was imposed. A 5-year stay out was imposed, or agreed to. I guess the commission has agreed to it. So now there's a 5-year stay out. There was a cap on distribution spending by the utility. A substantial portion of, I believe, commission staff suggested revenue requirement adjustments were accepted. There was some, I don't remember the particulars, but there was some agreement on the structure of what in Iowa they refer to as individual customer rates, I think is what they are, ICRs or something like that. But those would be the kinds of rates that would apply to customers like Microsoft, large data centers. Those are the ones off the top of my head.
Do you understand that that settlement also authorized a higher return on equity for the utility?
It authorized a higher return on equity than it currently had, but it was lower than requested by the company. And it's important to note that, if I'm remembering correctly, that only applied to rate base that fell outside of the utility's advanced rate making construct, where ROEs for certain plant is set in advance.
And it also gave the utility the ability to retain certain tax benefits, right?
That one I would have to double check, but that, yeah, I wouldn't want to speak to that. I don't remember specifically.
Do you recall whether it gave the utility the right to retain energy margins for new investments?
I do not recall one way or another, no.
Your Honor, could you please pull up Stasic Exhibit 1?
Okay.
Mr. Singletary, are you familiar with this document?
I have seen it, yes.
Okay. And I understand this to be a summary of the settlement that Alliant Energy, which is the parent corporation of IPL, put together. Is that your understanding?
Correct.
Okay. Could you scroll down, please, Your Honor? Okay. That's a security statement there on page 2. Here we get into the terms of the agreement. If you could scroll down one more page, okay. Here, I believe, sort of in the middle of the page there, it talks about retaining tax benefits and energy margins for new investments. Do you see that? The line begins 5-year rate-based moratorium.
Okay, thank you. That's what that says, yes.
Yep, okay. Any reason to dispute that that was an actual term included in the settlement agreement?
No.
All right, and I believe you testified in your rebuttal that this settlement was indeed approved by the Iowa Utilities Board recently, right?
Yes, correct.
Sorry, I was on mute. By the what utilities board, Mr. Wilson?
The Iowa Utilities Board.
Iowa, okay.
Yeah.
I don't know how particular they are, but they've renamed themselves the Iowa Utility Commission.
Oh, thank you. Thank you for that clarification. Would you agree that while some terms of this settlement agreement benefited customers, other terms benefited the utility, all else equal?
What I can say from my perspective is there were a number of terms that, from a customer perspective, produced, benefits for customers. I don't know if I feel comfortable speaking on behalf of Alliant and whether or not they feel like, there were the benefits that, whether they would see it as they got benefits out of it, or rather they avoided worse consequences.
Well, generally speaking, in your experience as an analyst, both at the Wisconsin Public Service Commission and for CUB for many years, a utility which receives a higher ROE even on part of its rate base would generally view that as a benefit. Fair?
Sure. Yes, we can agree
And a
on that.
utility that gained the ability to retain certain tax benefits and energy margins for new investments would generally view that as a benefit. Fair?
Sure.
Okay. And given that experience that you have in this field, would you assume that the Iowa Utilities Commission looked at the overall fairness of all terms of the settlement and considering its reasonableness as opposed to considering a single term in isolation?
That is the general approach taken by most commissions, yes.
The Iowa Utilities Commission did not oppose a disallowance of return on the Lansing plant over Interstate Power's objections, did it?
No, that was part of the settlement agreement.
To your knowledge, the Iowa Utilities Commission has never disallowed a return on a retired plant in a fully litigated proceeding, has it?
I am not aware either way.
The Wisconsin Commission has never disallowed return on a retired plant, to your knowledge, has it?
Nothing that I can point to in an order specifically.
And they haven't done so as part of a settlement, correct?
I would say if the sorry, you're talking about disallowances. I'm trying to think of it from the company's perspective. If I assume for the moment that WC Energy Group doesn't view the securitization of part of P4 as a disallowance, then no.
Right. I mean, for the securitization of P4, WEC Energy Group still received a return on the retired plant, albeit at a lower rate through issuance of bonds, and that was agreed to as part of a settlement, right?
Yes, I was just, it depends on if we're talking about disallowances, I was just trying to cover the bases because certainly what the company will receive over time as a consequence of the securitization is not the same as what is often characterized as full traditional recovery. But I think your question was if the commission had authorized a disallowance, and with subject to that discussion we've just had, I would say no.
Thank you. The Wisconsin Commission hasn't imposed a full disallowance of return on retired plant against a utility's wishes in a fully litigated case, has it?
Not that I'm aware of.
So you would agree that you're asking the Wisconsin Commission to break new ground in terms of its accounting treatment of retired plant in this case, right?
I don't know if I would use break new ground, but sure.
Your recommendation to disallow the full return on Oak Creek 7 and 8 is not predicated on a conclusion that Wisconsin Electric's investment in any of these units was imprudent when made, is it?
No, that is not the regulatory principle that my recommendation is based on.
Instead, your recommendation is based on reducing rates for Wisconsin Electric's current customers, correct?
I disagree. The basis for my recommendation is starting from the used and useful principle, which is applied fairly frequently in utility regulation. And yes, it does produce positive outcomes for customers in the form of reduced bills, but as a general regulatory policy matter, I start from the used and useful principle in this instance.
I'd like to direct your attention to your rebuttal testimony, please, at line or page 14.
Okay, I'm there.
This has to do with head count and FTE. Just a prefatory question for purposes of this discussion. Do you view the terms head count and FTE as essentially interchangeable?
We can use those interchangeably here. Yeah.
Okay, thank you. If a utility's head count is subject to escrow accounting treatment as you propose, why should the revenue requirement be limited to only 25% of the company's requested amount as you propose?
I guess as just a personal, or just a, not personal, but just as a general matter of I guess practice, is from my perspective is, when offering alternatives to the commission is to try to provide as many pathways forward for the commission as possible, and try to signal to the commission what outcomes CUB might find, or any party might find acceptable if it's not one of the, I'll call it off the shelf, fully baked alternatives. And so the 25%, you're right that if the amounts, the dollars associated with positions, head counts that were unfilled would be subject to escrow accounting, subject to refund to customers, then there wouldn't necessarily be a difference between authorizing, again, subject to that accounting, the full amount the company has asked for, and say 25% above audit levels, as I've suggested. But the commission may wish to send some sort of signal with respect to head counts and the expectations that the companies have and can with respect to future hiring and what it can attract and retain, beyond just giving the company everything. But from a mathematical standpoint, I believe the underlying thrust of your question is correct in that if the commission were to adopt the specific portion of my recommendation, which is to make the increase in headcounts subject to refund, say through escrow, that it wouldn't matter if it were 25% or the full amount that the company's asking, except that there would be an upper cap, obviously, if the commission just went with 25.
So following that logic, would you have a fundamental objection to your cap being 50% or 75%?
No, I will admit there's no magic number to the 25. It was an attempt at gradualism. We'll call it that.
Sure. Okay. Thank you. I'd like to talk just a little bit about forestry expense, and we can stay in your rebuttal testimony and look at pages 5 through 8, where you talk generally about forestry expense. Ultimately, you adopt staff's recommendation that the revenue requirement for forestry should be based on the historic 3-year average then for forestry, right?
Yes.
In your discussion on the issue of forestry appears mostly to be a recitation of staff's analysis on the issue. Did you conduct any independent analysis or just rely on staff?
I looked at the evidence that staff pointed to, looked at the information provided in data request response to the best that I could with the volume that there was. And based on my review of Ms. Kraft's testimony, I agreed with, the way that she viewed it, and therefore that's why I supported her recommendation.
Okay. So is it fair to characterize your conclusions on forestry in this case as being in alignment with Ms. Kraft?
I believe I don't want to speak for Ms. Kraft, but my understanding for why she supports staff's audited levels was based off of not believing there was enough evidence to support the requested increase. And so if that is in fact consistent with, how her thoughts regarding this issue, then yes, I am in agreement with her.
In your rebuttal at page 7, line 4,
okay, I'm there.
Okay, you note the higher tree trimming cost at Wisconsin Electric versus WPSC, and you called the difference between the two alarming, right?
I would say, what is it, about 4 times higher is unusual in looking at between companies, at least in my experience.
Right, and that was a difference that Ms. Kraft first flagged in her testimony, right?
Correct.
Did you review Mr. Megna's rebuttal testimony, and specifically pages 8 through 13 on the issue of the relative cost per mile for tree trimming as between WEPCO and WPSC?
I know I did, but if we're going to get into specifics, I'll have to go back and refresh my memory.
Yeah, sure. We might want to pull it up. I'm not going to get into great specifics, but it may be helpful just to have it up.
What pages were you looking at?
8, around 8 to 13.
Attorney Wilson, you said rebuttal, right?
Correct. Yep. So in this part of Mr. Megna's testimony, I'm going to paraphrase, but you tell me if you think I'm unfairly paraphrasing. He talks about several differences between the utilities, including the urban versus rural nature of their service territories, the number of customer calls they get for safety zoning, and the current differences in their tree trimming cycles. Does that ring a bell?
Yes.
And then Ms. Kraft responded in her rebuttal testimony on this point, and she found at page 1 to 2 of her rebuttal testimony that, and I'll quote it, she's found that Mr. Megna's testimony, quote, adds important context to the record for understanding the requested forestry-related budget increase. Did you read that?
Yes, and I have it up in front of me. Yes.
Okay, great. And then at page 3 of her rebuttal testimony, Ms. Kraft says that, quote, with this additional information, the commission could find that WEPCO's requested increase for forestry management expenses to be reasonable.
I see that. I see that. Yes.
And I think her reference to this additional information includes the explanation about the relative difference in cost per mile as between WEPCO and WPSC. Is that the way you read her testimony?
Her statement does seem to be fairly general with respect to the previous discussion in that rebuttal. So subject to her saying something otherwise later today, that seems to be the case. Yes.
Okay. Do you have any reason to disagree with Ms. Kraft's conclusion on this point?
So one thing I feel compelled to say is that, as is often articulated in many proceedings, commission staff's role is different from parties. And it generally does not take a position. And from my perspective, when I see staff say that something could be deemed reasonable by the commission based off of the evidence in the record, it's staff's position that there is enough evidence in the record for the commission that it could make that determination, but it does not necessarily represent staff's position that it is reasonable. So with that caveat, I would agree with with Ms. Kraft that the additional testimony that was provided by the company is definitely appreciated. My initial concern, the foundation of sort of my initial concern and my reason for agreeing with Ms. Kraft was that the evidence didn't seem to provide, and there wasn't enough there to really kind of support the ask. And so to the extent that there is a more complete record that the commission could make its decision upon, I would agree with that.
Okay, thank you. You agree generally that dead and dying trees near WEPCO's distribution lines can cause power outages, right?
They can.
In this case, there's been testimony about the dual threats posed in Wisconsin Electric Service territory by the emerald ash borer and more frequent summer and winter storms. Do you recall that?
Yes.
And do you have any reason to believe that those dual threats aren't a real issue for the company?
I do not have any reason to not believe that the company is facing both of those.
Okay. Do you agree that as a result of climate change, storms in Wisconsin are becoming more frequent and severe?
In general, yes.
Do you believe that climate change is having an impact in Wisconsin in terms of more severe storms and extreme temperatures?
Yes.
And do you believe that climate change is impacting the ways in which energy reaches homes and businesses here in Wisconsin?
Can you be more specific? I mean,
sure. Yeah, sure. In particular, climate change is leaving transmission and distribution lines prone to increased damage during extreme weather events, correct?
I would agree that climate change, what you had previously asked me about, means that those assets are potentially exposed to those types of weather events more frequently and more severely. Yes.
And would you agree that climate change is posing significant challenges for utilities in Wisconsin, both currently and in the future, regarding storm restoration duration and costs to recover from storms?
In general terms, yes.
And would you also agree that climate change is both currently and in the future causing increased costs for forestry expense?
To the extent that we're tying, vegetation near utility assets to the impact from, say, storms, yes, but you have to have both of those in play, obviously, depending on the asset.
All right, nothing further. Thank you.
All right, thanks. Any other cross? No?
That way has a little brief follow-up on those last points, Your Honor.
Okay, sure, go ahead.
Mr. Singletary, you were just asked a number of questions about climate change. Is it your understanding that burning fossil fuels is a large contributor to climate change?
Yes.
And haven't the applicants been doing that for years?
Yes.
And aren't they proposing to do that again in the future with new fossil fuel infrastructure?
Are you referring to existing facilities or applications for new facilities?
I was referring to applications for new facilities.
Yes.
Are you aware of any way that the applicants have had to pay for any damage that's been caused by climate change to people or municipalities that have been affected by it?
Objection goes beyond the scope of the cross and relevance.
You can respond?
Me, Your Honor, or the witness?
Oh, you, the attorney.
Thank you. Are you, let me rephrase the question. Are you aware, Mr. Singletary, of any costs that the applicants have sought to compensate individuals or municipalities for damage caused by climate change?
Objection, it's the same question, goes beyond the scope of the cross and relevance.
It's not the same question. It was tied to cost the applicants have sought, which goes to this proceeding.
Okay, but I'm gonna sustain the objection.
Okay, nothing further, Your Honor. Thank you.
Okay. Any other questions? Cross questions? No, redirect?
No redirect, Your Honor.
All right. Thank you. You're excused.
Thank you.
And we have another cub witness.
Cub calls Dr. Steve Keim.
Okay, raise your right hand. Don't see you yet. There you go. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Please state your name and position at Cub.
Steve Keim. I am Chief Economist and Regulatory Strategist.
Dr. Keim, did you file direct rebuttal and surrebuttal testimony along with 5 exhibits?
I did.
And is that testimony and the information contained in those exhibits true and correct to the best of your knowledge?
Yes.
Do you have anything to add to your testimony at this time?
No.
The witness is available for cross.
All right, so I can accept the direct rebuttal, surrebuttal, and Keim exhibits 1 through 5. For the record, do we have any cross? Nothing?
Commission staff has a couple of questions.
Oh.
Good afternoon, Dr. Keim. Evan White's on behalf of Commission staff. I just have same question I asked you, I think, last week. Have you had a chance to review the sir rebuttal of applicant's witness Bulkley?
Yes, and as I said last week, I've read it. I've not analyzed it in detail, but I'm basically familiar with what she's saying.
Okay. On page 11 of that sir rebuttal, starting at line 17, so the end of that page and going on to the next page, witness Bulkley says, further, Dr. Keim's criticism of the use of historical data is inconsistent with his own analysis, whereby he references long-term historical average GDP growth to support his own DCF analysis. Do you have any response or anything you want to say as it relates to that sentence?
Can you just go off the record for a second? Sorry to interrupt, but you said that was page 17?
11.
11. Oh, I don't know why I heard that. Okay, great. Go ahead.
Line 17 is maybe what you heard.
Thank you. All right, back on the record.
Your Honor, am I supposed to be seeing?
Your Honor, this is not cross. This is like redirect or something.
Okay.
Staff counsel is asking Dr. Keim to expand upon a point that he made in his testimony. If anything,
No.
Dr. Keim is aligned with the staff witness on the issue of ROE. This is not cross-examination under in any sense of the word.
Okay, let's hear from staff.
I was going to say maybe the Attorney Wilson, maybe you misunderstood what I was asking. I was asking for his response to sir rebuttal from witness Bulkley. So I think it is a fair question to ask because sir rebuttal didn't come in until this morning.
Okay, well, let's see where it goes. I'm curious to hear this.
And this is a similar set of questions that we had in the pub service case.
Mm-hmm.
All right, so we'll go ahead, Dr. Khan, did you, do you remember the question?
Not exactly. If I could have it read back, please.
Sure, let's try to find that. Yeah, go ahead.
On page 11 of the SIR rebuttal, starting at line 17, so end of that page and going on to the next page, our witness is the next page. I'm sorry. Witness Bulkley says, further, Dr. Keim's criticism of the use of historical data is inconsistent with his own analysis, whereby he references long-term historical average GDP growth to support his own DCF analysis. Do you have any response or anything you want to say as it relates to that sentence?
Yes, Ms. Bulkley is assuming that averages either are or are not reasonable analyses. That's actually just an incomplete way of looking at data. Stock prices are what are known as a non-stationary series. And as I said the other day, that doesn't mean they don't move or they move. It has to do with the characteristics of the underlying distribution. Long-term GDP is actually a stationary series with a drift. You should average that, but you should not average stock prices. So you have to go through each item and decide, does this meet stationarity conditions or is it non-stationary? And then that tells you how to proceed. I've proceeded consistent with the statistical bases of those data series.
Thank you. I don't have anything further.
All right, thanks. Any other cross? No redirect?
No redirect.
All right, thank you, Dr. Keim. You're excused.
Thank you, Your Honor.
And double check our list here. Go off the record for a minute. Oh, yes, so Walnut Way is next, is that correct?
Your Honor,
I
do
missed
we
something.
recall Mr. Content for the one question that Mr. Singletary punted to him?
Sure, I think is witness content still available?
Yes, Your Honor.
Okay.
You're muted, Attorney Coburn.
Apparently he is.
Okay.
I was
All
going
right,
to say, I'm not sure. I need to go check, but.
All right, and so witness content, recall you're still under oath. And go ahead with your questions, Attorney Wilson.
Thank you, and sorry to bring you back, Mr. Content. I've just got, I think, one question for you. Two.
Oh.
Were you present for Mr. Singletary's cross-examination, in particular the series of questions about the bill that was introduced in the last legislative session about integrated resource plans in Wisconsin?
Yes.
Okay. Did CUB take a lobbying position with respect to that bill?
Yes, we supported SB 651 and the companion bill, which I think you referenced in the assembly. That bill had three main components that we supported, which was giving the commission the authority to approve whether a power plant should be retired before it's retired, or could be retired before it's retired, expanding the duties of the commission relative to securitization and expanding the amount of a retired plant balance that could be subject to securitization, as well as the integrated resource planning process that you discussed with Mr. Singletary.
All right. And was CUB specifically supportive of the portion of that bill relating to reinstituting integrated resource plans in Wisconsin and doing away with the strategic energy assessment?
Yes.
Thank you. Nothing further.
All right. Any redirect?
No redirect, Your Honor.
Okay. Thank you. You're excused. So are we back to Walnut Way? Yeah, looks like that's our next. So Walnut Way, are you here? Here you go. Call your first witness, please.
Thank you, Your Honor. Walnut Way calls Roger Colton.
There you go. Raise your
I'm
right hand. You may. Okay. Do you swear or affirm tell the truth, the whole truth, nothing but the truth?
I do.
Okay, great. Okay, go ahead.
Thank you, Your Honor. Would you please state your name?
My name is Roger Colton.
What is your position?
I'm the owner of the firm Fisher Sheehan, Sheehan, in Colton, Colton, Public Finance and General Economics.
Did you cause to file, did you prepare and cause to be filed direct rebuttal, rebuttal testimony and exhibits 1 through 30?
Yes.
And have you also been made aware of certain corrections the administrative law judge has suggested to the rebuttal and rebuttal and exhibits 1 and 30?
I am aware of those.
Do you agree to the the corrections that have been suggested?
Yes.
And with those corrections, are the documents that you have caused to be filed complete and correct to the best of your knowledge?
Yes.
Do you have any additions or responses to your testimony based on anything you've seen in rebuttal filed by the applicants or what you've heard today?
I do have a response to the testimony of Mr. Zagonis from this morning, from earlier today.
Okay. Please proceed.
I have 3 brief points that I would like to make. Number 1 is that as we heard, the inclusion of lift arrearage forgiveness credits, it was in this particular rate case, was not simply an inclusion of historic credits, that they involved a projection of credits as well. And that projection is consistent with what Mr. Zagonitz stated in his direct testimony at pages 9 and 10 and at pages 25 and 26. Number 2 is that Mr. Zagonitz again talked a lot about the accounting treatment of the uncollectibles and more particularly the lift arrearage forgiveness credits and the lift credits against current bills. And I would simply assert, I would simply assert that irrespective of the accounting treatment, that the accounting treatment of lift credits, whether they be arrearage forgiveness credits or credits for against the current bill, don't guarantee future rate recovery, that there can be deferred credits that exist that are denied rate recovery in a future rate case. Indeed, I cited one example of that in Philadelphia, where credits were denied rate recovery or were denied separate rate recovery because they were already included in rates in my testimony. Number 3 is that as I reviewed the prior orders, the prior lift orders, I noticed that the authorization of deferred accounting for lift credits expired with the expiration of the pilot low income program. When the commission authorized the lift program as a permanent tariff program, it did not address the deferred accounting of lift credits, and it certainly did not authorize the deferred accounting of lift credits. That was in the 2024 lift order by the commission.
Are you aware of any current order authorizing deferral accounting for the full lift program then?
The whole lift program was simply authorized earlier this year. I am not aware of any order subsequent to the authorization of the expansion of lift to be a permanent tariff program authorizing deferred accounting credits. And that may well be because the company on any number of occasions told the commission when it was seeking the permanent program that the program would be cost neutral. And so it could well be simply that the assumption was that there would be, given the cost neutrality, that there would be no additional costs that would need to be deferred. No additional net incremental costs that would need to be deferred.
Thank you, Mr. Colton. The witness is available for cross.
Okay, so I can accept direct, rebuttal, surrebuttal, and exhibits 1 through 30 from witness Colton, just with the corrections we're expecting. Any questions for the witness?
Yes, Your Honor, the applicants have some cross, and this is for the record, Attorney Goldschmidt, for the
Yes,
first and hopefully only time today. Nice to see you, Your Honor.
Yes, good to see you. All right, proceed.
But before we get to those questions, I would like to note we let the answers go forward just now to hear their scope. I think at least the third point was pretty far beyond the scope of the sir that was offered previously. So if it would be acceptable to Your Honor to complete the record, we'd like to have Mr. Zagantz come back up at some point to clarify this point about the accounting treatment and the commission's recent orders. And we can either do that now if you prefer, or at the conclusion of Mr. Colton's cross.
Let's carry on with Colton's cross, and then yes, we can recall Zagantz for clarity.
Thank you. Good afternoon, Mr. Colton. My name is James Goldschmidt. I'm one of the attorneys for the applicants. Thank you for your time. Where are you testifying from today?
I am in Belmont, Massachusetts, which is an inner suburb of Boston.
I'm happily familiar with it. Nice part of the country. Starting with your third point in testimony from the stand today, you would agree that the commission's 2024 lift order would speak for itself, correct?
I would.
And that would be true of all of the commission's orders on this particular issue of lift accounting, correct?
I would agree with that.
Thank you. Let's turn to your direct testimony, please. Starting at pages 20 to 21. You can start at the bottom of page 20.
I'm there.
Okay, in this portion of your testimony, you state that utility affordability generally means 6% of income, but then you assign lower thresholds of 3% and 3% or 4% and 2% for electric and gas, respectively. Do you recall that testimony?
I do.
And then you describe applicants' rates as unaffordable whenever they exceed those lower thresholds, correct?
I do. For individual fuels, yes.
Thank you. To know the applicable affordability threshold in this context, wouldn't we need to know whether a given customer is electric only, gas only, or both?
We would need to know whether a customer was a combination customer or not.
And for electric only or gas only customers, the relevant threshold would be 6%, right?
For an electric heating customer, the burden, the affordable burden would be 6%. When I say electric only, I'm talking about electric heating. So electric and propane or electric and some other fuel would not be an electric only customer.
And the same would be true for gas only customers, correct?
When you say the same would be true, what do you mean by the same?
If they're a gas only customer, then the relevant affordability threshold from your perspective would be 6%, correct?
No. No, that is not correct.
Why not?
Because the 6% applies to total home energy bills. If somebody is a gas only customer, that would mean that they would have presumably, when you say gas only, I'm assuming you mean gas only from one of the companies in this proceeding, but they would still have an electric component to their total home energy bill. So the total home energy affordability would be split 50-50, 3%, 3%, and the gas component would be 3%. Gas would never, well, I'll stop.
Okay, so for those gas only customers of these applicants, you're presuming that they're receiving electric service from some other utility. Is that right?
Well, I don't make that presumption. I didn't make that presumption because I didn't have to, but if called upon, I would say yes, that I'm assuming that they receive electricity from some other utility.
Okay, let's take a look at your table 4, which is on page 23 of your direct testimony. Here in table 4, you show the number of customers and the bill to income or BTI ratio for those customers at various ranges of the federal poverty level at existing rates, correct?
I do. Yes, the answer is yes.
And those figures are calculated by utility, correct?
Yes.
Now you have the numbers for how many of applicants' customers are gas only, how many are electric only, and how many are dual utility, right?
I do.
Did you perform your table 4 analysis of the affordability of current rates using those numbers?
Well, the customers that are included in table 4 are based upon the numbers of customers that the company provided in response to discovery.
Understood. But if we look, for example, at the 61,732 customers between 0% and 50% of the federal poverty level under the WEC electric utility, your table 4 doesn't indicate how many of those customers are also gas customers of applicants, correct?
That's correct. I do. Yes, that is correct.
Okay. Why didn't you perform your table 4 analysis based on which customers are customers of one or both utilities?
Well, the question is, why didn't I combine the the gas and electric, people who take both gas and electric from the company into a separate category. And the reason for that is because that would skew the analysis of affordability. Somebody could have, well, it would skew the analysis of affordability. It would combine the two bills into a single percentage, and that would be inappropriate.
Why would that be inappropriate? Wouldn't we want to know which customers are paying one bill and which are paying two when we're talking about affordability for these applicants?
If, perhaps for some
I'm sorry.
purposes.
I'm sorry. Can you start again, Sarah? I think you broke up in the beginning, Mr. Colton.
Yes, perhaps for some purposes, but I think that for the purposes of evaluating or assessing the affordability impacts of the rate increase proposed by the electric company or the rate increases proposed by the respective natural gas companies, you would not want to be combining the two services.
Okay, well, as you sit here today, do you know the current energy burden, as you use that term, for any actual subset of applicants' customers?
I don't know what you mean by that question.
Do you know for any actual subset of applicants' bill-paying customers what their energy burden is based on whether they are paying one bill or two?
Back to form, I'm not with the term subset.
I can back up.
Okay.
We've already said that we don't know how many of these customers in table 4 are paying one bill and how many are paying two, correct?
I have said that, yes.
Okay. So if we don't know that, then we don't know, do we, what the actual energy burden is for any of the customers in this table? Do we?
I agree that I did not calculate a total energy burden for customers who take combination service from more than one of the utilities, from the electric utility plus one or the other gas utility, yes.
And if we take a look at table 5 on page 24 of your direct, here you show the number of customers and the bill to income or BTI ratio for those customers at various ranges of the federal poverty level at applicants' proposed rates, correct?
That's correct.
And similar to table 4, does your table 5 analysis of the affordability of proposed rates reflect how many of applicants' customers are gas only, how many are electric only, and how many are dual utility?
For both companies, yes, the same answers that I provided for table 4 would apply for table 5. Table 4 and table 5 were calculated the same way, only for table 5 I use bills at proposed rates.
Okay, we can short circuit some of my questions that way. Thank you. Let's turn to page 25 of your direct testimony.
Before we move on, I just wanted to interject. I did not notice the use of the acronym WEC-E. I think we can refile this testimony with the more accurate acronym of WEPCO for the applicant, WEPCO, Wisconsin Electric. And for Wisconsin Electric gas operations, is that still the way the utilities names that?
Yes, we would use WEGO.
Yes, okay, yes, so WEGO for, I think what you have labeled here as WEC-G. That'll just be more consistent with how we're typically term these subsidiaries. I sorry, I missed that on the first review. So anyway, proceed with your questions.
Sorry, just to
Yeah,
clarify on that.
question, Your Honor.
Wait, who's
when-
speaking?
Witness Colton's.
When you ask for that to be done,
Yes.
should or should we assume that we should just do a global search and replace for wherever I use those two acronyms? Your request doesn't apply just to these two tables. It's wherever I use those two acronyms or those two acronyms.
That's correct. Yeah, thanks for clarifying. Seeking clarification. Yes, wherever you use that acronym, those two acronyms, please replace those with ones we're more familiar with.
Consider it done.
All right, thanks.
Thank you.
Okay,
That
go
was
ahead
my
with your
question
question.
too.
Okay, thank you. That was a helpful clarification, Your Honor. Turning to page 25 of your direct testimony, Mr. Colton. There at the top of the page, you highlight a 2021 report from Sierra Club analyzing energy burden among Black and Latino neighborhoods in Milwaukee. Do you see that?
I do.
The percentages that you cite, 2.1% for white majority neighborhoods, 5% and 5.3% for majority Black and Latino neighborhoods, are all below the affordability threshold of 6%, correct?
Or total home energy, yes.
Okay. And the 2024 update to that report, which you reference at line 15, confirms that energy burdens in those neighborhoods have in fact decreased since 2021, correct?
And specifically, what are you pointing at?
So the 1.9% for majority white neighborhoods at line 18 and 4.9% for majority Black and Hispanic neighborhoods at lines 19 and 20. Those percentages are lower in 2024 than they were in 2021, correct?
Or for households at median income, yes.
Okay.
Noting that on at page 11, for example, I point out that the 2021 report, majority white neighborhoods had a median energy burden of 2.1%. Yes.
Okay.
And that applies to each of these numbers.
And those median energy burdens fell from 21 to 2024, even as utility rates increased over that same period, correct?
The numbers in exhibit Colton-8 are lower than the 2021 numbers. Yes, at median income.
And just to be clear, that's true even though utility rates were increasing over the same period, right?
Objective form, are we just talking about WEC utilities? Or are you talking about other utilities?
That's a fair revision to my question. I'll accept it. I'm asking here specifically about WEC utilities rates.
The answer to your question is yes.
Thank you. Indeed, being that this is a report about the Metro Milwaukee area, these are all Wisconsin Electric and Wisconsin Gas customers that we're talking about here on page 25, right?
Yes.
Doesn't this show that gains in income in these communities are outweighing relatively smaller increases in utility rates?
No, that's, or not necessarily. The numbers that I talk about on pages 25 and 26 are again based on median income, and the affordability issues that I identify and discuss throughout my testimony are based on low incomes. And I talk in a variety of places about the different definitions and the different ways to examine low income. So you might say that people at median income were experiencing a lower burden, but that has nothing. That does not indicate that the affordability issues for low income households improved in the same time.
Okay, so your testimony consistent with lines 20 and 21 on page 25 is that there were slight increases in median income that have lowered median energy burdens, but you're pointing out now that there may not have been corresponding gains in low income over the same period.
I think I pointed that out in a variety of places in my testimony, but yes.
Okay.
Yes, I would. I agree with you that it's important to look at that line on that statement on lines 20 and 21, that slight increases in median income with the emphasis on the median have lowered median, but again, with the emphasis on the energy, on median energy burdens.
Thank you. Turning to page 26 of your direct testimony, you go on to say that the lowest income households are experiencing a higher energy burden in 2024 than they were in 2021, correct?
I see that on lines 6 and 7.
Have you calculated that yourself?
No, I relied upon the Sierra Club, the update to the Sierra Club report, which was attached as an exhibit.
And do you know whether the absolute number of lowest income households has gone up or down in the Metro Milwaukee area since 2021?
I do not.
Turning now to page 27, looking at your table 6. This shows what you call household energy insecurity at various annual household income levels based on a Department of Energy survey conducted back in 2020, correct?
That's correct. Published in 2020, yes.
So perhaps conducted even earlier.
Yes, I would, yes, perhaps.
Is any of this data in table 6 specific to applicants' service territory?
No.
Have you performed corresponding analysis for applicants' service territory?
No.
Have you performed any analysis to determine whether the percentages in table 6 would still be accurate today?
If I heard your question correctly, have I repeated this analysis at a subsequent date? No.
Thank you. Now turning to page 29, looking at your table 7. This shows what you call energy reduction actions in response to inability to pay by range of federal poverty level, correct?
That's correct.
And this is based on a National Energy Assistance Survey in 2018?
That's correct.
Is any of this data in table 7 specific to applicants' service territory?
No.
Have you performed a corresponding analysis for applicant's service territory?
No,
Have you performed any analysis to determine whether the percentages in table 7 would still be accurate today?
no.
Turning to page, or staying on page 29, I should say. You state at line 8 that you do not address revenue requirement issues in your testimony, correct?
That's correct.
So you have no basis to dispute applicant's total cost of service, correct?
I have expressed no opinion with the exception of the lift credits. Of course, I've expressed no opinion and presented no testimony one way or the other.
And you don't dispute the basic principle that one way or another, applicants' rates must collect 100% of their cost of service, correct?
Oh, I'm not sure I agree with that at all.
Tell me more.
In fact, I would disagree with that.
Can you explain your disagreement with that statement?
Absolutely. A utility rate case is designed to set rates such that revenues and expenses in the future will provide an opportunity to the utility to earn its authorized rate of return. But your question asks whether a utility must recover 100% of its costs, and that's simply not the case. Hard stop.
I understand. We may be getting hung up on a difference between what happens after rates are set and how rates are set in the first place. So let me rephrase my question in terms of how rates are set in the first place. Would you agree with the basic principle that rates should be set such that the utility is able to recover 100% of their cost of service?
I'm going to object to this line of questioning because I think Mr. Colton already articulated that he's not offering an opinion on this issue.
Okay, I'm going to sustain the objection.
Well, may I be heard, Your Honor?
Sure.
Mr. Colton does, as we'll get to in a minute, and as he just referenced in his answer, offer opinions about whether the utilities should be able to recover the costs of their lift program. So as a subset of the revenue requirement, my question is asking Mr. Colton whether rates should be designed to recover 100% of the utilities costs, which would include the costs of the lift program.
I think that's a different question than asking Mr. Colton about the cost of the lift program.
And respectfully, I'm just trying to understand whether we agree on basic principles or whether we have to discuss those before getting to the specifics. And right now, it's not clear to me that we do.
Okay, go ahead with your questions.
My question is simply, as foregrounding for our discussion of the lift program, do you dispute the basic principle that one way or the other, a utility's rates should be designed to give them the opportunity to recover 100% of their costs of serving customers?
I think I would disagree with that as broadly as you've stated it. Rates are to be set so that the utility has an opportunity to earn its authorized rate of return. When you and looking at the recovery of costs is a way to get there. But when you broadly state recover 100% of its costs, there are so many squishy, that's a term of art, words in there. So I think we could talk all afternoon about what constitutes a cost. We could talk all afternoon about whether simply because a utility incurs a cost, whether it's entitled to recover the cost. We can talk all afternoon. Well, there are too many words in your broad, very, very broad statement that each of us could put our individual meanings on, that I could not broadly agree with your statement. No.
Okay, and as pleasant as this is, I'm sure neither one of us wants to talk all afternoon, so I'll move on.
It's more beer conversation than testimony conversation.
That's fair. Do you acknowledge that any proposal for certain customers to pay less based on their income would require other customers to pay more?
No.
Is that a no?
Yes, that was a no. The answer to your question is no.
Okay. Assuming two customers have the same usage, what Wisconsin legal authority would authorize the commission to set lower rates for one of them based on their income?
Objection calls for a legal conclusion.
I believe Mr. Colton is an attorney.
Right, he's testifying as a witness. He's not acting as Walnut Way's attorney in this case.
Your Honor, if the answer is I don't know, that's fine. I just
overruled.
And I'll
Would you
object
like-
to foundation.
Could we have the question read back, please?
Question, assuming two customers have the same usage, what Wisconsin legal authority would authorize the commission to set lower rates for one of them based on their income?
And then my objection after, in addition to the one that was overruled, is object to foundation.
Okay, so in his direct testimony, does he not indicate his law degree received in 1981? Is there more foundation we need to lay?
Well, and the concern is that he's not here as a Wisconsin licensed attorney. I don't want to make him give testimony about the law. If that's not his background. And
Your Honor, if his answer is he's not aware of any legal support for his position, I'm fine with that answer. I'm just trying to make my record.
And whether he is aware of that still gets to the objection.
All right, overruled.
My answer would be that's a legal conclusion that I would leave to the Walnut Way attorneys, although I would note that the commission has approved such programs in the past, including the LIFT program on the representation by the company to the commission that the program would be cost neutral. In addition, while I have not looked at Wisconsin specific law, I do note that in other jurisdictions, because I was part of a research team that looked at the legal basis for income qualified programs, that there are other jurisdictions that have found that having a program which provides lower rates to payment troubled customers, income qualified payment troubled customers, actually generates improved payment patterns, and that they should not be viewed so much as a social program or a low income discount as they can and should be viewed as a way to address and to improve those payment patterns.
Following up on the portion of your narrative answer referring to the previous tariffs approved by the Wisconsin Commission, Are you aware that the utilities in those cases offered those tariffs voluntarily?
Your original question didn't distinguish between programs that were offered voluntarily and programs that they were directed to implement.
Are you aware that those tariffs were offered voluntarily?
I'm not sure. I would say, at least with the LIFT program, that it was offered voluntarily. I believe when you trace LIFT back, there is a commission order directing the company to convene a low-income task force and to develop a program. So unless we could come to an agreement on what you mean by offering the program voluntarily, I would not agree with that.
And those orders that you're referencing would speak for themselves, correct, sir?
I think commission, well, consistent with what I said before, I think commission orders would speak for themselves. In saying that, I would not go so far as to say that commission orders are always completely unambiguous and that reasonable people could not interpret commission orders differently.
Turning to page 30 of your direct testimony and your table 8, this presents the difference in residential bills given rates requested by applicants and rates found reasonable in commission staff's audit, correct?
Yes. Table 8 on page 30. Yes.
Thank you. My first question for you here is, what do these dollar amounts represent? The $11.91, for example.
The monthly rate increases.
Monthly rate increases. Okay.
Yes.
And that's again by utility, correct?
That's correct.
Does this analysis in table 8 attempt to differentiate between electric only, gas only, and combined customers?
No, these numbers were taken directly out of the source documents that are cited in the footnotes and that were provided as exhibits. So
okay,
these are not my numbers. These numbers are numbers provided by the company and provided by the staff.
Okay, and using those numbers, you did not attempt to differentiate between electric only, gas only, and combined customers for purposes of table 8, correct?
That's correct.
In part 2 of your testimony, which begins right below table 8 on page 30, you emphasize an order point on alternative low-income assistance programs from applicant's last rate case, correct?
I do quote a commission ordering point there, yes.
Nothing in that order point that you see there beginning at line 7 of page 30 says that a percentage of income payment pilot needs to be fully developed by now, does it?
I agree with that.
And the commission has opted to implement that order point through a separate docket, 5 UI 121, that it initiated in March of 2023, correct?
I agree that the commission has begun a document to consider whether, and if so, whether to implement a percentage of income pilot, yes.
And applicants are participating in that docket?
Yes.
Walnut Way is participating in that docket?
Yes.
Is it your opinion that the parties are participating in that docket in good faith?
Check to relevance.
Your Honor, may I respond? Oh, thank you.
Overruled.
None of the parties have explicitly done something that would indicate bad faith to me.
Is
So
it your?
the answer to your question is yes.
Thank you, and I apologize for speaking over you. Is it your position that applicants are responsible for setting the pace in that docket?
It's my position that the actions of the applicant can facilitate or slow down the pace of that of that docket. Yes. But the docket, the scheduling is really driven by staff.
Is it your position that applicants should be developing a percentage of income payment pilot outside the docket the commission has established for doing so?
Well, I'm not sure what you mean by outside the docket. I believe that the expectation is that the company will, as well as other stakeholders, will develop a percentage of income pilot that would eventually be presented to and considered through the docket. Yes.
Thank you. At pages 32 and 33 of your direct testimony, you, and let's focus specifically on page 33 at lines 11 to 16. You have a proposal there for a date certain for presenting a percentage of income pilot and alternatives to the commission, correct?
I do.
The date certain you propose for a final recommendation from the PIP pilot collaborative is March 1st, 2025, correct?
It is. On
But
line
then the
16.
date, I'm sorry, I lost the end of
On
your
line
answer.
16.
Thank you. But then the date certain that you propose for a set of alternative low-income programs, in addition to LIFT, but excluding the PIP pilot, is January 1st, 2025, correct?
It is.
Are you aware that the commission's order in a rate case like this one typically comes out in late December?
I have no knowledge one way or the other of the timing of a commission order.
Knowing that now, is it really your position that the commission should give the companies at most a week or two over the holidays to develop what you call a set of alternative low-income programs?
Objection, argumentative.
Overruled.
May I be heard?
Overruled.
What I believe is if the commission believes that the January 1, 2025 and March 1, 2025 deadlines are not sufficiently after when a final commission order would be, that the commission in its wisdom could adopt the principle of setting a date certain and establish what that date certain should be.
Turning to your second recommendation, beginning at the bottom of page 33, you suggest that the commission delay implementation of new rates until the company complies with prior orders directing adoption of low-income programs, correct?
Yeah, the reason I hesitate is because of your use of the phrase low-income programs. What my testimony states here is that there were very specific orders provided to or directed toward the company, which the company did not comply with. And I identified those two orders and state that the commission should enforce its orders through delaying implementation of new rates.
So this proposal is conditioned on the commission finding that the companies failed to comply with those prior orders that you referenced, correct?
That is, yes.
If the commission finds that current rates are inadequate, what Wisconsin legal authority would authorize it to delay setting just and reasonable rates?
The same objections to this question as of the prior one requesting Wisconsin legal authority calls for a legal conclusion and foundation. Thank you.
Okay, overall.
I think your question is too ambiguous to be responded. For me to respond to the specific legal authority that the commission has to enforce its own orders is something that I believe would be inherent in the commission's authority. You said to set just and reasonable rates. I think that's another one of those buzzwords that, or buzz phrases that you included in your question, but that has all sorts of judgment and behind it. The question isn't answerable as asked.
Okay, just to be clear, we're talking about a proposal that the commission use its inherent authority to enforce its own orders to delay implementing rates, having found that current rates are inadequate. And your position is the Wisconsin Commission can do that?
Yes.
And my question is based on what?
I think the legal authority for that is a question that I would need to leave to my attorneys, to Walnut Way's attorneys.
Fair enough. Turning to your third proposal on pages 34 and 35, starting at 34:14. This proposal relates to a moratorium on utility shutoffs for low-income customers, correct?
That's correct.
And this moratorium would also be conditioned on compliance with the commission's prior order point in on low-income options, right?
That's correct.
So if the applicants are already complying with that order point, there would be no basis for this moratorium either, right?
Your question assumes if applicants are complying. If the commission finds that when it said that the company was to consider alternative low-income programs prior to the next rate case, and that they have complied with that, then there would not be a need for an enforcement order. Yes.
Do you believe that such a moratorium would increase applicants' uncollectibles?
No.
Why not?
Oh, I have done significant research on the relationship between disconnections and increases in arrears, increases limiting my response to residential arrears, residential disconnections. There are a variety of things that I found. One is that the ability to disconnect service has to a residential customer in arrears has very little, if any, relationship to the level of arrears. Number two, and I published an article in the Electric Power Journal looking at an empirical analysis of data from Iowa. There is a study that the Bureau of Consumer Services of the Pennsylvania PUC.
I'm sorry,
did.
I'm sorry, sir. Bureau of what services?
The Bureau of Consumer Services of the Pennsylvania PUC did, which found that disconnections and uncollectibles don't have a relationship. I did work in Rhode Island relating to National Grid, which found that the rate of disconnections and uncollectibles were not associated. I did work in California with respect to the disconnections of people with medical certificates, which gave rise to disconnection protections, which found that there was no relationship. One thing that my work in various rate cases that have looked at the issue over the years have found is that a utility rarely, if ever, disconnects service to everybody whose arrears might merit disconnection or might qualify it for disconnection. And so if a utility cannot disconnect service to customers A, B, and C, they instead redirect their collection efforts to customers X, Y, and Z. So there is no basis whatsoever to conclude that prohibiting or barring disconnections for a subset of customers would necessarily increase uncollectibles.
Are you aware of research showing that a policy of disconnection for non-payment in fact causes customers to prioritize paying their utility bill over other bills?
Nothing recent, at least. I'm not aware of anything recent. Indeed, in virtually every one of the 300 plus rate cases that I've participated in as a witness or a consultant, one of the discovery questions I've asked is provide any study or other document which documents a relationship between the disconnection of service and either the reduction in uncollectibles or the acceleration of payments. And not one single utility, zero utilities, has provided such a research document.
Your Honor, if I could at this time, I'd like to pull up the cross exhibit that we circulated along with our pre-hearing disclosures.
Okay, let's go off the record for a second. We may be in need of a break here. So how many questions are you anticipating for this witness remaining?
Oh, I would say I'm about halfway through.
Okay, so I think I'm saying we should probably break. So let's do a 10-minute break and we'll try to get to another one in a much quicker time coming up next. But at this point, let's break for 10 and we'll come back and continue.
Thank you, Your Honor.
All right. letting someone in who dropped out of Zoom. Here we go. All right. Well, let's get back. We still have questions for witness Colton, so go ahead, Attorney Goldschmidt.
Thank you, Your Honor. Just before the break, I had asked that we pull up the cross exhibit that we had circulated with our pre-hearing disclosures. That's the one. And just would ask that this be marked as Colton 31 for discussion purposes.
Okay, we can do that. And just give us the title for the record.
Yeah, this is an article titled Understanding Why Customers Don't Pay, the Need for Flexible Collection Practices, parentheses, revised, close parentheses, prepared by Roger Colton, dated January 1991.
Okay, great, thanks. You marked
Did you say
it.
1991? 1991? Okay, thanks.
Okay, so we marked that as Colton 31. Go ahead.
Mr. Colton, do you recognize this document that we've marked as Colton 31?
Yes.
Are you the preparer of this document?
Yes.
And if we turn to the first page of text, which is PDF page 2, the first sentence says, the first step of analysis in seeking to respond to problems involving utility customer non-payment is to determine precisely why households might not pay their bills. Do you see that?
I do.
Is that the general purpose of this study, as you recall it?
Well, clearly the study is 33 years old. So to remember the purpose of the study here 33 years later it involves a stretch, but the title refers to flexible collection mechanisms, and this refers to the need for flexibility.
And you have no basis to dispute that you prepared this study yourself, correct?
I think I already answered that question.
Okay, just part of my standard exhibit offering patter. So at this point, Your Honor, we would offer Colton 31 into evidence.
Any objections? Okay, it's in.
Thank you. If we turn to PDF page 13 of Colton 31, we see here a reference to a Wisconsin study, and specifically a 1983 study by the Wisconsin Public Service Corporation. Do you see that?
I do.
And Wisconsin Public Service Corporation, or WPSC, is the sister utility of the applicants in this case, correct?
I will accept that, yes.
In fact, you've offered, strike that. If we turn to page 19 of the study, PDF page 19, there's the beginning of a discussion there at the bottom of the page about a group that was surveyed on which bills to pay first if they had to make a choice. And 79% of respondents said that they would pay the utility bill first. Do you see that?
Yeah, it refers to this group. I would need to go back and look to see what that reference is to.
Okay, if we go to the bottom.
Anything else to add?
Yes, I see. Having said that, I see the sentence that you point out.
Okay. Okay. Thank you. And if we go right to the top of PDF page 20, there's a sentence there that says, the reason the utility bill is paid first is because it represents an essential service and is subject to disconnection for non-payment. You see that?
I do. Again, with the reference being to this group, and one would need to read the paper to determine what group this group refers to. Yes.
Okay. And if we, just for the record, go back to the bottom of page 18. We see a reference there at the bottom of the page to households in group 1. Do you see that?
Yes.
Okay. Any basis to dispute your own description of that finding?
Check to form.
Okay, I guess we could be more clear with the question.
Okay, if we go back to page 20 of the PDF, the statement there is the reason the utility bill is paid first is because it represents an essential service and is subject to disconnection for non-payment, correct?
I see that sentence.
And those are your words, correct?
Yes, with a citation.
And if we go to page 21, we see another set of statistics there, this time relating to group 2 households. And in group 2, 77% say that they would pay the utility bill first, correct?
Actually, that's not what that's not exactly what this paper said. If you go back to the page, and I have these printed, so before the immediately preceding page to the one that's on the screen.
Oh, from this one. Okay.
Okay, so what this report or what this paper stated is if this group had to make choices in which bills to pay first, they would pay the bills in the following order. So there is a bit of nuance that the paper presents that are not picked up. The nuance isn't picked up in the sentences that you're cutting out.
Okay, and for the record, we're looking back at page 19 of Fulton 31 now. If we go back to page 21, which is where I was, my question is simply for group 2 households, if they had to make choices in which bills to pay first, 77% would pay the utility bill first, correct?
Again, with the same observation that that this group of households was provided a set of 4 options, and they were required to make a choice between those 4 options. So given the nuance that the paper presents, I would agree that you read the words that are on that piece of paper.
Okay, and that is in fact a choice that low income households do sometimes have to make, isn't it?
When you say that is a choice.
The choice of which bills to pay first.
Well, but that's not what this paper says. This paper says if you had to choose between paying the utility bill first, the telephone bill first, the gas credit card first, or the charge account first, it doesn't. This paper doesn't talk about paying bills generally or making other not lifestyle, but household choices. It presents 4 options and said within those 4 options, if you were required to make a choice, if you had to make a choice, which one of these would you pay first?
So is it your testimony, sir, that low-income households do not have to make that choice?
Again, I would ask what you mean by that choice.
The choice you just referenced in your answer.
I would say that, yeah, I wouldn't say that households are required to make a choice, the choice between these four particular options. No.
Okay, and if we go to the top of page 22, for group 2, the first sentence says, as with group 1, the reason the utility bill is paid first is because it represents an essential service and is subject to disconnection for non-payment, correct?
Yes, referring to group 2, which is
And-
defined in the paper, but which we haven't defined today.
That's fine. And those again are your words, correct?
Yes, with a citation.
Okay. If disconnection for non-payment incentivizes customers to pay the utility bill first, then a moratorium on disconnection would reduce that incentive, would it not?
Object to form, I think and I think it mischaracterizes the testimony of the witness and his testimony. That these are apples to apples comparisons.
Okay, I think the witness is capable of responding, so let's hear what the witness has to say about that.
I would need to reread this paper that's 33 years old to determine what group what characteristics are group 1, what characteristics comprise group 2, to determine who we're talking about. But the mere fact that there are 4 different groups would indicate that that the answer could well be different between each of the 4 groups.
All right, and my question wasn't about what the paper says. My question is, if disconnection for non-payment incentivizes customers to pay the utility bill first, then a moratorium on disconnection would reduce that incentive, wouldn't it?
And my answer to your question is, I do not agree that the disconnection of service incentivizes customers to pay first, but accepting exclusively for the purpose of this answer to your question as presented, I would agree with that. But I disagree with the underlying assumptions in your question.
Okay, and continuing with the premise, which you disagree with, that would result in some increase in non-payment, wouldn't it?
Object to form.
I'm sorry.
Overruled.
Thank you.
Necessarily, no.
Let's turn to your 4th proposal on page 37 of your direct testimony.
I just have I want to interject here just for a brief question. I just wanted to make sure I understood that the exhibit were Colton 31, the context of the quotes that we were looking at, that conclusion statement about what was it? So I just said the conclusion about disconnection being the motivation for choosing the utility as the first payment option. And I don't have the right language in front of me, but that's you. I just wanted to make sure, witness Colton, I'm understanding you are reporting what the results of the study said, or were you making that as your conclusion?
Well, this paper is, as you can see, is heavily footnoted. So I was seeking to report on existing literature.
Right, okay, I just wanted to make sure I understood that. Okay, go ahead. Option 4, or issue 4, what was that?
Yes, well, maybe one more question before we move on, Mr. Colton. If this proposal of yours, a moratorium on utility shutoffs for low-income customers does increase uncollectibles, who should pay for that increase?
Objection assumes facts not in evidence.
It's a hypothetical.
Okay.
So over.
Again, understanding that that I disagree that a moratorium on disconnections for low-income customers would increase uncollectibles. My answer would be it depends.
Okay. Turning to your fourth proposal now on page 37. Your fourth proposal is no late payment charges for low-income customers, correct?
Yes.
Okay. If we're not disconnecting for non-payment and we're not charging late payment charges for late payment, what incentives are left for timely payment of customer bills?
That question assumes that late payment charges are an incentive to pay for low-income customers. And that I think is a demonstrably erroneous assumption that the way to incentivize somebody who already can't afford to pay, to make their payments is to increase their bill even further. That response would be counterproductive rather than productive.
I understand your view on that, sir, but my question is different. It's if we take that off the table, and if we take disconnections for non-payment off the table, are there any remaining incentives for customers to pay their bills on time?
Of course, there is the incentive that that people want to pay their bills on time. That it is not the case that the only way to get people to pay their bills is to use a hammer to coerce that payment. The incentive is that if people can enter into payment plans that they could retire their bills over time. The incentive is that if customers may not enter into budget billing, if they have a pre-existing arrears, then there would be an incentive. The incentive would be that if you aren't paying your bills, your family, your friends, your neighbors know that you're a scofflaw. So again, the fundamental basis of your testimony, of your question, that only coercion is the way to get people to pay their bills is an error.
Okay, your answer referred to a number of programs that could be put in place after bills fall behind. But as to paying bills on time in the first place, I think I heard you say the incentives are people's natural inclination to pay their bills and that your friends and family might find out if you don't. Is that accurate?
I did say that, but the more accurate characterization is that whether or not I can develop a comprehensive list of the incentives on why people pay their bills here on the witness stand, after looking at a 33-year-old document, misses the point that disconnections and late payment charges are not the only way to get people to pay their bills on time.
Okay. Have you calculated the financial effect of this proposal?
No.
Okay, looking at page 40. At the top of the page, your rationale for exempting low-income customers from LPCs is tied to applicants' alleged failure to comply with the Commission's prior directive on developing alternative low-income assistance programs, correct?
I don't see the word alleged there, but otherwise, yes.
Okay, you have not offered any rationale for this proposal other than this failure to comply, correct?
The rationale for the proposal is that when I, testifying on behalf of Walnut Way, presented this recommendation in the company's last rate case, the commission told the company to consider alternative low-income assistance programs, including a consideration of the proposals that I made on behalf of Walnut Way prior to this rate case, and that given the failure to do that, that this is an appropriate response.
So if the applicants are already complying with those order points, there would be no basis for this exemption, right?
That basis for this exemption would go away, yes.
All right, and then turning to your fifth recommendation at the bottom of page 40. This one is for no disconnection or reconnection fees for low income customers. Your rationale for this proposal is likewise tied to applicants' alleged failure to comply with the Commission's prior directive on developing alternative low income assistance programs, correct?
That is a rationale, yes.
Okay, so similar to these other proposals that we've discussed, this proposed exemption would not hold if the commission finds that we have complied with these order points that you referenced, correct?
The commission could easily decide that these proposals are reasonable, that it is irrespective of whether the commission finds that the company was in compliance or non-compliance, that with the late payment charges and the reconnect fees in particular. I talk throughout my testimony about the relationship between unaffordable bills and payment difficulties and the irrationality of taking a customer who cannot afford to pay their bill with which to begin and to respond to that inability to pay due to unaffordability by increasing the bill even further.
But the rationale you offer for your...
Before we move on, while we're on this page, it may be easier to do it here. I just noticed you use the acronym again, WEC, in relation to these recommendations. And I just wanted to be clear that when you're using this reference for these recommendations, you're talking about all the applicants in this case, or you're talking about specific subsidiaries? And
no, all.
Okay, so would it be fair to replace WEC with applicants, plural apostrophe? Or we could be specific with the subsidiaries. Either way, I guess will work. But I would just be clear as to who these recommendations pertain to, rather than using the holding company acronym. Okay.
We will do that. Yes.
Right. Okay, proceed, Attorney Goldschmidt.
Thank you, Your Honor. So just closing out this fifth recommendation, The only rationale you've given the commission for this proposal in your testimony is the applicant's alleged non-compliance with commission's prior order points, correct?
The rationale for exempting low-income customers from exempting low-income customers who are having payment difficulties from paying increased bills because of those payment difficulties is discussed throughout my testimony. When I discuss time and again the relationship between unaffordable bills and payment difficulties.
Okay.
So
let's talk a little bit of
to take an unaffordable bill that hasn't been paid and to try to generate payment of that unaffordable bill by increasing the bill even further through a late payment fee or reconnect charge is unreasonable. And that's what the paper that you had introduced as an exhibit talks about when I talk about the need for flexible collection mechanisms.
So your testimony is now that the commission should adopt this recommendation regardless of whether the WEC utilities are complying with the order point you referenced?
What I'm saying is that the commission would have a basis to order these irrespective of whether the commission makes a finding on compliance or non-compliance with the directive to develop alternative low-income assistance programs prior to the next rate case, with the next rate case being this rate case.
Okay. Let's talk a little bit about the LIFT program. You generally recommend expanding the LIFT program, right? Proposing several modifications that would broaden eligibility.
That form, and misstate the testimony, I believe.
Okay, is there something you can point to with respect to your question?
Sure. Why don't we go to page 8 of Mr. Colton's direct?
8?
Page 8. And here on page 8, Mr. Colton, you propose a number of modifications to the LIFT program, including reducing the level of arrears required to be a part of the program from $300 to $120, to remove program eligibility criteria requiring a prior EAP grant to the customer, and to extend program eligibility to any customer who has received SNAP assistance in the last 12 months, correct?
I see those, yes.
All right. So you generally recommend expanding the LIFT program by proposing several modifications that would broaden eligibility for that program, correct?
Yes.
But then you also recommend denying recovery of the company's LIFT costs through rates, correct?
Yes.
Aren't those two recommendations inconsistent?
No.
Well,
And I may have said yes too quickly in response to your last question. My recommendation is that the company not be allowed to separately recover LIFT costs through an increase in its uncollectibles. And the reason for that is that those costs are already in rates, number one. And number two is that the company should only be allowed to recover the net costs of a program, not the gross costs.
Okay. Your position is that expanding LIFT would be prudent and in the interest of serving customers, right?
I agree with that.
Expanding eligibility.
Sure, I'm happy to phrase it that way. Your position is that expanding lift eligibility would be prudent and in the interest of serving customers, correct?
Any lift eligibility in the ways that I have presented in my testimony, yes.
Okay, but the commission should be able to order the applicants to do that without recovery of their costs?
Object to form.
Overruled.
Your question assumes that unless the company recovers its lift costs through its uncollectibles as it has been presented in this proceeding, that they are not recovering their uncollectibles. And that is an assumption with which I disagree.
We turn to page 45 of your direct testimony. Here you're recommending that in addition to the percentage of income payment pilot,
I'm sorry, here you're recommending.
that in addition to the percentage of income payment pilot, the commission should also require the company to implement a modification to lift that takes account for customers' income, correct?
I do, yes.
Okay. What is the point of a PIP program based on customer income if applicants are separately redeveloping lift based on the same thing?
I have that question read back.
Yes.
Question, what is the point? Sorry, question, what is the point of a PIP program based on income if applicants are separately redeveloping lift based on the same thing?
I don't understand that question.
Well, the purpose of a percentage of income payment pilot is to give customers assistance with their bills based on their level of income, correct?
No, the purpose of a percentage of income payment pilot is to provide customers with a bill that is affordable, such that the company will be able to improve the payment patterns of program participants. The purpose of a PIP is not simply to distribute money to distribute discounts to low-income folks.
If the purpose of PIP is to give customers a bill that's affordable, we use information about those customers' income to inform what that bill should be, do we not?
That's correct. Well, whoever is responsible for the enrollment, yes.
And with respect to the company's current lift programs, you are here proposing that we use information about customers' income to inform what their bills should be, correct?
To inform what the credits that they would receive, yes.
So what is the difference between those two things?
Check to form.
Overruled.
Percentage of income plan is forward-looking. It applies only to bills for current service. The LIFT program has an element of that to it, but the LIFT program is directed toward pre-existing arrears that were incurred at a time when a low-income customer was receiving an unaffordable bill. So the LIFT program is designed to give people a fresh start, so they're not receiving an affordable bill for current service, but facing an inability to pay because they have a pre-existing arrears from when their bills were not affordable. So they're two completely different programs. Well, they're not completely different. They are self-supporting, but they have two different objectives.
When you refer to the various expansions of eligibility that you've proposed for the LIFT program, have you calculated the cost to the company for any of those eligibility expansions?
I have not calculated the net incremental cost, which would be the cost that should be subject to recovery, no?
And just to be clear, you haven't calculated the gross cost either, correct?
That's correct.
If we turn to page 51 of your direct, line 17, you say that while LIFT participation continues to grow, it remains at a fraction of the potentially eligible customers in arrears. Do you see that?
At page 51, which line again?
17.
Oh, of course. Yes, I see that.
If it's true that LIFT participation is not currently reaching enough eligible customers, wouldn't it make sense to focus on reaching more of those customers before expanding eligibility?
No, we're talking about your question is confusing two different things. The eligibility is low income as defined in Wisconsin. People at or below 150% of poverty. We talked earlier about expanding eligibility, and we're not expanding eligibility beyond that low income population. We're expanding the scope. We're doing exactly what your question now just asked about. We're expanding the ability to identify and enroll that population of customers below 150%. So by expanding the program to people on receiving SNAP assistance, we're not making the population of at or below 150% bigger. We're expanding the ability of the company to reach and enroll that population that is at or below 150% of poverty.
Looking at the current universe of the applicant's customers who are eligible to participate in the LIFT program as it's currently constituted, do you know what percentage of those customers are currently participating?
No.
Is that something you would want to know before deciding whether to expand eligibility for the program?
Again, referencing the conversation we just had about what is meant by expanding eligibility, my answer would be no, I wouldn't need to know that.
Okay. Let's turn to your discussion of what you call the racial implications of the applicant's billing and collection practices. This starts at page 54 of your direct testimony. It's part 4 of your testimony. Is the Public Service Commission of Wisconsin authorized to account for customers' race in setting rates?
Public Service Commission is directed to adopt just and reasonable rates. I would think that if there are racial disparities in collections or in the non-payment of bills or the inability to pay for bills, that the commission would clearly have the authority to inquire, and having inquired to direct whatever relief the commission deems would be appropriate. Yes.
I just want to be sure I understand. It's your position that the Public Service Commission of Wisconsin can set different rates for customers based on their race?
Objection. I think that's argumentative, and I believe that misstates the testimony.
That's what.
Okay, I'll sustain that objection.
Is it your position that the applicants know the race of any of their customers?
Dr. Form.
Overruled.
I have that question read back again.
Yes, go ahead.
Question, is it your position that the applicants know the race of any of their customers?
Yes.
How would they know that?
Well, unless the companies have no contact whatsoever with their customers, and I would suggest that that is not the case. They would have occasion. Your question was whether they would know the race of any customer, and I think that they would. They being the companies.
Do you think the companies in general know the race of each of their 1.1 million customers?
That's a different question, and I would agree that the companies would not.
Okay. Should we be asking the applicants to collect that data?
Should we be asking the applicants to collect data on the race of each of the company's residential customers? Is that your question?
That is my question.
No.
Okay. Is it your position that applicants should be making assumptions about their customers' race based on the zip code where they live?
It is my testimony that one can do reasonable studies of the racial implications of the affordability of bills and of the consequences of collection activities based on zip codes. Yes.
If we look at your tables, table 14 on page 58 of your direct, this shows what you say would be the impact of applicants' proposed rate increases on the affordability of electricity for majority non-white census tracts in Milwaukee County at the second and third quintile of income, correct?
Yes.
And if we look at table 15 on page 60 of your direct, this shows what you say would be the impact of applicants' proposed rate increases on the affordability of electricity for concentrated non-white census tracts in Milwaukee County at the second and third quintile of income, correct?
Yes.
How does your analysis in tables 14 and 15 compare to the impacts of the proposed rate increases for the second and third quintile of income as a whole?
I don't know. I didn't do that inquiry.
If that's the case, then what role is race playing?
The role that race plays is the role that I present in my testimony here.
But if you haven't compared,
right. Let me back away from that quite. I didn't say that race plays a role. What I said is that there is a definable, quantifiable, disparate impact based on the racial composition of zip codes. And knowing And it's one thing not to know that that exists, but knowing that disparate impact exists, and to then suggest that there is no role for the company to address why that impact exists or what might be done to address that disparate impact is what my testimony gets to.
Okay, my question is just seeking to confirm that your tables 14 and 15 do not control for income in an attempt to isolate race, correct?
They control for income to the extent that I looked at the second and third quintiles of income. Yes.
But only for certain census tracts. You don't compare those census tracts to the second and third quintile of income as a whole, correct?
You already asked that question and I answered that that's correct.
Okay, so don't these tables just show that race and income tend to correlate?
I believe my testimony is that that's one of the very questions that that you should inquire into, knowing that there is a disparate impact as I have presented. The company should, if it doesn't agree to do that on its own, it should be directed to make those inquiries and should be directed to determine not only the why, but the what remedy would be appropriate, and should report to the relevant civil rights entities that I articulated.
We look at your proposal on page 81 of your direct to deny recovery of lift uncollectibles. Would you agree that any arrearage forgiveness under lift now would, if not forgiven, be bad debt later?
I agree that the company previously stated that it believed that 100% of the lift credits would have become bad debt even in the absence of the program. Yes.
And would you agree that applicants would traditionally be permitted to recover those bad debts amounts if they were eventually written off?
Oh, yes, absolutely. I agree with that.
If that's the case, then why shouldn't applicants have the same right to recover those same amounts if they're forgiven sooner under lift?
The question would become, as I've talked about in my testimony, whether you are already including them in rates. And I agree that the company has the right to include uncollectibles in rates, but I do not agree, as I explain in detail in my testimony, that the company has the right to first collect the uncollectibles in rates and then again collect those same dollars through separate inclusion of lift credits.
Finally, turning to your proposal to disapprove applicants' insufficient funds fees, which begins at page 90 of your direct. You devote a fair amount of attention to applicants' comparison to industry standards for financial institutions. Do you recall that portion of your testimony?
I do.
Do you understand that the companies were comparing their individual insufficient fund fees to those charged by major financial institutions?
My understanding is what was set forth in my testimony, which is that when Walnut Way asked the company to provide the basis for its assertion that imposing an NSF fee, a non-sufficient fund fee, would incentivize people to not pay with financial instruments with insufficient funds, that they cited those banks or those financial institutions. And my testimony was that that was an inappropriate or not inappropriate. That was an unreasonable conclusion to reach, and that the company has no basis to assert that an NSF fee has any incentive function whatsoever.
And that's based on your opinion that NSF charges for financial institutions are major profit centers, correct?
That's part of it. The other part of it was the testimony I presented in my rebuttal, which talked about the studies, or in maybe the litigation by the federal government, which found that financial institutions were posting payments in order to maximize the imposition of NSF fees. So the NSF fees were not being used to incentivize a customer from avoiding having insufficient funds, but they were being used for exactly the opposite purpose.
All right, so you don't have any evidence that the applicants in this case are doing that, do you?
I already stated that my testimony was in response to a very specific discovery request to the company, asking for the basis upon which the company reached the conclusion that NSF fees served an incentive function. And I responded to the company's response to that discovery request, providing what the company said was its basis.
And part of your basis for disagreeing with that comparison is because the banks are up to no good with their NSF fees, correct?
Objective form and argumentative.
Overruled.
The company said the reason we believe that there is that NSF fees serve an incentive is because we've looked at these bank fees. And my response is those bank fees are not being used as an incentive. So if that's a yes to your question, then the answer is yes. But I believe that saying yes understates what my testimony is and what the company said its own rationale was.
But Mr. Colton, if your basis for disagreeing with the NSF fees at the banks being used as a comparison in this case is that there's evidence that the banks are using them improperly, my question to you is, do you have evidence that the utilities are using these fees improperly in the same way as those banks?
Well,
that's a yes or no question.
No, it's not a yes or no question. The utility said we propose an NSF fee of X dollars because the banks have NSF fees of X dollars. My testimony says that those bank fees are unreasonable and are unreasonably used. I think one can then reasonably reach the conclusion that, well, if you're relying upon an unreasonable basis, then your fees are also unreasonable.
I think
Mr.
the record is
Colton,
clear. I think the record is clear on this point.
Your Honor, I still have not gotten an answer to my question of whether he has evidence that the utilities are treating NSF fees the way he says that banks are. It's a yes or no question.
I don't think that's within the scope of the testimony. He's explained the reason for his explanation about bank fees, and there's nothing to do with whether the company has the same motivation or not. He's just responding to the company's explanation and its citation for referencing the bank fees, and that's as far as it needs to go.
Your Honor, may I make a record on this?
Yeah.
Mr. Colton put in extensive rebuttal testimony citing findings of impropriety by banks who are using NSF fees as a way to boost their revenues by racking and stacking customer payments to their accounts. And he says that that's a reason why it's not reasonable for the utilities to use NSF fees as an incentive for payment. My only question for him is whether he has any evidence that the utilities are doing the same thing. And although I've asked that question 3 times, he has not answered it.
So this was on rebuttal?
Yes.
Where in rebuttal?
We can pull up his rebuttal testimony. He referenced it himself in his answer. This is on page 7 of his rebuttal testimony. He's making the point that financial institutions don't actually impose NSF fees because of their deterrence effect. That's to support an argument that the utilities must not be using NSF fees for their deterrent effect. He supports that argument with evidence of how financial institutions process customer payments improperly. If that's the argument he wants to make, I'm entitled to ask whether he has evidence that the utilities are doing the same thing. Because if they're not, then these fees may serve a deterrent effect for the utility customers in a way that they don't for bank customers. That's all I'm trying to ask. And I think it's a straightforward question of whether he has evidence of utilities doing this or not.
Okay, I'll allow it, but I think this was on rebuttal. So if the company had evidence to counter this about it with its own source, that would have been a much more efficient way of getting anything to counter this evidence. It could have been in the record on rebuttal. If you have some, then we should just point it out.
That would be proving a negative from the utilities perspective. I'm asking the witness if he has evidence of the utilities doing what he says the banks.
Fine, let's get the answer.
The utilities are not presented with the same question the banks are presented with, which is the order in which to pay bills. So those so your question is asking for a comparison between 2 non-comparable things.
So the answer to my question is no, correct?
No, my answer to your question is what I said it was.
Your Honor, but it's a direct question. Do you have evidence of the utilities doing this or not?
Just objective form. So there's a practice that's referred to on Mr. Colton's rebuttal testimony, page 7, lines 7 to 20. I interpret that as illustrative of the issue that Mr. Colton is raising elsewhere in his rebuttal, including at the top of page 8 and on pages 6 to 7 of the rebuttal. So I think that's. Maybe the question could be clarified, but I think Mr. Colton says in his rebuttal on page 8 that the high to low posting issue is not the issue here. It's relying on the practices of NSFBs in general to be a deterrent.
If his answer is that there's no reasonable relationship between the banks and the utilities on this point, then this testimony is irrelevant and should be stricken.
Okay, well, you had an opportunity to do that.
It wasn't until a moment ago that the witness stated that there's no basis for the comparison. And I'm not asking to strike it. I'm just asking for an answer to my question. Does he have evidence of the utilities doing this or not?
Doing this being the high to low posting procedure specifically?
Yes.
If there's a question pending, Your Honor, Mike,
Does the situation be for high to low posting that you cite in your rebuttal testimony with reference to banking practices for NSFBs have any relation to your understanding of what utilities do when it comes to imposing NSFBs?
utilities are not presented with the question of posting checks against a bank account. The posting of high to low is evidence that the banking NSF fees are not used to incentivize or to disincentivize paying with checks that have insufficient funds. And that's where it's relevant to the utility industry. The applicants have cited the bank NSF fees.
But I don't understand how it's relevant to the utility industry if you just said they don't do high to low posting.
The utility, when the utility was asked, what do you...
I know the background, but how does it relate? How does high to low posting relate to utility practices?
The posting relates to utility practices in that it disproves the applicant's assertion that bank NSF fees are used to incentivize or to disincentivize payments that result in insufficient funds.
And your reference to high to low posting is limited only to making that relationship, only to making that point. It's not accusing the utility of affecting a similar practice.
Yes, it is making that point, and yes, it is not accusing the utility of making of engaging in a similar practice.
Okay.
And if in fact the utilities are unable to engage in a similar practice, then how a bank might use insufficient fund fees has no bearing on what the utilities might be using them for, correct?
No, I disagree with that. And that's what we've spent the last 10 minutes going round and round about.
Have you performed any analysis of whether the utilities in this case are using NSF fees as a profit center?
No.
Have you compared the individual amount of those NSF fees at the applicants to NSF fees at major financial institutions?
I made the same comparisons. Strike that. I used the comparisons which the applicants themselves provided in support of their proposed fee. And my inquiry was limited to the comparisons that the applicants themselves provided.
As you sit here today, do you know how the applicant's standard NSF fee compares to the standard NSF fee at a major financial institution?
Check to form, and I don't know if we've established, I'll leave it at that.
I'm sorry, I missed the last part of that objection.
It's just a form objection.
Okay, so I guess I'll overrule it then. I need to understand it. Okay.
The comparison that I made was to the financial institutions that the companies themselves provided as.
Your Honor, I apologize for breaking in. We just experienced a streaming issue here and I missed anything you said and anything the witness began saying. Are you able to hear us all right now?
Yes, we can hear you. There was an objection to form I overruled, and then the witness began the answer.
Thank you. I apologize for interrupting.
That's okay.
The only comparisons I made to the NSF fees of financial institutions were to the NSF fees at financial institutions that the companies themselves said they used in justifying their NSF fee.
And that was in the aggregate, correct?
I don't know what you mean by the aggregate.
The recipient's revenues from NSF fees as opposed to the individual NSF fee charged.
No, that's not correct. The discovery response is cited in my testimony and provided as an exhibit, and it will speak for itself.
And your testimony is that it did compare individual NSF fees between the utilities and financial institutions?
Yes.
Okay, and apart from whatever that response may say, you have no independent recollection of what those amounts are as you sit here today, correct?
No, I would need to look at the exhibit.
Okay. I don't have anything else for the witness, Your Honor. Thank you, Mr. Colton, for your time.
Right. So let's take witness butts.
Sorry, did anyone else have cross for Mr. Colton?
No, yes, I guess I should ask that. Any other cross? And any redirect?
I just have one question for the witness on redirect, Your Honor. And Mr. Colton, at the very beginning of the applicant's cross, you were asked why it wasn't, why you didn't combine the electric and gas utilities, and I'm not sure you were able to fully explain your answer about the 3% and the 6% difference and why it was appropriate to separate by gas and electric utilities. So if there was anything else you wanted to add, I just wanted to give you the opportunity to do that.
What I attempted to explain was you need to look at the individual fuels. Otherwise, a total home energy bill, a total home energy burden could appear to be affordable in the aggregate, even if one of the fuels imposes an unaffordable burden. And given that rates are set for individual fuels and not based on the total bill, you need to look at the affordability of the individual fuels.
That's all I had, Your Honor. Thank you.
All right. So I did remember that we were going to be recalling a company witness. Was that in
That's right, Your Honor. First of all, I have no further recross for the witness. And if you'd like to take up
Mr. going to give you that chance, but go ahead.
That's fair enough given the hour. I do, we would call Mr. Zagans back at this time if that's all right with you, Your Honor.
And this
Just to
is
clarify a few things.
Oh, and this is in response to what was it now? I can't remember.
This is in response to Mr. Colton's characterization of the commission's former accounting treatment for the lift.
Right. Okay.
Pilot.
I think we could use that clarification. So go ahead.
Thank you. And Mr. Proctor Brown will handle the question.
Okay.
While he's getting set up, Your Honor, I guess if we're just talking about the orders in the prior lift matters and what they said. I think Mr. Goldschmidt has established that the orders speak for themselves. So I'm concerned about the scope of this redirect, if that's the word for it. And I think it's supposed to just respond to the initial statement by Mr. Colton prior to the cross beginning. So I would ask that boundary be observed.
Yeah, Your
Okay.
Honor.
Yes.
So it only responds to the portion of Mr. Colton's testimony today prior to cross, and it doesn't have to do with the orders themselves. It has to do with the accounting treatment that Mr. Zagans has testified before, and I believe is the company's expert witness on that score will address the orders themselves and the language in briefing.
All right, that sounds good. And it was a bit confusing to me, the Colton testimony, just in terms of what order he was talking about. So yes, let's go ahead with a brief addition to the testimony. Just remember, witness Zagans, you're still under oath and you can proceed. Go ahead, Attorney Proctor Brown.
Thank you, Your Honor. Mr. Zagans, were you present for Mr. Colton's testimony?
Yes.
Mr. Colton testified about the deferral of lift credits. Would you explain how costs associated with the lift program were deferred?
Costs associated with the lift program are deferred when they become bad debt, and they're deferred into the bad debt escrow.
How do applicants propose to amortize the bad debt associated with the lift program?
Bad debt in total is proposed to be amortized over 2 years.
Have applicants responded to staff's questions associated with the lift program and bad debt during the audit?
Yes.
Did Mr. Colton identify any accounting errors in his testimony today?
No.
Thank you, Mr. Zagans. I suppose, Your Honor, he's available for recross. If that's the appropriate term.
That's okay. We just say cross. Any questions for the witness?
Just one, Mr. Zagans, Krista Westerberg again, can you identify any prior order of the commission that authorizes deferral accounting treatment for lift credits prior to this rate case?
And Your Honor, I just object to that. That's a legal conclusion. That's literally what Ms. Westerberg objected to this testimony being about, and we will address that in briefing.
I'll withdraw.
Okay. All right. Okay, great. So no redirect?
No redirect, Your Honor. Thank you.
Okay, thanks. You're excused.
Thank you.
All right. So let's go off the record. Who do we have left for testimony? We still have Bieber. Is that right? I think I missed.
Others might correct my recollection, but I think we may have excused Bieber.
That might be the.
I don't know if anyone else has a recollection of that, but
I think that's right. Yep.
Yeah. Okay. Well, just for the are there any questions for Bieber, just in case? We can always address that at some point. If not, okay. All right. So I think we have. So we still have Butts, and we still have commission staff.
Your Honor, we also have Lane Collin.
And Lane Collin, yes, that's right. Okay.
And commission staff just has a couple of, well, I guess maybe even one quick question for witness Collin.
Okay, and Tierney has questions. There's questions for Tierney. Okay.
Your Honor,
yes.
For commission staff or folks that don't have any cross, we'd be totally fine if we want to take them. We don't have lengthy cross for Mr. Butts or Mr. Collin. Nothing like what was for Mr. Colton. So up to Your Honor, of course, but
that's good to know. I appreciate it. I think staff does usually wish to remain and witness the hearings. That's why they usually are set to go last, unless there's any conflicts, anyone needs to leave. We can keep them on for this brief cross for Butts and Colin. So why don't we press on for now, and we can see how far we get before our next break. So let's call witness Butts. I don't see him.
He's got a window, but he hasn't turned on his camera yet.
Okay.
There we go.
I'm present, Your Honor.
There you go. All right, great. I'll swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, great. Go ahead.
Good evening, Mr. Butts. Krista Westerberg here. Could you please state your name and position?
Antonio Butts, Executive Director at Walnut Way Conservation Corporation.
And did you file or prepare and cause to be filed direct rebuttal and rebuttal testimony in this case, as well as 2 exhibits?
Yes.
And are those documents complete and correct to the best of your knowledge?
Yes.
The witness is available for cross.
Okay, that's great. Yeah, so direct rebuttal, rebuttal, and 2 exhibits. I can accept those. And are there questions? Look like the applicant had a question.
Yeah, thank you. Good evening, Mr. Butts. My name is Joe Wilson. I'm one of the lawyers for the applicants in this case. How are you?
Good, and you, sir?
Good, thank you. Mr. Butts, do you have your direct testimony in front of you?
I do, but I'm going to look for some support from the judge to get it on the screen as well.
Sure. Yeah, and I want to look at page 6 specifically.
All right.
So page 6, line 6. I want to just paraphrase your argument and make sure I'm understanding it. My understanding is you argue that only legal fees that produce a direct customer benefit should be recoverable from ratepayers. Is that right?
Could you repeat that question? I couldn't hear the front end clearly.
Sure. My understanding is that you're arguing that only legal fees incurred by the applicants that produce a direct customer benefit should be recoverable from ratepayers. Is that right?
I'm not sure I understand how you're framing the question. Could you ask it a different way?
You direct the witness to a particular part of his direct.
Yeah, sure. So look at page 6, lines 6 through 11, and maybe you tell me what you mean there.
Should we read it, Judge, or what
no, I think we have the citation. We know where we are. And is the sentence "if legal counsel," is that the sentence you're referring to?
Yeah, correct.
Okay, so if legal counsel, that beginning with that line and the remainder of the sentence, if you want to read it and then answer the question based on what you know.
All right, thank you. All right, can you repeat the question one more time?
Sure. Why don't you just explain what you mean by customer benefits in this context?
Lower rates or improved services?
I'm sorry, I couldn't understand you, sir.
Lower rates or improved services?
Thank you.
Okay. So is it your testimony that only legal services that lower rates or improve services for customers should be recoverable from customers? Am I understanding that correctly?
No, you're not.
Okay, what have I got wrong?
That I didn't state that. But I stated that benefits in this case, are lower rates and improved services.
So you did say that.
The benefits are, in this case, are lower rates and improved services, but not limited to, so.
I think the question.
I'm sorry, but not limited to.
Those two items.
Thank you.
Lower rates or improved services.
What other categories of legal services should be recoverable from customers, in your opinion?
Subject to form, as to, are we talking about legal I think the witness is referring to legal fees incurred in this matter as opposed to other legal fees. If you could clarify your question.
Well,
That's what we're trying to understand. I guess if that's not in the testimony, that it's limited to this case, is it? Doesn't say that. So that's what he's trying. I think that's what the Attorney Wilson is trying to elicit from the witness. To what, just explain how that sentence applies in the witness's mind. What is meant by those words? So I think the track we were on was that there may be other benefits than just lower rates or improved services, because it's such as lower rates or improved services. And the question was, are there any other items that can be included on that list that the witness did not include in the written testimony?
I'm sure there are that would require time to conceptualize and bring forth. The overall thought is that if legal counsel leads to improved profitability, then ratepayers should have some benefit to that improvement in overall profitability. And those benefits could show up in a variety of different ways for ratepayers specifically. Is that okay, Judge?
Oh, it's an answer. I'll see what the Attorney Wilson has any follow-up for that. Go ahead.
Yeah, I'm not sure I understand that. So let me see if I understand. On one side of the line are legal fees that lower rates or improve services, and your position is that those could be recoverable from ratepayers, correct?
Finish your question.
What?
Finish your question.
I did.
So he asked you to confirm or deny that statement by ending the sentence in correct. That's kind of the lawyerly way of asking you to confirm or deny the statement that he was prefacing that with. So why don't we read that question back?
On one side of the line are legal fees that lower rates or improve services, and your position is that those could be recoverable from ratepayers, correct?
Maybe, but the variables depend. So I don't have a certain answer for that.
Okay, so those could maybe be recovered from customers, right?
It's a possibility. Yes, sir.
Okay, and on the other side of the line is legal services that I think you said go to profitability, right?
No,
and those
I don't
could
think that's what I
not
said.
be recovered from customers. Is that right?
No, I don't think that's what I said. Go ahead and rephrase the question.
All right, explain what you mean by when you talk about legal services having to do with profitability.
I mean, when legal services improve the profitability of the company, ratepayers should also be able to benefit from that profitability.
How so?
In this case, in this example, benefits being lower rates or improved services.
So when Wisconsin Electric spends legal services that increase profits for Wisconsin Electric, if the result was to lower rates for Wisconsin Electric, then those legal fees should be recoverable from customers. Is that your testimony?
No, it's that if the legal work leads to increased profitability, ratepayers should also be able to benefit from that profitability. Clearly, there are affordability issues. So ideally, that profitability would help resolve those affordability issues.
Okay. I'm just not sure I'm following the proposal here. Is it your position that no legal fees that the company spends on rate cases like the one we're doing today should be recoverable from customers?
Our position is a deeper analysis of the legal fees and the categorizations to understand what the proof of work is in order to make a difference.
I'm sorry, I interrupted you.
Well, I ended it, so I was done with that part. So if someone else needs to repeat it.
Okay, so we need deeper analysis of what exactly?
Legal fees.
And what information are you looking to gain from that deeper analysis?
The analysis will reveal that.
Well, but what information are you looking to discover as a result of that analysis?
What services were performed? What is the proof of work? How is it categorized? And a number of other items associated with maybe forensic level auditing.
Let me ask it a different way. Is it not your position?
Judge, did I not answer the question? Judge, something happened there. Can you help me out?
Yeah, you didn't answer my question.
No, go ahead.
Can you hear can you hear us okay? And we can hear you fine. Are you having trouble with the connection at all?
No, sir, not at all.
All right, so the way things generally work, and I guess I'm not sure if we've had you appear before in the last cases. I assumed you had, but I'm not sure. But I think generally I let whoever's asking cross questions proceed with those questions. And then if there's something wrong with the question in the opinion of your attorney, that person can object, and then the questioning stops. And then I need to decide whether that question's okay or not. But if that doesn't happen, if Attorney Wilson's asking questions and there's no objections, you need to just keep answering those questions, and he'll keep asking questions until he's done. Don't worry about him. But the idea is just keep answering those questions until we have a complete record, or unless there's an objection, and then we'll deal with that when it happens, if it happens. Okay. So I think we have another question so he's gonna now ask a question based on your last answer in order to get some more information. So we're gonna let him do that and see what that question is next. So go ahead, Attorney Wilson.
Thank you, Judge. So maybe I'll just try the question again. Is it your position that no legal fees the company spends on rate cases should be recoverable from customers?
No, it's my position that if it's any improved profitability from the use of legal, that ratepayers should be able to benefit from that profitability. And examples of that are lower rates and improved services.
So when you say improve profitability, do you mean increase customer bills, or do you mean something else?
I mean, overall company profitability.
And how how would you measure that profitability?
It could be done a number of ways. One would be by earnings, company earnings.
What? So, and by that, do you mean the company's authorized return on equity?
Possibly.
Okay, so in this case, several parties have proposed to lower the company's authorized return on equity. Are you aware of that?
I would object to, I think this exceeds this scope to some extent. Mr. Betts has not testified or offered testimony on the return on equity or ROE issues.
Well, I understand that. He's saying that we ought to peg recovery of legal fees in some way to profitability, and said one potential way to measure that is to tie it to authorized ROE. So trying to understand how those things would tie together.
I don't know if I said that. I think I'm saying that there should be a deeper analysis into the legal fees and understanding what are the fees for, what is the proof of work, how are they being categorized, how do they connect to specific streams of work, albeit a rate case, this particular case, or any other. So
yeah, to what end?
We'll know when we're able to do an analysis, to have an understanding of how the resources are being used and to what end and to whose benefit. Because there's an affordability issue.
Okay, in your direct testimony, page 7, you argue that the commission should scrutinize legal expenses to more equitably allocate such costs and ensure that the pursuit of utility profitability does not come at the expense of those least able to bear the burden. That's at lines 21 to 23. Do you see that?
Yes, sir.
How's the commission supposed to do that?
I'm just going to object to form because I think Mr. Wilson did not correctly quote the testimony.
Oh, okay. Well, I can reread it better.
Okay, why don't you do that?
Okay. You say that the commission needs to apply, quote, greater scrutiny of legal expenses and a more equitable approach to allocating these costs, ensuring that the pursuit of utility profitability does not come at the expense of those least able to bear the burden, end quote. Did I read that correctly?
I think so.
How is the commission supposed to do that?
How is the commission supposed to do what?
What you're suggesting they do there?
What are you reading that I'm suggesting that they do?
Apply greater scrutiny of legal expenses and a more equitable approach to allocating these costs, ensuring that the pursuit of utility profitability does not come at the expense of those least able to bear the burden, end quote.
Yeah. Conduct the analysis, do the thorough investigation, do the forensic level auditing, uncover the information so that what we're discussing can be determined.
Okay. So the steps you've already suggested they take, correct?
Is it noted here in the testimony that you want to point to?
No, I'm asking you. Those are the things they're supposed to do, the things you've already said, yes?
I don't understand the question.
I think it's pretty clear.
Are you asking the commission to apply greater scrutiny to the legal expenses of the company?
Yes.
Okay.
In your surrebuttal testimony, Mr. Butts, page 3.
Yes, sir.
At lines 5 through 7. You criticized the company for failing to segregate out the legal fees related to the rate case in the application and in Mr. Zagans's rebuttal testimony. Do you see that?
Specifically, what are you?
Lines 5 through 7 of page 3 of your rebuttal testimony.
Okay.
Do you see that?
Yes, I see those lines.
What would be the purpose of segregating out the specific costs of the rate case proceeding as you propose here?
We don't know how the utility is currently segregated or categorized, and knowing that would reveal something new of which we would be able to make new determinations off of.
But what would be the purpose of specifically segregating out the costs of this specific rate case proceeding, as you suggest?
To understand the uses, designation of the resources.
What's special about the rate case proceeding that these costs for this proceeding need to be specifically segregated out?
I wouldn't say that something is special about it. I'd say it's just relevant as it relates to this is the case that we're involved in.
Are you aware of any legal requirement that the company segregate out its legal costs in the way you've suggested?
Active form and foundation.
Do you want me to respond?
He can tell us if he's aware of that. Yes. So overruled. You can answer the question, please.
I don't think so, but I could.
The last thing I want to do is just ask you about a couple specific examples to see if I can better understand the test you're setting up in your testimony. You said that costs that legal fees that lower rates and improve service could potentially qualify for recovery from customers, right?
Could potentially. Correct.
Okay. Let's talk about the legal fees that the company would incur to buy a solar farm, okay? A solar farm, if it is supplying electricity that a customers need, could improve services. Would you agree with that?
It just depends on where the services are, who they're being provided to, and who the end benefactors are. Is actually one of the disparity issues.
Well, let's assume that Wisconsin Electric's customers need the electricity that the solar farm is going to provide. Would you agree that that solar farm will provide electricity and that will improve services?
It could.
Okay. If that solar farm is acquired and then placed into rates, that could increase rates for customers, couldn't it?
It depends. There are a number of variables there.
It depends. Well, all else equal, would you agree that if the company acquires a solar farm and places it into rates, it's going to increase costs for customers?
I can't, especially understanding the utilities affordability issues. And
Do you know one way or another if the utility buys a solar farm and places it into rates, whether it's going to increase cost per customer?
if I understand the question the way you said, the way that you just asked it, I don't think it's any way of knowing until something is put in commission, until it's actually operating.
Okay, let's assume that when the company buys this solar farm, it will increase customer rates by some amount, okay?
That's the assumption, okay?
So this solar farm will both improve service to customers, but also increase costs to customers. Should the legal fees incurred to buy the solar farm be recoverable from customers under the test that you're trying to establish in your testimony?
I don't think so, primarily because the process to end at the result that you just described wouldn't be the process used in the end, which creates more costs and better service. So
how's that?
The front end decision or strategy or whatever's attempted to be accomplished, your outcome wouldn't be the preferred or desired outcome. So the front end catalyst or what initiates it wouldn't produce that outcome. So no. So to end up with that outcome, you have to have a series of choices. Those front end choices, we wouldn't make those choices to produce the outcome that you described. Hence, again, the disparity, the affordability issues, the procedural components of this, which are creating the outcomes that we have with respect to disparities.
Not sure I follow that.
Okay.
I'm not sure I follow that. Let's try one more example. So let's say the utility is buying a natural gas plant, okay? You with me?
Yes, sir.
All right. So, and the utility is going to incur some legal costs to get the environmental permits necessary to build this natural gas plant, not acquire, okay?
Mm-hmm.
And the natural gas plant will provide needed electricity to customers, but it will also increase the cost to customers, okay? So should the legal fees expended to get the environmental permit for that natural gas plant be recoverable from customers?
I can't agree because your hypothetical wouldn't be the case. The performer for the natural gas plant would produce certain outcomes. And then on the front end of that, one of the outcomes that you wouldn't want it to produce would be higher rates. So I just can't agree with you because of what initiates the outcome. And so your hypotheticals are these what ifs, but we don't have any sense of the impetus.
So is it your testimony that only acquisitions of generation that are free or reduce costs to customers, only the legal costs for those sorts of acquisitions should be recoverable from customers?
We can't answer it because we aren't able to do an analysis on the legal costs to reveal the new inquiries and questions. So
Okay, Attorney Wilson, I think I've heard enough. I don't think we're gonna gain much more. Okay,
Thank you.
all right. Any other cross? No one else? Redirect? Redirect, that's Attorney Westbrook.
Judge Newmark, I have one cross question related to Attorney Wilson's cross.
Sure, yeah, go ahead with cross, sure.
Mr. Butts, I'm Kara Coburn Ferris from the Citizens Utility Board. Good evening.
Good evening.
Just one question. Just to clarify that testimony that got a little muddy for me. When attorneys and their witnesses argue positions that benefit shareholders while clearly raising costs for customers, should customers pay those attorneys and witnesses service fees?
Could you repeat the question again?
Let's read it back.
When attorneys and their witnesses argue positions that benefit shareholders while clearly raising costs for customers, should customers pay those attorneys and witnesses service fees?
I would say no.
Thank you. No further questions from Cub.
And I don't have redirect, Your Honor.
No redirect? All right. Thank you very much, sir. You're excused.
Thanks, Judge. Judge, and also I appreciate your help tonight. I think I understood, but I appreciated the attorney's inquiries and discussion with me. So,
All right, great. Well, I appreciate you being here. So take care and good luck.
You too, sir.
All right, so we have Weeg.
Yes, good evening. Thank you, Your Honor. I would like to call Lane Collin to the stand, please.
Right. You there? Raise your right hand. You swear
Yes,
or,
I'm here.
You swear or affirm, tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Hi, Mr. Collin. Could you please, I guess, state your name for the record?
Yes, my name is Lane Collin.
Okay. And did you prepare and cause to be filed direct testimony, rebuttal testimony, and rebuttal testimony, and 6 exhibits in this proceeding?
Yes.
Do you have any corrections to the testimony or exhibits?
I do not, except I would note that I did correct some of the quantifications in my direct testimony in my rebuttal testimony.
Okay.
And so some of the amounts supersede those in my direct testimony.
Understood. Thank you. Thank you for that. If I were to ask you today, while you are here under oath, the questions set forth in your testimonies, would your answers remain the same?
Yes, they would.
Thank you. Mr. Collin is available for cross.
Okay, let's go off the record for a second. So I clicked the wrong button. I stopped your video, Debbie. And I can't turn on video. That would not be good.
I got a pop-up that said start my
Okay.
video.
Okay, there you go. That's just a way to give you a little break there. So, so let's see.
Mr. Collins is available for cross is what Mr. Heinzen said.
Right. I'm just looking for the people here. Okay. All right. So do we have any questions for witness Collin?
Your Honor,
Yes,
Commission
Your Honor.
staff just. Sorry, didn't mean to talk over you, Attorney Proctor Brown, but I just have one quick question, so maybe it makes sense for us to ask that quickly.
Okay, if that helps, if that's helpful, let's go ahead.
Good evening, Mr. Collin. Evan Whites on behalf of the Public Service Commission. I just have one question. I think I asked you the same question in the hearing last Friday. In your testimony, you use a variety of terms ranging from remaining environmental costs, environmental retired plant costs, retired or just environmental costs. And I just wanted to clarify your use of those terms. Are they interchangeable or do they have independent significance?
Yeah, to the extent that the terms used the word environmental, they would be interchangeable. If on the other hand, it was just a generic retired plant cost, remaining retired plant costs would include environmental plus non-environmental.
Thank you.
All right, great, thanks. Applicants have a question?
Just a handful, Your Honor. Thank
All
you.
right, go ahead.
Good evening, Mr. Khan. My name is Attorney Patrick Proctor Brown, and I'm an attorney for the applicants. I believe we had a little bit of a colloquy on Friday.
We did, yes.
You've recommended different options for WEPCO's recovery of its remaining investment in the PIP and Oak Creek units 5 through 8 in this docket, correct?
Yes, that's correct, plus other already retired plant costs.
And none of your recommendations related to any retired plant are predicated on a conclusion that WEPCO's investment was imprudent, correct?
That's correct.
Your recommendations are based on reducing rates for WEPCO's current customers, correct?
Yes. Or reducing the rate increase, not necessarily reducing existing rates, but reducing the rate increases in 2025 and 2026.
Is it your understanding that the commission has the authority to deny the return of a prudent investment in its entirety?
I think that seems to me like a request for a legal opinion, and I would decline to give you one. If you would like my layman's representation, it would depend on whether or not the costs were prudent. It would depend on whether the costs or the asset was used and useful, depend on whether the costs were reasonable. These are the typical standards used for assessing recoverability of investment costs.
Thank you. You recommend that Wisconsin Electric defer the revenue requirement impact of an earlier than planned retirement of Oak Creek Power Plant 7 and 8, but not the impact of a later than planned retirement. Why?
Well, first of all, I'm interested in consumer protections and the impact on customers, in particular, my clients, but all customers that would be affected by this. And an earlier retirement would result in savings for the company. A later retirement would result in increased costs compared to what the company has in its revenue requirement. With that as the context, the company certainly has the opportunity to respond, and in fact has in its rebuttal and surrebuttal testimony, essentially asking for symmetrical treatment. I wouldn't be opposed to that.
Right, because it's your understanding that if there's uncertainty in the retirement date, a symmetrical option would hold both customers and the company harmless, correct?
Yes, and the commission has done that in the past. I think that's a fair outcome.
Thank you, Mr. Cullen. That's all the questions I have.
All right, other cross? No, redirect?
No redirect, Your Honor.
All right, thank you. You're excused.
Thank you, Your Honor.
Thank you.
All right. So we just have, is it true, let's off the record, is it true we just have questions for witness Tierney for commission staff?
That's correct from applicant's perspective, Your Honor.
Yes. And, okay. So the rest of the witnesses, we're just gonna verify testimony. Okay, so why don't we pursue that? Let's call our first witness.
Can I run to the bathroom real quick?
Yes, you can.
I'll be very quick.
All right, take a 5-minute break.
No, I don't even need that long. I'll be
No,
right
well,
back.
you can't get people back. We'll just stand here and wait. How about that?
I'll be right back. I don't know the last time I wrote over 300 pages in one day.
Bravo.
But now I have to do the transcript too. My proofreader loves me. She's like always busy.
I think that's about 5 minutes. We have commission staff witnesses next. I see we have people lined up here, so let's get started. Let's get on the record, and we'll have Attorney White's call our first witness.
Thank you. Commission staff would call Akanksha Kraft to the stand.
Seeing you yet? Should be there. There you go. All right, raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Good evening, Ms. Kraft. In this proceeding, did you file or cause to be filed direct and serve rebuttal testimony?
Yes, I did.
And did you also file or cause to be filed 6 exhibits?
Yes.
Are the statements and representations made in your testimony and exhibits true and correct to the best of your knowledge?
Yes, they are.
And do you have any additions or modifications to either your testimony or exhibits to make at this time?
No, I do not.
Thank you. The witness is available for cross.
All right, do we have any questions? None? Okay. Thanks very much. You're excused.
Thank you.
Next, commission staff would call Jennifer Malley to the stand.
My video. Let me know when you can see me.
Here we go. It's a little delayed. No, we got you now. We have your. No, I don't know if that worked. Okay, well, we can probably proceed without it Oh, there we go. Oh, all right. We'll do. Yeah, don't do anything. Hands up. Hands up.
Right hand, here it is.
Right hand. There you go. You swear or affirm, tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Good evening, Ms. Malley. In this proceeding, did you file or cause to be filed direct, supplemental direct, rebuttal, and rebuttal testimony?
Yes.
And did you also file or cause to be filed 7 exhibits?
Yes.
Will you also be submitting delayed exhibits in this proceeding?
Yes, I will be filing a revised data response or DRR exhibit for additional responses that staff has received, as well as a public comments exhibit for public comments after the public hearings and all public comments have come in.
Thank you. Are the statements and representations made in your testimony and exhibits true and correct to the best of your knowledge?
Yes.
And do you have any additions or modifications to make to either your testimony or exhibits at this time? I know we talked about one revision earlier in response to a ruling of the ALJ, but any other revisions other than that?
No, that's the only one.
Thank you. The witness is available for cross.
All right, any questions? None, thank you, you're excused.
Next, commission staff would call Cara McFerrin to the stand.
Should be seeing you here. There we go. All right, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead.
Good evening, Ms. McFerrin. In this proceeding, did you file or cause to be filed direct and rebuttal testimony?
Yes, I did.
And are the statements and representations made in that testimony true and correct to the best of your knowledge?
Yes, they are.
Do you have any additions or modifications to make to your testimony at this time?
No, I don't.
Thank you. The witness is available for cross.
Any questions? No, thanks very much. You're excused.
Next, commission staff would call Caitlin Nye to the stand.
Raise your right hand. Oh, we're going to unmute you there. Okay, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead.
Good evening, Ms. Nye. In this proceeding, did you file or cause to be filed direct, supplemental direct, and rebuttal testimony?
Yes, I did.
And did you also file or cause to be filed 8 exhibits?
Yes.
Are the statements and representations that are made in your testimony and exhibits true and correct to the best of your knowledge?
Yes.
And do you have any additions or modifications to make to either your testimony or exhibits at this time?
No, I do not.
Thank you. The witness is available for cross.
Okay, any questions? No, thanks very much. You're excused.
Next, commission staff would call Mike Ritzma to the stand.
Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Good evening, Mr. Ritzma. In this proceeding, did you file or cause to be filed direct and rebuttal testimony with errata for your direct testimony?
Yes, I did.
And did you also file or cause to be filed 1 exhibit?
Yes, I did.
Are you submitting any delayed exhibits in this proceeding?
Yes, as I referenced in my direct testimony at the end, I'll be submitting a delayed exhibit regarding changes in market prices for energy and other things enumerated in my direct. That would be done prior to the commission's discussion of the record.
And will that be labeled exhibit PSC RISMA 2?
Yes.
Okay. Are the statements and representations made in your testimony and exhibit true and correct to the best of your knowledge?
Yes, subject to the change that I identify in my errata.
And do you have any other additions or modifications to make at this time?
No, I do not.
Thank you. The witness is available for cross.
All right, any questions? None. All right. Thanks very much. You're excused.
Thank you.
And I guess that leaves lastly, commission staff would call Reed Tierney to the stand.
Okay. Should be there somewhere.
Yep, I'm here.
Okay, well, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes.
Okay, go ahead.
Good evening, Mr. Tierney. In this proceeding, did you file or cause to be filed direct, supplemental direct, and sir rebuttal testimony?
Yes.
And did you also file or cause to be filed 6 exhibits?
Yes.
Will you be filing a 7th exhibit pursuant to the discussion that we had earlier today?
Yes, I will.
Okay. Do you have any additions or corrections to make to your testimony or exhibits at this time?
Yes, I have one correction to my direct testimony. And it is on page 26, where I talk about Schedule 8 of my exhibit EXPSC Tierney 1. And I incorrectly refer to dividend growth as earnings growth. So I would just like to make that correction.
So you will be changing the phrase earnings growth to dividend growth on, is it pages 26 and 27?
Yes, I believe so.
Okay, can you just give us line citations for those?
Sure. 1 second. Yeah, so that's page 26, line 20. And page 27, line 1.
Okay. Great, thanks.
With those corrections noted, are the statements and representations in your testimony and exhibits true and correct to the best of your knowledge?
Yes.
Next, I want to ask Mr. Tierney, have you had the opportunity to review the sir rebuttal of applicant's witness, Zagantz?
Yes, briefly.
In that sir rebuttal, Mr. Zagantz references, or I guess poses a question about the date for staff's inflation estimate. Do you have a response to that?
Yes. The date used was in March.
Of which year?
Oh, 2024.
Okay. Did you also have an opportunity to review Mr. Zagantz's statements about on page 2, your testimony related to a credit rating downgrade?
Yes, I did.
Do you have a response to that?
Yes. In that testimony, it says Mr. Tierney does not dispute the 600 million over a 30-year time period that the credit rating downgrade would cost. I do dispute those numbers. I got the exhibit in late yesterday afternoon, and I'm going to be filing a response to it. But I do not endorse those numbers.
Thank you. I don't have any further questions, and the witness is available for cross.
Okay. So I guess let's just go off the record for a second. I guess in terms of the current statement that we have for Zagantz, our conclusion that Mr. Tierney does not dispute. I don't know if that was the witness's understanding at the time, or is that something we can clear up so there's no confusion if someone's reading this testimony but doesn't have the benefit of Mr. Tierney's exhibit that's going to be coming in later.
Your Honor, I don't know that the exhibit is specifically referencing this point, which is why the question was asked on testimony.
Yes.
I think this more relates to Mr. Tierney's rebuttal testimony. And if you give me 1 minute, I can point to the specific. The bottom of page 11, I believe, addresses this issue.
Zagant's rebuttal?
No, Mr. Tierney's.
Tierney's rebuttal, okay. So,
and if you'd like, I can ask a follow-up question based
yeah,
on
I guess, I mean, does the rebuttal, oh, yeah, if you can help clear that up, I guess the way it's phrased, it just seems like we might be missing something here, but,
I'll ask a follow-up question.
Okay, yeah, why don't we try that? Okay, let's get on the record. Go ahead.
Mr. Tierney, just one follow-up question to help flesh out your previous responses. At the bottom of page 11 in your rebuttal, do you respond to the question, quote, does commission staff agree with the applicant's analysis of what a credit rating downgrade would cost?
Yes.
And what is your answer?
No.
Okay. And is that the same cost that you just responded? You were disputing Mr. Zagant's statement that you are in agreement with that cost.
That's correct.
Thank you. Hopefully, I think that clarifies the link between those two.
Yeah, okay. Well, maybe I'm seeing something different, but it may be late in the day. So all right, that the transcript will have what it has in it in terms of clarification. So okay. So do we have any questions for witness Tierney?
Yes, Your Honor. Applicants have questions for Mr. Tierney.
Go ahead.
Mr. Tierney, my name is Attorney Patrick Proctor Brown. I'm an attorney for the applicants. We haven't met before today, correct?
Correct.
Part of your testimony in this case relates to imputed debt for off-balance sheet obligations. Would you agree with that?
Yes.
You've acknowledged, and this is in your direct testimony at page 6, that it is the Commission's long-standing practice to include off-balance sheet obligations in the financial capital structure for Wisconsin's large investor-owned utilities. Would you agree with that?
Yes.
You've also acknowledged that the standard Commission practice is not to include off-balance sheet obligations in the regulatory capital structure, but to include the equity. That's at page 7 of your testimony. Do you agree with that?
Yes.
You also noted that in this case, the off-balance sheet obligations were not included in the regulatory capital structure, but the equity was. You agree with that?
Yes.
That's also the standard Commission practice, correct?
I'm sorry, it's also the standard.
Commission practice, correct?
Thank you.
Yes.
With those approaches, the Commission has maintained consistency between the utility's revenue requirement and how the credit rating agencies treat off-balance sheet obligations in setting the utility's credit ratings. Would you agree with that?
Can I have that question read back?
Sure, let's read it back.
Question: with those approaches, the Commission has maintained consistency between the utility's revenue requirement and how the credit rating agencies treat off-balance obligations in setting the utility's credit ratings. Would you agree with that?
Yes, I would agree with that.
And this isn't in your recommendation to the Commission, but you include alternative capital structures for Wisconsin Electric that would reduce the amount of equity in the regulatory capital structure, correct?
That's correct.
You state that the purpose is to address Wisconsin Electric's high regulatory equity layer, and this is quoting you, the alternatives below do not seek to invalidate the prior decision to reclassify the $600 million of off-balance sheet obligations as new debt, but seek to address a new issue of Wisconsin Electric's high regulatory equity layer and the impacts that has on customers. You agree with that?
Yes.
And that's at page 8 of your testimony. And just so
I
the
think
judge
so.
can follow along. In these alternatives, you reduce Wisconsin Electric's regulatory equity layer. Would you agree?
I posed two alternatives. One, the imputed capital structure reduces the regulatory equity layer. The other alternative is just a decrease to the financial and regulatory equity layer.
The effect of both would be to reduce the amount of Wisconsin Electric's off-balance sheet obligations that are reflected in its regulatory capital structure. Would you agree with that?
Not necessarily.
Why not?
Well, the problem I'm trying to address here is the high capital structure. So I wouldn't necessarily be modifying the off-balance sheet obligations. I'm looking more at this as a larger problem of the capital structure. So I'm modifying the capital structure, not specifically the off-balance sheet obligations.
Right, but the effect of your modification is to decrease the regulatory capital structure that would be included if you imputed debt in accordance with the credit rating agencies and the commission's longstanding practice, correct?
I would have the effect of decreasing the equity layer.
Right, so you're accomplishing excluding a part of the off-balance sheet obligations through your alternative capital structures. Would you agree?
I would not agree with that. I did not seek to exclude a certain portion of the capital structure. So I'm not specifically not including off-balance sheet obligations.
But the effect would be the same as if you specifically excluded an off-balance sheet obligation. Would you agree?
The effect would be the same as if I excluded any portion.
So in that sense, your alternative capital structures are a departure from the commission's longstanding practices. You would agree?
Not necessarily. I cite two cases in which the commission approved imputed capital structures in my direct testimony. So
Those are not
precedent.
cases for.
I'm sorry, I didn't hear the end of the answer.
Oh, I said there is some precedent.
Thank you.
The precedent there is for small utilities, not large investor-owned utilities such as the applicants. Would you agree with that?
They are investor-owned utilities. They are smaller than the applicant.
You base your alternatives on the fact that Wisconsin Electric has a larger regulatory equity layer than the other WEC utilities, as well as all three other large IOUs in Wisconsin. Is that correct?
Yes.
But that's because Wisconsin Electric has more off-balance sheet obligations than the other utilities. You agree?
That's a piece of it. It's also just the commission's decision to grant that capital structure.
Right. So if they granted the same financial capital structure across the IOUs, the only significant difference between those three IOUs is the off-balance sheet obligations for Wisconsin Electric are larger. You'd agree?
Which are the IOUs? Talking about the subsidiaries? Or
The other four, the other Wisconsin IOUs, the large IOUs that it's referring to.
So outside of the utility,
outside of Wisconsin Electric, yes.
Okay.
With that clarification, Mr. Tierney, did you understand my question?
Yeah. So if I'm understanding correctly, all things being equal, I do think WEPCO has more off-balance sheet obligations than the other major IOUs.
And that's due primarily to the Point Beach PPA. You'd agree?
Amongst other things, yeah.
The Point Beach PPA was entered to as part of the sale of Point Beach to NextEra. You understand that background?
Yes.
The commission approved that sale and found that the Point Beach power purchase agreement was reasonable, correct?
Yes.
You're not suggesting that the Point Beach PPA is now unreasonable because of its impact on WEPCO's regulatory capital structure, are you?
No, that's not what I'm suggesting.
By reducing Wisconsin Electric's regulatory equity ratio to a level akin to those of other Wisconsin
I'm sorry.
IOUs.
I'm sorry. Can you start the question over?
I can.
Just slow down a little.
Yes, I will. Thank you.
Okay.
Thanks.
By reducing Wisconsin Electric's regulatory equity ratio to a level akin to those of other Wisconsin IOUs, you would effectively ignore some or all of the off-balance sheet obligation represented by the Point Beach PPA. Would you agree?
I don't agree with that.
All else equal, that's the difference, right, Mr. Tierney?
I am not specifically seeking to invalidate that off-balance sheet obligation or that PPA or anything. I'm seeking to address the large capital structure.
And the only thing that you can identify as a significant difference between Wisconsin Electric and the other IOUs is the Point Beach PPA, right?
That's not true. There's the commission sets the capital structure, so past commission decisions have also impacted it.
You claim that your alternative regulatory capital structures that reduce the equity represented by off-balance sheet obligations would allow, and I'm quoting now, the applicant's equity holders to maintain their current financial capital structure for the purposes of obtaining credit ratings, but provides, and this is in brackets because it's summarizing your testimony, savings for customers. Do you agree with that?
Yes.
Do you have any direct knowledge about credit rating agencies and how they would react to a PSC decision that did not reflect a significant portion of Wisconsin Electric's off-balance sheet obligations in the utilities revenue requirement?
My understanding is credit rating agencies would react more positively to the imputed capital structure because it maintains the current debt to equity ratio than they would to just a straight decrease in the capital structure that wasn't imputed.
They'd see that as an increased risk and justification for a potential downgrade in Wisconsin Electric's credit rating. Agree?
They would see anything that negatively impacts the financial situation of the company as potential risk.
Are you recommending that the commission take action that risks Wisconsin Electric's credit ratings?
No, I'm not. I was unable to get any clarification on whether the applicants were predicting a credit rating downgrade as a result of this change.
Thank you, Mr. Tierney. I'm going to switch gears to some testimony from Dr. Keim earlier today. Did you hear Dr. Keim's answer to your attorney's question about the use of historical stock prices in the DCF model?
I did, but I might need to have it reread.
Well, I'll summarize it for you and maybe subject to correction. We'll move on from there. But my understanding of Dr. Keim's basic testimony today was that average stock prices should not be used in the DCF model. Average historical stock prices should not be used in the DCF model because that data is not appropriate for the DCF model. Is that the basic summary of Dr. Keim's testimony?
Your Honor, I'm going to object. I think there was a little bit more nuance to it, but I admittedly can't recall the specific details. I don't know that it was that blanket of a statement.
Okay, let's go off the record. I think there is a portion of Dr. Keim's written testimony that this is based off of, isn't it? Wasn't he responding to testimony as part of that question, Attorney White's?
He was responding to the statement of applicant's witness Bulkley.
Okay, so maybe that might provide at least some. And that was the rebuttal?
Sir, I believe.
Was it sir? Okay. So, is it an average? Is that? No.
I believe it was page 11
okay.
of Bulkley. And I think it was the bottom of that page.
Right.
The sentence that starts with further.
Okay, so perhaps this would refresh the witness's recollection of Dr. Keim's response reacting to this.
I'm comfortable staying off the record now to see if it does refresh his recollection.
Yeah, so it's the idea of averaging or not averaging. That's what I recall, and relating to different using stock market data versus other data.
You know, it's been kind of a long day. I think I would need to hear Keim's statement read back to me.
Yeah,
I don't, off the top of my head, I don't remember exactly what his point was.
Okay, so I think we've asked our expert to summarize it in a digestible way, and maybe I'll just pose that and see if it rings a bell to Mr. Tierney.
Okay, so you can ask another question.
Well, I can continue to do this off the record to see if it jogs his memory before we get back on the record. It's really just an introductory question. But yeah, so Dr. Keim testified today that it was not appropriate to average historical stock prices, but was appropriate to average GDP growth rates. Does that ring a bell?
Yes. Yep.
Okay. And then I think he also objects to using historical stock prices generally in the DCF analysis, and that's just the frame. So I can go back on the record and just say that we've refreshed his recollection, and then continue with the questions if that works for everybody.
All right. Yeah. How about how does that sound, Attorney Whites?
If that's a witness Tierney's recollection, I think that
the
recollection has been refreshed.
Is that correct, witness Tierney?
Yep. Yes.
Okay. All right. So let's get back on the.
Can I just ask quickly? Is
Yes.
there DCF and DCS? Are those two separate things, or did I just mishear it?
It's only DCF.
Okay. Thank you.
Okay. Thanks. All right. Let's get back on. Go ahead, Attorney Proctor Brown.
Thank you. While we were off the record, Mr. Tierney, we refreshed your recollection about Dr. Keim's testimony earlier today. Is that an accurate summary of our off-the-record conversation?
Yes.
And just generally speaking, Dr. Keim objected to the use of average historical stock prices in the DCF model and the use of historical stock prices in the DCF model. You'd agree with that?
I believe so, yes.
Should we imply from your attorney's questioning of Dr. Keim on that point that staff agrees with Dr. Keim?
Your Honor, I'm going to object. I don't think that that's an appropriate question. The goal of commission staff is to flesh out the record, not to take any particular position. So the fact that a question was asked does not imply that staff is taking a particular approach. It's
I'll just withdraw. I can just get rid of the preamble, Evan. That's fine. I'll withdraw it. I'll just get rid of the preamble.
All right, that's fine. Let's move on.
Yeah. Do you, Mr. Tierney, on behalf of staff, agree with Dr. Keim that it's inappropriate to use average historical stock prices or historical stock prices in the DCF analysis?
Objection, Your Honor. I think this is Kara Coburn-Ferris from CUB here. I'm concerned that this is a big oversimplification of Dr. Keim's testimony, and I'm not comfortable with it. And I wondered if we could go back. I think if the question can be asked in a way that doesn't construe Dr. Keim's testimony or simplify it, it might be okay, but I don't think that what Attorney Proctor Brown is saying is exactly what Dr. Keim said. It was a very nuanced discussion.
Okay. As I would expect. So can we ask the question without reference to Dr. Keim? And I think now that we know what
I don't really think so, Your Honor. I mean, his background to the question might be nuanced, but his point is you shouldn't use average historical stock prices or historical stock prices in the DCF analysis. I'm not trying to characterize the background to it. I just want to know if staff agrees with his fundamental point about the DCF analysis and its inputs.
Your Honor, what if the question is asked as to witness Tierney's understanding rather than of the particular subject instead of?
That's what I was getting at. I don't know if that was
Okay, I can ask it that way, I suppose.
okay. Right, why don't we try it?
Sure. Mr. Tierney, what is your understanding of Dr. Keim's testimony as it relates to the inputs to the DCF analysis?
I believe Mr. Keim testified that the use of historical stock prices was not adequate for the DCF model.
And with that understanding of Dr. Keim's testimony, do you agree with it on behalf of staff?
I don't have a strong opinion on that. I would need to look into it.
One of your own DCF analyses relies on a 90-day historic average of historical stock prices. Do you agree with that?
Yes.
Should the commission ignore the results of that run based on Dr. Keim's opinion?
No.
If that DCF run was removed, the midpoint of your DCF runs as corrected by Ms. Bulkley would increase. Would you agree?
Are you referencing Oakley's testimony?
Yeah, we can pull it up. It's page 4 of Ms. Bulkley's Sir rebuttal. So, Mr. Tierney, you have in front of you figure 2 to Ms. Bulkley's Sir rebuttal. And this is an updated chart from drawn from data in your direct testimony. Would you agree with that?
It appears to be.
And Ms. Bulkley has taken some of the corrections that you agreed to in your Sir rebuttal testimony, and this is the results of those corrections. Would you agree with that?
Your Honor,
No.
I guess I'm going to object. I think this slightly mischaracterizes what this figure is. I think there is a difference between Mr. Tierney's analysis, especially in light of the corrections noted earlier. And I think this gets to the issue of whether or not to include EPS, earnings per share, in the model. So I don't know that this figure is a exact update to Mr. Tierney's model.
Okay, response?
I would just say I don't think Mr. Tierney has taken issue with this at all. And it's just the fact that he didn't sponsor a new table in his Sir rebuttal testimony after admitting to errors in his analysis. So this is, I think, just really a formulaic function of the way that his schedules work, and updating erroneous testimony, admittedly erroneous testimony.
I respectfully, I disagree. If you look at the title of the figure, it specifically references EPS and DPS growth rate scenarios, and I don't believe that that's what Mr. Tierney uses.
Well, that's what his testimony said. He did make a correction on the stand today, so I don't. The specific numbers don't particularly matter, but my understanding of this is it's just a function of the corrections that he admitted to in his Sir rebuttal, and if that needs to be challenged, certainly could have been, but I can withdraw that characterization if that simplifies this.
I think if there's a specific question, yeah, I would appreciate withdrawing the characterization because I don't know that that's accurate.
Okay, so let's re-ask.
Okay. Yeah, we'll do our own math on the brief. That's fine. So the second line here says DCF 90-day average stock price. You agree with that?
Yes.
And this is in basic format the same as the table that's in your direct testimony that you've acknowledged in Sir rebuttal contains inaccurate numbers. Would you agree with that?
It's formatted similarly. I think the inputs are different here.
That's fair. So in your direct testimony, in an analysis that displays your corrections, these would be the same 5 analyses on the left-hand side. Would you agree?
Those are the same names. I did not use earnings per share, though, and I believe Bulkley did.
That's fair. Your Honor, I think you moved off of the chart I was using.
Oh, sorry. Got a mind of its own. Okay, there we go.
And the way that you just calculated the average and midpoint is weighting each one of those 5 analyses the same, right? So each counts as 20% in the average, the high, and the midpoint, correct?
That's correct.
So 40% of that analysis were the 2 DCF analysis. You agree?
Yes.
And so if we removed the DCF 90-day average stock price from either your analysis or Ms. Bulkley's analysis, the DCF analysis would be weighted less in the results that you report at the bottom, right?
It would not include the 90-day analysis, so the relative weighting of all the other models would increase.
You now have 4 analyses, each weighted equally at 25%, right?
Yeah.
And you would agree with me that the DCF analyses produce the lowest of the low results in this chart, right?
Yes, I believe that's correct.
So if the DCF analysis was weighted less, the low average would go up and the midpoint would go up. You agree?
I would want to make a clarification. Are we talking about Bulkley's charts here or mine? Because I consider them different.
Well, we don't have a chart in your sure rebuttal testimony. We can look at the direct, but that's
I
you've
believe I
admitted
did.
that's wrong.
I believe I did file one. It's table 1.
So
Okay,
yeah,
we can let's look at table 1. That's fine.
Let's clarify because I'm sorry. Let me just interject. So I tried to look through the Tierney Direct. I didn't see a table 1. Oh, maybe I missed
in my sir rebuttal.
Right. So that's what I was. So I think it was. I think Attorney Proctor Brown was referencing Mr. Tierney's direct for table 1, but I believe it's a rebuttal. So I just want to make sure we're clear as to what testimony that was filed in. I can display table 1 if it's helpful.
Your Honor, I think I understood Attorney Proctor Brown was referencing the sir rebuttal because it was the updates with the errors that were pointed out by Bulkley, but perhaps he can let us know if that understanding was incorrect.
My understanding is this is a similar table that was in the direct, but that the results of his corrected analysis weren't reported in his sir rebuttal testimony. If I'm an error there, that's fine.
One at a time. One at a time. Yeah, I don't think it's labeled. I just don't see a table 1 in his direct. Maybe it's just not labeled. It's just not labeled table 1, I believe. But that's just a.
I think the questions are the same on his sir rebuttal. If there's a table like this in his sir rebuttal, I'm happy to ask them there. It's really just a directional question.
It's page 5 of the sir rebuttal.
Okay.
Okay. So Mr. Tierney, we have up now table 1 in your sir rebuttal testimony. Generally speaking, this is a similar table to the one we were looking at in Ms. Bulkley's testimony. You agree to that?
It's formatted similarly.
And has the same 5 analyses listed under model, right?
They are listed with the same names, but I don't believe they are the same analyses.
Okay. But in your reported results, you weighted the DCF models as 40% of the reported low, high, and midpoints, correct?
Yes, each model is 20%. So.
And in your chart, discounted cash flow 90-day includes an average of historical stock prices, right?
Yes.
And that's the second lowest result in low, right?
That's correct.
So if DCF models were weighted as only a quarter of this analysis, as opposed to 40%, the average of the low would go up. You agree?
Certainly looks that way.
And the same thing's true of the midpoint, right?
I would need to actually, crunch the numbers to make sure, but it appears that could be the case.
Okay, so once you did the math, it's possible and the midpoint goes up and goes up more than your recommendation to the commission on ROE. Do you agree to that?
I'm sorry, your recommendation to the commission.
It goes
On-
higher than the recommendation to
I
the
think it was
commission
just on ROE. Is that what you're
on
missing?
ROE, yeah.
Thank you.
Well, I don't know. I haven't done the math.
That's fair. I have a couple questions about your corrections for your testimony. Do you have that in mind?
The ones I made earlier?
Yeah, in your rebuttal testimony. Oh, I'm
Oh,
sorry.
okay.
Your corrections today, during your testimony today. Do you have that in mind?
Yes.
And that was on direct.
Correct.
It was on direct, yeah. So I believe, and you correct me if I've got this wrong, your testimony corrections exclude the earnings per share growth from your DCF model. Is that the upshot of the corrections that you made on the stand today?
Where exactly are you seeing that? The earnings per share growth?
So you talked about how it shouldn't have been earnings growth rates. It's on the page right here.
Yep.
Should have been the dividend growth rate. Is that a fair summary?
So it's direct attorney, page 26, line 20 is the first reference.
Yes, that should be dividend.
But you did run the DCF model using both dividend and earnings growth, correct?
Yes.
Did you rely on your earnings growth DCF results?
No.
Why not?
Well, it's been the standard practice to use dividend growth. We view it as a more reliable measure of what investors are concerned with, and utilities being primarily dividend stocks. We felt dividend per share growth was the correct metric.
Then why did you do the EPS analysis?
I believe we've done the EPS analysis pretty consistently in the past, but we've generally only ever used the dividend numbers.
And you're using the kind of royal we there. Have you personally used both of those analyses in rate cases before the Wisconsin Commission?
Yes.
That's all the questions I have, Your Honor. Thank you.
Okay, other cross? Nobody? Redirect?
Just briefly, I just wanted to ask and clarify the point, Mr. Tierney. When you're talking about an imputed capital structure, does that mean that the company would actually have to either issue new debt or physically alter their capital structure, or is there a distinction to be drawn with a imputed capital structure?
Yes, there is a distinction. An imputed capital structure would set a capital structure that would be used only for rate making. The capital structure would be unaffected in reality. The company would not be required to issue new debt or equity.
And then I wanted to follow up. You were asked some questions about the PPA for the Point Beach nuclear plant, and whether or not your suggestion sought to negate those off-balance sheet obligations or to negate that purchase power agreement. Is it your understanding that there was a relatively recent change as to how that PPA was accounted for in off-balance sheet obligations?
Yes, I believe there was a change in the prior rate case.
And do you know generally, or could you just give us a short rundown as to what that change was or how that came about?
Yes, I believe one of the credit ratings agencies wanted to reclassify some of that debt associated with the PPA as equity, and the commission agreed to it in a settlement.
So the change didn't result from the PPA itself, but from an action from the credit rating agency, if I understand that correctly?
Yes, that specific change, yes, was requested and agreed upon in that settlement agreement.
Thank you. I don't have anything further.
Okay. That's great. So thanks very much. You're excused. I think we have beat this up enough, and we certainly have all the documents here. I did want to mention, I didn't make that statement for all the documents here, but we did go through the offered evidence list as the witnesses were on the stand, and we have verified the documents that are listed on the offered evidence list, so I can accept those for the record pending the verifications by the witnesses who will file by affidavit and the corrections that we've all are aware of on the offered evidence list, and also that occurred during the hearing. So we'll look forward to getting those. Otherwise, I think we have the record that we need from parties and staff, and we'll look forward to getting public comments in the public hearing sessions and the written comments. With that, is there anything else we need to address before we adjourn?
Nothing from applicants, Your Honor. Thank you very much for indulging us tonight.
Okay, always happy to indulge these late night hearings here. Who mentioned that it was a beer hearing, a beer question, right? We can all.
Mr. Colton.
Yes, yes. We'll all should have celebrate a little bit for the end of this. So, okay. Well, with that, I think we're all set. So thanks very much for everyone's patience and presence here. And we're adjourned. Take care.
Thank you, Your Honor.
Thank you.
Appreciate it. Thanks, everybody.
Good night, all.
Thank you, everyone.
Can you stand?
Yeah. Not gonna let me get out of here.
No.
No.
Well, I don't want to have to go email back and forth tomorrow. I'll just.
Yeah, that's okay.
Okay. It's not anything big. Kathy said to tell you because
Let me just make sure we're alone.
Okay.
And I need to check the live stream because I lost my connection. Usually
I see it